All right, good morning, everyone. It's 10 o'clock. I'd like to call to order the Judiciary Committee meeting for Monday, March 17th, 2025. Happy St. Patrick's Day, everyone. Welcome to the Judiciary Committee. All right, couple of ground rules before we get started. For those who've not testified before this committee before, we have a strict 3-minute bell. You get 3 minutes. If you do not have a full 3 minutes of speaking, don't worry, it's okay. You don't have to fill the full 3 minutes. We'll gladly take it back. Also, if you have submitted written testimony to us, please don't come up and read your written testimony to us. We don't need you to speed read your written testimony into the record. We have laptops. Your written testimony is uploaded in front of us on our laptops. We can all read it. Coming up here and speed reading it to us does us absolutely no good. So please just highlight key portions of your written testimony. Feel free to address questions that may have come up on the bill with respect to previous people who've testified, or just come up, say good morning, note you've submitted written testimony, see if there's any questions for you, and leave it at that. We don't allow people to switch spots. If you are not in the room when your name is called, that's okay. We will get you at the end after the rest of our list has concluded. We do have 50, 60-ish folks signed up, so we will try to go as expeditiously as we can so that folks get a chance to testify before it gets too late in the day. All right, with that, we'll call up our first person, which is Megan Scanlon. And Megan, turn the microphone on, please.
All right, good morning. Good morning, Senator Winfield, Senator Kissel, Representative Stafford, and distinguished members of the committee. My name is Megan Scanlon. I'm the CEO at the Connecticut Coalition Against Domestic Violence, and I wanted to urge you to support Senate Bill 1502, which would significantly reduce harm to survivors of gender-based violence in Connecticut by giving the justice system the power to reduce a survivor's punishment if gender-based violence was a contributing factor to their offense. Survivors can sometimes receive severe sentences for actions directly tied to their victimization, whether they're coerced into committing a crime by their abuser, fought back to survive, or turned to substances to cope. In New York, for instance, a DVSJ recipient had an abusive boyfriend who threatened to harm her children if she was not driving the getaway car in his robberies. In Connecticut, judges already recognize how abuse shapes criminal cases, but with over 70 mandatory minimums, sometimes their hands are tied when it comes to sentencing. 1502 increases judicial discretion by allowing judges to issue nuanced, trauma-informed sentences while still retaining the power to deny relief if a survivor cannot prove that their victimization was a contributing factor to the crime. It's not a get-out-of-jail-free card. It simply makes it possible for the justice system to consider the full context in which their offense took place. Second, I want to urge you to support Senate Bill 1505. This is a recommendation that came out of the Domestic Violence Criminal Justice Advisory Council. This measure seeks to encourage the court to use its discretion in recommending that certain defendants receive domestic violence education and treatment in addition to mental health treatment if they have the capacity to do so. Currently, some individuals charged with a family violence crime are referred to the supervised diversionary program, which is meant for individuals with a psychiatric disability, as well as veterans. We support psychiatric disabilities and people getting the treatment that they need, but we also would argue that failure to address the abusive tactics and dynamics in domestic violence relationships would not only increase the defendant's recidivism rate, but would also open up the victim to future acts of violence. And I'm happy to answer any questions.
Thank you. Senator Kissel.
Thank you, Chairman Winfield. Megan, good morning. Great to
Morning.
see you. And finally, the legislature's off and running. And I just want you to know what a pleasure it is serving on the council with you as chair. And on these matters, definitely reach out to Senator Flexer and myself if you want to know the status. And I'll certainly do whatever I can to move them forward. So thank you.
Thank you.
Thank you, Senator. Comment or question from other members of the committee. Representative Stafford.
Thank you, Mr. Chair. Good morning, Megan. Megan, just briefly, have you had a chance to review the state's attorney's testimony on the bill?
Yes, sir.
Do you want to comment on that?
I think our only comment is around the 70 mandatory minimum laws. So it doesn't really get around the fact that there are 70 mandatory minimum laws, that there's really no ability for judges to have as much discretion as this law would allow.
That sounds right to me. Thanks.
Thank you, Representative. Comment or question from other members of the committee? Representative Howard.
Thank you, Mr. Chairman. Good morning, Megan. Thank you for your testimony. Did you happen to look at Senate Bill 1327, which is the sentence reduction? Did you look at that at all?
I have not, sir.
So the only reason I bring it to your attention, and I certainly won't ask you to comment on it here, but it might be worth taking a look at. In section 1 of the bill, it allows for applications for sentence modification every 2 years as opposed to every 5 years, which I would think could re-victimize victims, especially with domestic violence or sexual assault, that, creating a re-trauma for them. So I won't ask you to comment on it if you didn't get opportunity to see it, but 1327, the CADV might be interested in it.
Yeah, I'll take a look at it. Thank you.
Thank you.
Hi, Senator Flexer.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you for joining us again.
Thank you.
Tanisha Signore.
Good morning, everybody. Good morning, Senator Winfield, Representative Safstrom, and esteemed members of the Judiciary Committee. My name is Tanisha Signore. I'm the Policy Director at She Leads Justice. We're a statewide nonprofit that uses a justice and equity lens to advocate for marginalized and under-resourced women and girls in the state of Connecticut. As a part of our work, we're proud members of the Connecticut Domestic Violence Survivors Justice Coalition. We have been a leader in advocating for marginalized women in Connecticut for a long time. We often work with women who have experienced domestic violence. We know that it is pervasive in our society. We know that it disproportionately affects women, and we know that it's largely underreported. Experiencing domestic violence, sexual assault, stalking, or trafficking is incredibly traumatic and can often be unrealized by those who are experiencing it. Individuals who are incarcerated for crimes related to these abuses deserve to tell their stories and have their circumstances be considered. Domestic violence experiences are complex and unique to the person who is experiencing them. Our understanding as a society of these offenses is ongoing and constantly evolving. Our legal system needs to recognize this reality, create policies which operate in a trauma-informed capacity, and begin to adjust its mechanisms to allow individuals to heal, rehabilitate, and safely rejoin society with the tools they need for their futures. SB 1502 has the power to create increased opportunities for victims and survivors in Connecticut to experience humanity and understanding from our justice system. Those who have experienced the cruelty of mandatory minimums, those who have feared retaliatory actions from their abusers, those who were unable to process their abuse and trauma pre-conviction, those who were discouraged from bringing their experiences up during sentencing or tunneled into plea bargains, SB 1502 has the power to change their lives, as it is beginning to do in other states. It will help modernize Connecticut's sentencing practices, allow for increased discretion by decision makers, and create incremental but meaningful change for survivors. We believe strongly that this bill is not simply important, but that it is necessary. It's a necessary step for our state to take to come to terms with the distressing and unimaginable impacts of domestic violence, sexual assault, stalking, and human trafficking on victims and survivors. We urge the committee to take a purposeful step towards justice today and favorably vote on SB 1502. Thank you for your time.
Thank you. Good timing, by the way. Comment or question for members of the committee? Comment or question, Representative Fishbone?
Thank you, Mr. Chairman. Good morning.
Good morning.
What is domestic violence?
What is domestic violence?
Yeah, what's the minimum of what domestic violence is under our statute?
I'm not sure I understand your
Well,
question.
can domestic violence be merely verbal?
If it's coercive, yes.
Well, why would it need to be coercive? I'm just, 46B1 is the statute that defines domestic violence in Connecticut, and I'm just trying,
Are you looking at it?
oh, I know it.
Okay. So
So,
why are you asking the question then?
well, that's what we're talking about today is domestic violence, right? We're talking about
Yes.
a murderer under this, asserting to a court that they were a victim of domestic violence
Mhm.
and
Not only asserting there are evidence provisions within the
well, they're
statute.
asserting it because we'll get to how they prove it. But I'm
Just a second before we go too far, because I can see how this is gonna go. Question is asked, response is given, question. Over talking each other makes it difficult to understand what's happening.
Thank you, Mr. Chairman.
I would be happy to meet with you also outside of this because I'm actually one of your constituents and I was trying to contact you about this bill.
Okay, we're
before
here in
then.
a public hearing. I
Yeah.
tend not to, this is a public process, right?
Yeah.
So the legislature meets, votes on certain things based upon public hearings and that kind of, not what happens behind closed doors. And I don't
Okay.
like that secret stuff, but
Oh.
I've been involved in domestic violence cases, defending a victim where the husband, says you're a effing B, right, in front of the kids.
Mhm.
And under our statute, that is domestic violence. You would agree with me?
Yes.
But I don't. Okay, so that is, I mean, DCF gets involved and all that stuff. That is, and I think it's correct that, we shouldn't be saying that bad stuff in front of the kids because kids learn from their parents and hopefully they learn well from their parents. And then, unfortunately, what we learn is that kids, as they get older, emulate their parents, right? So dad saying that to mom in front of the children, more than likely that child is going to determine that that's appropriate conduct and may do that bad conduct as they grow up. So public policy wise, we've said that those kinds of things are bad and that's domestic violence. So I'm trying to figure out if the domestic violence is merely verbal, why it would make sense for a judge, their discretion to be taken away on a sentencing, because this is a mandate. This is the law says. So somebody is convicted of shooting up a school, let's say, 20 people are dead, and at sentencing, ordinarily the sentence would be life without possibility of parole. That then they could assert that they were a victim of domestic violence and perhaps language like that, and why it's good public policy that the discretion of the judge on sentencing would be removed.
And that's an interesting example to choose. I would say that the discretion is not being taken away from the judge. I would say that the discretion is actually being improved for decision makers. And by doing that, they are able to take the different circumstances into consideration, including the types of crime and the circumstances surrounding abuse related
So are
to
you
the
aware how our
survivors.
courts sentence presently?
I'm not a lawyer, no. So,
Okay, so you've never been to court, you've never seen somebody sentenced on one of these cases?
I mean, I've been to court. I used to be a victim advocate. Unfortunately, it was during COVID, so a lot of the things were remote, but I
Okay,
witnessed it.
well, when you said it doesn't take away the discretion, I'm looking in particular at line 87 of the bill. And it says the court shall depart from the applicable sentence subsections. So that's a mandate. That says the court has to do something. So I don't know, you were saying it doesn't take away discretion. I'm trying to figure out what the basis of the representation is.
I would maybe defer that question to one of the other experts within the coalition, only because I'm testifying on behalf of the coalition, but I'm not leading it. So I am not as much of an expert on this particular policy as the other leaders in the coalition.
Okay, so then what about the timing? It appears to me that if one is sentenced, and they've asserted this, and the court denies the application, it's without prejudice, meaning that they can refile. Why would we have, because at the other end of these cases, there's victims, right? So now somebody is convicted, mass shooting, let's say, and the court rejects the domestic violence claim under the statute, sentences them for life without parole. They've lost that. It appears to me that they could turn around the next week and then reassert that. Why is that good public policy?
Well, I believe there's other time considerations within the bill, but I will repeat my previous response, which I would ask that you refer that question to one of the leaders within the coalition.
Are you aware of I'm sure as a victim's advocate, pre-sentencing reports, you've seen those, been aware of those?
I'm not sure, to be honest. I was dealing primarily with contacting victims after the police reports were filed
Okay.
and letting them know about the processes and stuff like that.
Okay, so you've never been involved with a PSR in our courts?
I don't think so, no.
Okay, well, I'm just trying to figure out, because I think these sort of situations are already under our statutes allowed to be taken into consideration, and I'm trying to figure out why we would go to this leap. Or do you have some case, some scenario where this was precluded from being asserted and that we need this?
I think we have several examples, and I can tell you that the other people within the coalition who are testifying will be talking to you about them.
Okay.
They've worked one-on-one with individuals, victims, and survivors.
Thank you. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from members of the committee? Comment or question, Senator Fluxer. Oh, you know what? Representative Howard.
Certainly. Thank you, Senator. Good morning.
Morning.
Thank you for your testimony and for your work with victims and survivors. Did you have an opportunity to look at 1327, the first bill on the agenda?
I didn't. I briefly pulled it up after you told
Okay.
Mrs. Scanlon about it, but I haven't had a chance to read it yet.
All right. Thank you. Yeah. So I wasn't
you.
looking. I know if you're in the room. Just as somebody who advocates for victims, I would hope that you would take a look at that bill as well. Specifically lines 20 to 31 would allow somebody serving a sentence to essentially have their victim notified about them every 2 years as opposed to every 5. And it concerns me for victims, and I hope that some of the folks that are here today testifying on bill number 3, 1502, out of concern for victims, will also be concerned for victims who haven't been arrested for a crime, right?
Yeah, absolutely. Thank you. I appreciate that.
Thank you. Thank you, Mr. Chairman.
Thank you, Representative. Senator Fluxer.
Thank you, Mr. Chair. Good morning. Thank you for your testimony this morning. I just wanted to ask you briefly if you could just tell us a little bit more about the coalition that you're a part of and their work to get proposed legislation to this point.
Yeah, absolutely. So I was put in contact with Dr. Bashani Ree, who is the executive director of Drop LWAP and of New England, and she is working in coalition with some amazing national partners who have passed legislation in other states and including Oklahoma. And it was.
We don't like Oklahoma. They're here this week.
Oh, basketball. I have to start following basketball more closely, I think, now that I'm here.
Sorry for breaking the rules, Mr. Chair. Sorry.
It's okay. No, but they're doing incredible work, and they're already seeing it having a really, I think, beautiful effect in the states that it's passed for survivors who have been incarcerated.
Thank you.
Yeah,
Thank you again for your testimony. Thank you, Mr. Chair.
Thank you, Senator. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us this morning. Next, we have Pareesa Goodwin. She'll be joined by Muna Abbas to share the 3 minutes. For the members of the committee, following on the list is number 9 and number 3.
Thank you so much. Good morning, chairs, ranking members, and all esteemed members of the Judiciary Committee. My name is Pareesa Goodwin, and I'm here in support of Senate Bill 1506, an act concerning racial and ethnic impact statements. As stated by the good chair, I have my colleague Muna Abbas, who's been involved in the research and review of state legislatures' efforts to implement similar such analyses in their states. I'm the executive director of the Commission on Racial Equity and Public Health, which is a nonpartisan legislative branch agency which provides policy and data analysis with a lens to eliminate racial and ethnic inequities in health and social drivers of health. In 2018, led by Senator Winfield, the Connecticut General Assembly passed Public Act 1878 on a bipartisan basis to introduce racial ethnic impact statements, which I'm going to refer to as RICE because it's a long acronym, into the legislative process. These statements would allow for analysis of proposed bills using available data to predict whether a bill would narrow or widen existing racial or ethnic disparities. RICE has yet to be implemented, however, and the Commission has been assigned responsibility to produce these statements going forward with the hopes to formally begin the process in the 2027 legislative session, allowing for rules to be adopted. Over the last year, we have reviewed other state legislatures' similar efforts and met with nonpartisan analysts who conduct similar assessments. Taking what we've learned, we've recommended 3 changes to the statute, which we believe would be necessary for successful implementation. These fall into the categories of timeline, process, and access to information. I'm just going to briefly go over each of those. With regards to timeline, the bill makes provisions to clarify the timeline for a request, making it 2 days within the JF deadline. This is a shorter request turnaround time than is currently in statute, and the reason for the change is to allow the analyst more time to review the bill, identify and review relevant data and literature, and provide a thoughtful assessment on the projected impact. We're also making an assumption here that the statement would be included in the file copy and therefore need to be cognizant of those reporting deadlines. We believe this would be helpful in the long term, so that way the legislature is able to review these as a whole package and analysis of the bill. On process, the bill allows for the Commission to draft procedures for RICE in collaboration with all 4 caucuses. The procedures shall be memorialized by the Commission in a letter for request for inclusion in the joint rules at the start of the biennial session. This mirrors the approach used in Colorado's legislature and ensures that the office responsible for producing the analysis collaborates with legislative leaders or designees from all 4 caucuses in drafting the procedural rules and guidelines for the statements. The benefits of this approach is that it would ensure bipartisanship, a shared understanding of the RICE process and product, and a process and product designed that is feasible for nonpartisan staff to produce and meets the needs of the legislature. And finally, in order to conduct the impact assessments, the Commission will require access to information in a comprehensive and timely manner. This suggestion was also taken from Colorado statute, and their nonpartisan staff has relied on it in order to get timely responses from agencies when producing similar such statements. I also want to acknowledge the testimony from our good allies at DPH and make clear that we do not want any personal identifiable health information. And with that, I will close, and I'm happy for any questions that you might have.
Thank you. Comment or question from members of the committee? Representative Fishbaum.
Thank you, Mr. Chairman. Good morning. Thank you for coming here today. The change in line 8, you indicated that was a clarification. It appears to be a wholesale change, though. You're changing the term from 10 days to 2 days.
Yes.
So why is that good public policy? You're limiting. So if
Yeah.
the 2 days passes and this isn't asked for, then one can't ask for this report. Why is that good public policy?
Thank you for the question. And if I use the term clarification, that was me misspeaking, so I apologize for that. We intended to shorten the time frame so that way we have more time for the analysts to produce the statements if they're going to be included in the file copy. It is, it does allow or remove some flexibility in request timeline. So I understand if that's something that the legislature does not want to do or wants to talk about timeline. But my concern is that an analyst is going to need ideally 15 days, but 10 days at least to do analysis. So my concern is if we run up to the JF deadline or too far into session, then they're not going to have time to produce the statement.
So has there been an instance where that 10-day period has been a problem?
We have never done a RICE statement because there has not been rules or staff. So this would
Okay,
be,
so like public safety, tomorrow is their JF deadline.
Yeah.
Okay.
Yeah.
So under our existing statute, within 10 days of them JFing out a bill.
Yeah.
This report could be requested, and this is an impact, a racial impact report, right? So the session doesn't end until the beginning of June.
True.
I'm just trying to figure out why it appears to me, and please help me here,
sure.
that somebody's looking to limit the amount of these reports that are sought by taking 1/5 of the time that you currently have, right? And going down to 2 days instead of 10. So I don't get I don't get the connection.
Yeah, it's an interesting question. So just to be clear, right now, these statements are not being produced.
And why is that? Because they're not being requested?
They're not in the joint rules. There's no formal process. So that's something that we would like to have done we have a timeline, hopefully, once the any necessary changes are made in statute, then we would move on to the rulemaking in a bipartisan basis. And that's where we would like to have all 4 caucuses again come together and work on specifics. And then have staff in place to fulfill the requests, because right now there's nowhere for requests to go.
Okay, so the statute it's a statute, right?
Yes.
One could say it has even more effect than the joint rules. And
Yes,
I
yes.
know these reports have been sought in the past.
Yes.
Are you aware of where those reports were sought from in the past?
I have been told that legislators have made requests. They have sent them to perhaps different 5th floor offices and have not gotten a report because there's no assigned staff.
Okay,
at
so
this
that
point in time.
perhaps deals with the back end where the
Yes,
commission, and we're gonna get
Yep.
to that in a moment.
sure.
It appears in addition to shorting that time period, that you're also removing from the law the ability to ask for that report on an amendment.
Correct.
So that's a wholesale cannot do anymore. Why is that good public policy?
Well, I would say the word anymore is not quite correct because these have not been done at all. But, and I understand that concern as well. My concern is with practicality of these being done in a timely manner. So session moves along. If these are going to be in the file copy, then I don't think we can allow the 10-day turnaround time. But if 2 days is too short, I'm happy to have a conversation around what would be practical for staff to have enough time to do the statements. And as far as the amendments, my concern with that is amendments can be called on the floor. Analysts might not be given the language in advance. So again, I think there are maybe certain scenarios where that would be possible. It's hard for me to think of a real life scenario where an analyst would be given the language and enough time to actually do a thoughtful analysis. But I think there's ways to get at that. It would just require some specifics. So that way, I don't want a promise that someone can get a analysis on an amendment when it's actually not feasible for staff to do that. Does that make sense?
Well, no, it does, and I appreciate very much the exchange.
Mm.
However, if one asks for this report on the bill that's JF'd, and let's just say that the report comes back and it is extremely adverse
Mhm.
to the interests of this process, right? And you know, it's a bad report, not a bad content report, but the conclusions of the report say that this bill would have a significant negative impact upon minorities, let's say.
Okay.
Okay. So now the proponents of the bill see that in conjunction with the language that came out of the committee,
Mhm.
and they say, well, you know, let's move this around. Let's change this. Let's address some of those concerns,
Mhm.
which would result in an amendment, right?
Correct.
There is no process then for this amendment to be re-reviewed and a new report come out,
Mhm.
right? To avail those concerns.
Yeah.
And that's, you know, because you're totally taking out the ability to deal with an amendment.
May I respond?
Sure.
Because that's an excellent, I think that's an excellent case. And what I would say is, for example, in Colorado, where they have been doing similar such statements, they call them demographic notes. What they do is when a bill that they have done a statement on has been amended, they will go back and update the statement to reflect any substantive changes. And perhaps this language would get in the way of that, which is not something that we would want. If there is a real life scenario where it could be helpful to the legislature, we wouldn't want to get in the way of that. And I don't know if that's something that we need to make technical changes here, or if it's something that could be addressed in rulemaking. But the concern, and I think why we need to be very careful and precise with the language, is if there is something called on the floor, it might not be practical or possible for an analysis to be done. But I think that you bring up a really good real life scenario where perhaps we need to change this language so that way we have that optionality.
I appreciate that. You mentioned with regard to lines 20 through 29, that opened up collaboration between the leaders and the commission.
Yes.
And I'm trying to see the collaboration because I read this, that the commission just tells the leaders what the rules are. So can you just point me to where it says that they'll work together to work on the procedures and collaborate? That's what I understand collaboration is. We work together, right?
Yeah.
We meet, we exchange, we perhaps debate, we collaborate, right?
Absolutely.
It seems to me in line 23, it says the commission shall memorialize such procedures in a letter to the leaders, right?
Mhm.
So I would read that the commission creates the rules and then lets the leaders know what the rules are. So can you just point me to where the collaboration is?
Sure. It doesn't say collaboration, I don't believe, in the proposed bill, so I understand that. The idea here is that we would take on the labor of memorializing something and offering it as a request to the leaders for inclusion in the rules. But let me give a more full picture of what we're envisioning, which it doesn't say in the bill, is that we would want to pull together, similar to how we try to engage with every caucus on this issue. And while we were doing our research, we would want to pull together, ideally, someone from every caucus, as well as nonpartisan staff, other fifth floor colleagues, in designing the rules and thinking through using 2026 really as almost an informal pilot year where we can make sample products to share with that group before we finalize the more specific process and what the final product will look like. So that way we have a template, we have shared clarity and understanding on what this looks like. So we make sure it fits both the practicality and feasibility for staff, something they're able to produce reliably, and something that meets the needs of the legislature and is done on a bipartisan basis. So that's the vision. And I agree with you. It does not, you wouldn't understand that necessarily from the bill language. It doesn't give that kind of working group information.
Just to give you a little leg up there, it appears in line 28 that a request
Mhm.
is made, so it's not as draconian as perhaps I had presented it.
Okay,
The
thank
commission
you.
will, this is what we think should happen. Letter comes.
Yes.
And there's a request that the content of the letter be adopted, and I perhaps in a perfect world, there would be exchange at that point.
Yes.
What do you guys think about this? So no, I appreciate that.
Yes,
but,
and I also, if I may, thank you. I appreciate that, Representative. Also, it's not in my mind, the letter should in no way be, or the contents of the letter should in no way be a surprise to the leaders, right? Because we would ideally be working with them in drafting that content, and we would take on the labor of making it something formal for consideration.
I appreciate that. So thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? Just quickly, I just want to clarify that while some have said it's because we haven't created rules, the actual statute doesn't require that those rules were created. We haven't done it because we haven't done it. That's the long and the short of it. I do the conversation between you and Representative Fishbein about the amendments is of concern to me, and I think I've expressed to you before I have some concern with the number of days.
Yeah.
So I appreciate the work that you're doing because I think it will help us to get this thing that we've been talking about having done since we passed it 7 years ago done. But I will continue to engage to see if there's a way. The former minority leader of the Senate and I came up with the 10 days as it relates to the amendment, taking into account the way that sessions work. And I take the point that even that may not work, but I think there's something between there and here that may work, and be happy to engage you on that.
I would be more than happy to engage with you on that. Thank you.
Thank you. Again, any questions or comments from members of the committee? Questions or comments? Seeing none, thank you for your work. Thank you for joining us today.
Thank you so much.
Beth Hamilton. Beth Hamilton. Let's see. Okay. Prince Davis. Prince Davis. Daryl Fennel. Good morning, Mr. Fennel. You may proceed when you are seated.
Mr. Chairman, members of the committee, my name is Daryl Fennel. I'm here to testify in opposition to House Bill 7140. I've been a lawyer, a trial lawyer, an appellate lawyer since the middle 1970s. I've tried cases in nearly a dozen states. I've participated in arbitration proceedings as an advocate, both commercial and international, and I've represented clients in state and federal agencies. I am currently a commissioner of the Middletown Fair Rent Commission. I've seen all of their proceedings since the beginning and many fair rent commissions across the state. I think it's fair to say that I am familiar with a variety of procedural systems and whether they work or don't work. All of them are very different. The way to make a fair procedural system is to design it with three things in mind: the nature of the judges, the nature of the substantive law that's to be decided, and the nature of the litigants that are before the commission. It is not recommended that you take from one procedural system and paste it into another. For example, in commercial arbitration, the arbitrators are by and large not lawyers. It would not be recommended to use the federal rules of civil procedure in that proceeding. In this case, however, the bill takes from the Connecticut Uniform Administrative Procedure Act a provision and pastes it into the Fair Rent Commission. Administrative agencies and fair rent commissions could not be more different. Administrative agencies have the administrators are presumed to be specialists in areas that they're to regulate. They create the regulations that are to govern the field. They interpret the regulations. They often initiate prosecution of alleged violations of those regulations, and they judge the result of the prosecution. Because of the peculiar nature of administrative agencies, there has to be more procedural due process because there's no checks and balances as we see them from civics and from, the Constitution, because agencies are both executive and legislative bodies. They have to have more judicial scrutiny than normal dispute resolution bodies. Fair rent commissions are not made up of specialists. They're volunteers. Am I done?
You are.
Can I say one thing? I will submit written testimony later today.
Okay. So help me, because I hear the argument you're making about the difference, but I haven't heard in your argument what the problem with inserting that language is.
Can I answer that?
That's a question to you.
Okay.
Just so that we get to your full argument.
The bill says that the purpose is to allow for a record to be made for the appeal from the Fair Rent Commission to the Superior Court. I have read, there's collected in the Yukon Law Library in Hartford, housing court decisions, which are the appeal court for fair rent commissions, that go back to the beginning of fair rent commissions, which is over a half century ago in 1969. I have never seen a case where the Superior Court has criticized the record that's been presented to it. What this bill does, though, is take the record-making procedures of the Administrative Procedure Act, in which there are things like judicial notices of fact, proposed decisions, proffers of proof, which never come up among a lay board, objections to evidence and arguments on that. In fair rent commissions, there's generally just documents and testimony. The testimony is recorded, usually broadcast on the internet, but it's recorded and kept, and the documents are kept. That's what the Superior Court judges its case on. Now, the bill goes beyond what it purports the problem is by saying that Fair Rent Commission cases are contested cases under the Administrative Procedure Act. Now, that opens up a can of worms because there's about a dozen statutes that brings in, all of them wholly inapplicable to fair rent commissions. And one thing that I think this committee did not intend, which is it gives the appellate court the right to assess attorney's fees and other costs against the loser. Now, all of that is going to impose a lot of additional lawyer time on the municipalities. And I don't think you wanted to have, if a municipality loses an appeal, to have them be assessed with attorney's fees, or vice versa. If a landlord or tenant loses the case, to have them assessed attorney's fees.
Okay. All right. Representative Fishbein.
Thank you, Mr. Chairman. Good morning, sir. Can you just point me to the language in 7140 about the attorney's fees?
Yeah, that is in, let's see, that is in, I'm a bit, I have the wrong, okay, here we go. It's in, Section 4148A, subsection B.
Okay.
And it says
No, sir.
that
In
a court in its
Sir,
discretion.
Sir, in the bill.
In the
In the
bill.
bill, that's what.
Well, no, it's,
7140.
the bill itself says that that Fair Rent Commission cases are considered contested
Got it.
cases under Chapter 54. This is a provision that would apply to contested cases under Chapter 54.
Okay,
The
so-
attorney's fees
So
provision.
7140 itself expressly doesn't deal with the attorney's fees. It's the bringing these matters
Yes, yes.
into contested
By
cases.
saying that the case is a
Hold
contested.
on a second. I'm going to say the same thing that I've said before. When Representative Fishbane asks the question, let him get the question out, let him finish. Representative Fishbane, I think you know this already. When Mr. Fennel is answering the question, allow him to answer the question so that everyone listening can keep track of the discussion. And if there's something to learn, we don't miss it. Thank you.
Thank you. So, sir, it's your position that calling this a contested case makes it fall into a different statute that calls for attorney's fees. Is that
Yes,
fair?
because all of the
Okay.
statutes are headed with, under the Administrative Procedure Act, contested case.
Okay.
And all of those would be brought in, or at least arguably, it's open to a judge to decide that. You shouldn't allow that to happen if that's not what you want.
But, well, that is what I want. But looking at the 7140 that's before us, I mean, there's currently appeals from these Fair Rent Commission proceedings. You agree with that?
Yes.
Okay. And how are those handled presently?
Well, generally, the appellate, the person that's appealing will order the transcript will transcribe the tape of the hearing and order copies of the exhibits that have been admitted into evidence to be sent up to the Superior Court. Now, I have to say there are almost no appeals of Fair Rent Commission cases because the amount at issue is not that great. And if you make the legal requirements of pursuing it even greater than they are now, you would probably never have any appeals.
Okay, so you're aware of the legislature's expansion of, they now mandate that 80% of our towns now have these fair rent commissions.
Yes, every town over 25,000.
And that happened 2 years ago, I think.
Yeah,
if
3
that's
years
good.
ago, right.
Sure. I think 3 years ago it was 45,000 and then 2 years ago it went down to
Right,
25,000.
right.
Okay. So certainly the amount of work in this area may increase based upon the dramatic increase in these commissions. I'm trying to figure out, under 7148E, which is the appeal statute that presently exists.
Right.
Where is the requirement that the Fair Rent Commission have a recording?
There is none, but they all do.
Okay.
They all do.
So is it of harm to make it part of the law that they have a transcript?
Well, the question is who should transcribe the hearing? I mean, should there be a court reporter at the hearing? Should there be a video recorded, which everybody does? And who transcribes that? Is it the appellant? Is it the municipality? These, transcribing from a video recording is somewhat expensive. And to require the municipality to do it when, someone else is appealing is burdensome on the municipality. But, these are proceedings that only deal with very specific questions that are delineated in the statute. 13 questions on rent dispute questions. And the courts generally, give great deference to the commissioners, as long as there's no procedural irregularities.
So part of the problem per se is you say there's 13 questions, and that may be in your town, right?
No, it's in the statute. It's
Okay.
in the 7148C, I believe.
And that's the floor, right?
Right.
But the statute also allows the municipality to expand. So you have all of these towns, 80% of our towns that have now passed ordinances that are local law, right?
Right.
They're not the same, right? So
Right.
their questions very well may be different.
Right.
Getting to the transcript issue, the legislation, proposed legislation before us says any recording or stenographic record of the proceedings shall be transcribed on request of any party. The requesting party shall pay the cost of such transcript. So,
Okay, in other parts of the contested case statutes of the Administrative Procedure Act, it required the agency, which I assume, would mean the commission, although it's defined differently in the APA, to keep its own record of things like judicial notice, a variety of other things. So it would impose on the municipality some expense and some legal time.
so this avails your concern, this language, because we expressly say the party asking for the transcript is the one who pays for it.
No, because the other statute in the Administrative Procedure Act requires the agency to prepare a record of a variety of other things, all of which have to be transcribed from the tape.
Okay, I would think that since this is directly dealing with appeals from fair rent commissions, that this would guide, the other portion that they keep written notices related to the case, all petitions, pleadings, motions, and intermediate rulings. Is there a problem with clarifying that?
No, on what you just quoted.
Evidence received or considered, questions and offers of proof, objections and rulings thereon. Any problem with us making that part of the law?
Well, to suggest that, objections are, part of the practice of the Fair Rent Commission would distort what the Fair Rent Commission does. It's almost unheard of that an objection would keep evidence out unless it's so far beyond the 13 criteria that, it's a question of relevance. But, to suggest that there's objections, that just invites a litigator to come in and try to apply common law evidence questions to get an appeal. For instance, every document is hearsay. It can only come in if it falls into one of the categories of hearsay objection. So should landlords have to bring in their, the person who creates the documents and testify about the, it just overcomplicates what is a very simple procedure, and it will delay the resolution of these, which will cost landlords money, because when a complaint is filed for a prospective rent increase, the landlord is not allowed to increase the rent until there's a decision in the case. The longer you make the appeal process, the more complicated you make it, you'll make it longer before there's any resolution, and a landlord won't have, the right to increase rent. And conversely, in cases where there's a violation of state or local health and safety requirements, it takes longer before a tenant will get some satisfaction from that. These are designed to be simple procedures, not applying the excess due process, let's call it, of state agencies.
How long have you served on the Middletown Fair Rent Commission?
I've served since, I believe it was November, but I've been to every one since December 2023.
Sure. One of the things that, in my experience, people object to is the the veracity of a representation as to what similar units are rented for.
Mhm.
There are objections sometimes with regard to what is presented, a newspaper article
Right.
or an ad,
Right,
a print off from Zillow, things
Right,
like
right.
that. They're objected to. There's
Right.
rulings, right, on those matters.
but almost always they're allowed in.
Okay, but that is a perfect fodder for an appeal, right? So
I've never seen it. I've never seen it. And I tell you, I've read, all of the decisions at the Yukon Library's Fair Housing Collection. I've never seen an appeal based on an objection to evidence. Never. And this goes back to 1969, as I say.
And I will tell you, you had mentioned that you had never seen a case that the Superior Court had denigrated the commission for lack of
A record.
a record.
Right.
I don't have it. I can't readily find it, but I did run into one in Westlaw. Which is of concern because on a review, it's either a record review or it's a trial de novo, right?
Right.
Which a trial de novo before the Superior Court on an issue like this, which just for those of you following along, a trial de novo means you start fresh. It doesn't
Right.
matter really what happened before the Fair Rent
Right.
Commission, which could be a disaster with regard to these things. So,
Well,
the intent of
the,
this.
I'm sorry, go ahead.
The intent of this is to bring this in line, not to get to the parade of horribles of 4183 perhaps applied here, but I think it's pretty clear what's before us. And as you mentioned, there's volunteers. On my Fair Rent Commission, there's one lawyer, but they're not the chair, right? So,
And I'm not the chair of mine either.
my Fair Rent Commission is actually the chair is a fireman, a
Mhm.
firefighter, who doesn't have the background in evidence and
Right.
those kinds of things. And
Right.
that's a difficult position. And I'm just talking about my town, right?
Right.
I mean, there's many volunteers across the state that are doing this. So anyway, I appreciate the exchange, but thank you, Mr. Chairman.
Thank you, Representative. Comment or question from members of the committee, Representative Howard.
Thank you, and thank you for being here, sir. As exciting as that last dialogue was, I just need a couple of quick answers from you because you're an expert in this. Lines 25 to 38 of the bill, is it your testimony that if this bill passes, fair rent commissions are going to become more expensive for somebody,
Right.
whether it be the landlord, the tenant, or the municipality? Somebody's going to have to pay more money
Right.
to exercise a fair rent commission. Is that correct?
Right.
So today, when we have a housing crisis, we're going to pass legislation that either causes people who are providing housing a more expensive method to doing their job. That's choice one,
Right.
right? Choice two would be people who are already having trouble paying their rent. Those are the ones who come before you, right?
Right.
That it would become more expensive for them.
Right.
That would be choice two. Or choice three is an unfunded mandate on the municipalities. Is that fair understanding without
Yes.
whatever words you
And
guys
when
use?
it's more expensive to the municipality, it also becomes more expensive to the landlord who has to pay the property taxes. So,
Right. Would you agree with me that any unfunded mandate becomes more expensive for
yes.
taxpayers?
Well, not any unfunded mandate, but this unfunded mandate.
Well, can you give me an example of an unfunded mandate that wouldn't cost taxpayers more money?
The unfunded mandate that municipalities have ethics boards.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Thank you, Representative. Comment, question from members of the committee, comment, question from members of the committee. I do not see any. Thank you very much for joining us this morning and providing your testimony.
Thank you.
Dr. Bashani Ree. You may provide your testimony when you're seated.
Good morning. Senator Winfield, Representative Staffstrom, esteemed members of the committee. My name is Dr. Bashani Ree. I am the Executive Director of DROP LWOP New England, a nonprofit dedicated to restoring hope to incarcerated persons who are serving lengthy prison sentences. We are also proud members of the Connecticut Coalition Domestic Violence Survivor Justice Act. We colloquially refer to it as DVSJA. I am here today to testify in support of that bill, SB 1502. Personally speaking, I come to this work very naturally and professionally, actually. So I hold the doctorate in forensic psychology. I'm a trained restorative justice facilitator. I often testify using my education and my expertise in the areas of violence and dangerousness and risk assessment. But this bill actually hits on a personal note. So I'd like to talk from a more personal perspective today. One September morning, when I was a younger woman, I became a member of a club that I never wanted to join. I survived an attempt on my life at the hands of a romantic partner. It's the kind of story that is quite upsetting when I share it, and obviously upsetting for me too. I was attacked, put in a chokehold. I was dragged by my hair down the hall. I was pistol whipped in the face several times. As I was losing consciousness, I had a vision of my own body in a river. The only reason that I survived is because he let me go. I couldn't fight back. He was so much stronger than I was. As a proud member of the DVSJA coalition, I have had the privilege of sitting with some of the incarcerated women here in New York, including two women's stories who actually mirror mine pretty much verbatim, except at the end of their story, those men did not survive, and they are now incarcerated. When you read the literature about domestic violence, what you find out, especially about homicide and domestic violence, is that most of the time it is the woman's body who ends up in a river, and the men survive and go to prison. But we have to ask ourselves what happens when the women survive and the men do not. We don't have many examples of that, and this is relatively new territory for us. And I know that as a community, we do not want to ever incarcerate survivors of domestic violence, sexual assault, stalking, human trafficking. And I think we actually really do our best to try to prevent that. But I'm here today to tell you that it has happened. We know in New York, we know in Oklahoma, and we know in Connecticut. I ask you to consider SB 1502. Thank you.
Thank you. Comment or question from members of the committee? Comment or question, Representative Howard?
Good morning, ma'am.
Oh, hi.
Hello. Thank you for sharing your story. I think those personal things are important regarding that particular piece of legislation. I'm not sure if you've been here all morning. And if you don't, not comfortable answering this, just say so and I'll move on. But there's a bill before us today that allows somebody who's incarcerated to request a hearing for a sentence reduction. Currently, they can do that every 5 years. The bill changes it to every 2 years, and the victim has to be notified. Do you think that it's traumatic to victims every time they get notified of this?
I don't think that we can universally state. I want to make sure that I'm clear. I have not read the piece of legislation. However, often in my work, I talk about from a survivor and forensic psychologist perspective that survivors are not a monolith. And so it's not necessarily always traumatizing, but I do believe that survivors need to be more a part of the conversation if that is something that they want to do.
Okay, and thank you for taking the time to visit inmates or incarcerated persons, excuse me, at York. Without telling too much of my story, I spent an awful lot of time at York and part of my life visiting somebody very close to me. So try to maximize her visits every week if I could. So she didn't feel alone. So I appreciate that you stop and visit people, especially those who are survivors like yourself. So thank you. And thank you for the strength for coming today, because I know that's not easy either. Thank you. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Comment or question from members of the committee, Senator Flexer.
Thank you, Mr. Chair. Good morning.
Hi, good morning.
Thank you very much for your testimony and for your courage in sharing your very personal story. I'm wondering if you could tell us a little bit more about the coalition that has developed an advocacy for this legislation.
Absolutely. So we have come together with basically the leaders here in Connecticut around domestic violence. CCADV is with us. She leads Justice, the ACLU. And we've brought in some more regional and national partnerships as well. But the focus is to expand trauma-informed sentencing and to recognize that often when people, a crime has happened and there's so much that's going on, a court case is happening, there's so much that's going on. And then sometime, 10 years later, somebody revisits a case and realizes that our current understanding of domestic violence actually applies to this particular case. And this bill would then provide an opportunity for an attorney. It would give them a mechanism to say, hey, we now better understand these things. Can we have a conversation? This bill is just about a conversation. But the coalition also has Stop Solitary Confinement, Second Look, Sentencing Project. We try to bring everybody who's on the ground doing the work here into one space to get behind this bill.
Thank you. And earlier in this hearing, there were conversations about particular sections of this bill, and I wonder if you had any specific responses to that dialogue that occurred here earlier.
I do, actually. Yeah, the first I would say is that we're talking about criminal cases, not civil cases. So I want to be clear about that. Criminal.
And can I interrupt you for
Of
one
course.
one moment? And there's a different definition of domestic violence in civil cases versus criminal cases, correct?
Exactly. Yep. And then I believe that my colleague Tanisha from She Leads Justice started to go down this path. And I would reinforce that this is about giving judicial latitude. This is about saying that if somebody can show evidence that this is happening, this judge can now depart from a mandatory minimum and make a different decision.
And can you tell me more about what the evidence is and what kind of process there needs to be as this legislation lays out for how that evidence is put forward?
Absolutely. We're looking for written evidence of the abuse or the trafficking or the stalking. So ideally, you would look for police reports, hospital records, school reports, things like that, psychologists' notes, therapy notes, and whatnot. You can't always obtain those things. As we all know, in domestic violence, it often hides. So the other pieces that we put in there is if there are people who are willing to sign an affidavit, go on the record under oath, provide text messages or other communications that are maybe more non-traditional, but still show evidence of stalking, coercion, anything that meets the definition of domestic violence.
And then how is that evidence put forward?
The attorney would put it forward as a part of their motion. So this bill does not expand any processes. It takes the processes that are already in place and just adds domestic violence as a factor to it. So we're not creating like a whole separate process. So let's say somebody is going to be going before the parole board. There's already a process in place for the parole board. So you would add the evidence of domestic violence, stalking, sexual assaults to that parole package to say, hey, here's the evidence that we have about this. And then in the hearing, we can have a conversation about it.
Thank you. And can you tell me how similar statutes in other states, how they've been changed with legislation similar to what's proposed here today, and what the outcomes have looked like in those other states?
Sure. New York was the first state to pass this law. It was It was, it carved out a couple of specific areas that then reduced the number of women who would be able to have access to it. That being said, there are still about 60 people in the entire state of New York since they passed it, which was several years ago at this point, who have been able to find some sentencing relief under DVSJA. Oklahoma is brand new. It was last year that it was passed, and it was all inclusive, as in didn't exclude any offense types, but that's because it recognized that there were a significant number of women. My colleague, Ms. Alexander Bailey, can talk more about Oklahoma, but there's a tremendous amount of women who are serving life without the possibility of parole for killing the men who were abusing them. And that's, again, a new understanding for us that that would even happen. And here we are.
Thank you. And does your group, and you might not have the answer to this yet, do you have any research, that example you just gave,
Yeah.
that the women serving a sentence without the possibility of parole for the murder of their abuser, do you have any examples of women in Connecticut who are serving a sentence like that? And if you don't have that, that's okay.
I do. I have one that has come to mind. She's done 30 years and she is serving a life without parole sentence. And I actually started looking into her case on a hunch. And when she and I started having conversations and she detailed the relationship pretty much from start to finish, we did several sessions of interviewing and whatnot. And I laid it all out for her in a way that I think allowed her to see it for the first time. She took the fall for an individual who had planned a crime, and she did the crime, but she never told anybody. 30 years later, we're now having a conversation about that she was actually in a very abusive relationship. He had only physically assaulted her on a couple of occasions, but he had 100% control of her finances, had completely isolated her from her family, had told her on several occasions he wanted to get her pregnant so that she could never leave him, and had basically emotionally manipulated her. At that time, she was 20 years old and he was 33, and she was sentenced to life without parole and serving here in Connecticut.
Thank you for sharing that. And thank you again for your time and your testimony here this morning. Thank you, Mr. Chair.
Thank you.
Thank you, Senator Fletcher. Representative Fishbone.
Thank you, Mr. Chairman. Good morning.
Good morning.
You had said that this was not a new procedure.
Right.
But I'm reading in line 38. It says, well, 37, 38. Prior to a court imposing a sentence of imprisonment for a felony offense, a defendant may move for application of this subsection. So how is that not a new procedure?
And I'm not an attorney, Representative Fishbein. I do actually have someone from the Yale Law Clinic who'll be testifying later today. And she is an attorney, and I would ask that maybe that question be deferred to her. It is quite possible that I misspoke, so I want to make sure that I don't further muddy the waters.
Yeah, because I wasn't going to say anything, and well, moving on to the next. You said that this domestic violence thing has nothing to do with civil, that it's criminal?
Correct.
What's that based upon?
I heard earlier conversation where there was talk about like family and children and bringing up things that sounded to me like we were going down a civil path, but perhaps I misunderstood.
Well, no, it's the representation that you made to this committee.
Right. I'm
looking at the legislation, specifically in line 46. It says 40, 45, and 46. Domestic violence has the same meaning as provided in subsection B of section 46B1. It's not a criminal statute. It's a civil statute. So I'm trying to figure out, once again, you've made a representation to this committee that it's not the civil standard, that it's a criminal standard, but I'm looking at the language. So am I missing something?
I don't think you're missing something. I think that we use the definition from the civil language so that we were not rewriting what is very lengthy text from the civil language. This law applies to criminal cases.
Oh, understood.
Yeah.
But it uses the civil standard, which the civil standard, I mean, domestic violence could be verbal. I actually represent people who have been victims of domestic violence. And okay, that's all I have. Thank you, Mr. Chairman.
Thank you, Representative. Comment, question from members of the committee. Comment, question from members of the committee. Seeing none, thank you for joining us today. Thank you for sharing your story.
Thank you, Senator.
Gaylord Salters. When you are seated, you may provide us with your testimony.
Good morning, co-chairs Staffstrom and Winfield, ranking members Fishbein and Kissel, voice chairs Fletcher and members of the Joint Committee. My name is Gaylord Salters. I come before you today to advocate for Senate Bill 1327 raised, a measure of profound importance to those who, like me, have faced the harsh realities of the war on drugs, incarceration, and wrongful conviction. In 2022, I was fortunate to benefit from a sentence modification after spending 2 decades wrongfully incarcerated. This experience has instilled in me a deep understanding of the necessity for reform in our judicial system. While the state's attorney's office has taken commendable steps to review my case and pursue my exoneration, it was ultimately the sentence modification law that facilitated my prompt release. This underscores the importance of having an effective mechanism in place for both rehabilitated individuals and potential wrongful convictions. Since my return to society, I have engaged deeply with the individuals and organizations that I connected with during my incarceration. I currently serve as a board member for the Next Level Empowerment Reentry Program and as the director of the Breaking Chains Project with the nonprofit Dope Inc. Furthermore, I am recognized as a poster child for the Second Look movement endorsed by the Sentencing Project in Washington, D.C., and I have recently partnered with the Second Look Connecticut in their advocacy efforts within our state. I share my journey and current initiatives to emphasize their direct relevance to Senate Bill 1327. We must establish a system that effectively provides individuals who have received treatment from the Department of Corrections the opportunity for a second look and a second chance for redemption. Throughout my incarceration, I was able to achieve significant personal development and contribute positively both inside and outside prison walls. However, it is disheartening that the only meaningful opportunity for sentence modification arose 20 years later following a revision of the statute. Many individuals remaining incarcerated who pose minimal risks to society are still ineligible for sentence modification due to a lack of consent from the state's attorney's office or because they are serving under mandatory minimums. In closing, I urge the members of this committee to support Senate Bill 1327. It has the potential to transform lives and restore hope to those who have been denied justice for far too long. Thank you for your time and consideration.
Thank you, Mr. Salters. Comment or question from members of the committee, Representative Fishbein.
Thank you, Mr. Chairman. Good morning, sir. Nice job. Thank you for coming here today. When did you get out?
I got out in June of 2022.
Okay. Are you working?
Yes, I am.
Okay. Well, that's good. Good to hear. It's something that very important to me, that the being able to get back into society and to be productive. So I'm glad to hear those things. The bill that's before us, we currently have the sentence modification, and we're reducing through this legislation. What's proposed is to reduce it from 5 years to 2 years. Why? I mean, I appreciate that, you made good use of this, and the system, looked upon you kindly. But at the other end, I'm also thinking about victims. Why is it good public policy that if you tried, you didn't do well, perhaps I should ask you if it was your first time, but maybe we'll get there. Reducing that time, why is that good public policy?
Well, I could take on both of your questions, actually. You know, the first one you say is reducing that policy to allow the individuals those opportunities to get that sentence modification. One opportunity is the mandatory minimums, and mandatory minimums are kind of hard to get by when you are a defendant. Yet, if you're a witness in a case, mandatory minimums are easy to get rid of because you're working on behalf of the state. So if there's an individual who's in prison and has taken significant steps towards correction, and the correction process has worked with the Department of Corrections, I wouldn't want that individual to miss out on an opportunity to thrive when there can be a system that will allow that. So that would be the short answer for my question.
No, I
And
appreciate
then you
that.
asked about whether or not I have been in prison before or whatever. And that's a significant thing too, because I have been in prison previously that was not related to the wrongful conviction. And being in prison, you have to come to a point of growth in order to move forward. And I've come to that point of growth, but most of the individuals who will benefit from this law are individuals who have experienced recidivism. And when you experience that recidivism and you get incarcerated for a period that exceeds 10 years, I think growth is almost natural for an individual who wants to do something for themselves and to take that opportunity from an individual. I don't believe that everybody deserves the get out of jail free card or sentence modification. No, you have to work towards that road to redemption, but I think it's significant to put forth that road to redemption so that an individual has the opportunity to follow it.
No, I appreciate that. So there's two questions. I was specifically, the first time that you asked for a sentence reduction, were you granted that?
I was not. I was an individual who started my own company in prison. I started building generational wealth. I've gotten myself together. I had filed for sentence modification. I was wrongfully convicted. The state's attorney's office had it in limbo. I have documents where they were going to work with me as far as my appeal, and a sentence modification would have been the resolution. But I did not get that sentence modification then, and I had to go through the state's attorney's office at that time, even though I had accomplished phenomenal feats. So once the law was changed, now all that I have done in prison came to the forefront, and it was before a judge and his decision versus me going to the state's attorney's office and them making a decision. So there is a huge difference there. Like I say, director of the Breaking Chains Project, poster child for the Sentencing Project in Washington, D.C., board member of Next Level Empowerment Reentry Program. None of this would have been possible had the law not been revised. But now the law has been revised, and you see that I'm a product of what can be. And there are many individuals in there who, like myself, I have seen taking those steps towards correction, steps that show that the correction process can be effective, but the public will never know unless we create opportunities to give those individuals a chance.
Yeah, and sometimes those opportunities unfortunately have to happen behind bars, and you prove yourself and yeah, you're given a chance. So no, I appreciate that. So thank you, Mr. Chairman.
Thank you. Comment or question, Representative Howard?
Thank you. Mr. Salters, congratulations on your success. I was just reading a bit about you and the book that you published and whatnot. It's pretty impressive. Congratulations
Thank you.
on that. The bill before us, and I appreciate that your testimony seems to be that what we did in 2021 was sort of the catalyst to you getting out 6 years earlier and continuing the success that you had built on in prison, right?
Yes.
And then, but the bill before us, and I'm not sure if you've been here all morning. I'm mostly focused on the reduction of 5 years to 2 years after a denial. Do you have an opinion on that?
Yes. So say, for instance, if an individual has been languishing in a prison for 20 years and then he gets denied and he has to wait a whole nother 5 years before he can come up, that period of time, that 1 to 5 years, is a period of time that this individual has to maintain his composure in an element that is filled with violence and chaos versus having an opportunity to go back for a sentence modification in 2 years. Because if nothing has changed within that 2-year period, there's a likelihood that that individual may be following the same path within that 5-year period. But the risks that are present within that 5-year period for this individual who has taken the steps to correct himself and has been effective with it could potentially be harmful.
I'm reading your experience page on the Sentencing Project website, and it suggests here that the judge's decision wasn't based, and I'm not contesting whether or not you were guilty. But I'm reading this, and it says that the judge's decision wasn't so much on that, so much as success that you had in your rehabilitation. Would you agree with that?
100%. That's why I'm here today, not for a wrongful conviction.
Right. So, and then in the time that you spent as an incarcerated person in those communities, do you think that if somebody comes before a judge today and they haven't proven themselves as you did, right? And then do you think 2 years is enough time for them to completely turn that around and convince a judge that things are much different for them now?
No, I don't. If they haven't proven themselves in that time, I do not think that the 2 years alone is enough time.
Well, that's
But
sorry.
the individual who I'm advocating on behalf of is the individual who has proven himself. So you took the negative, and that would enact a law based on only the negative, and that's the problem now. That's what I'm trying to say. Like, if we don't put forth a chance, then you would never know.
Right. And I think it sounds to me like we might be in agreement because we all up here in this legislature have to weigh everything, right? And you may have heard me say earlier, I have a concern that victims of crime, true victims, who are dealing with post-traumatic stress and whatnot, have an opportunity, and many of them take it, to be heard at a sentence modification. The bill before us would take that 5-year wait time, if you will, from a denial to a reapplication and minimize and reduce it to 2 years, which in my opinion, at least for some victims, would have an adverse effect on them. And what I'm hearing from you is, well, if they get denied, the likelihood that in 2 years, they're going to flip that all around into a granting is low. Is that what I just heard you say?
No.
Okay. So
Not if they get denied. If the individual, not if they get denied alone. If the individual goes up, which individual are you going under the premise of? An individual who has actually corrected himself and taken the steps towards becoming a productive member of the society, or an individual who hasn't proven himself? Which individual?
Well, let's start with your case, right? The judge in your case, we're in agreement, looked at you and said, okay, Mr. Salters has taken the steps to rehabilitate himself and can be a productive member of society. Therefore, we're going to reduce his sentence, right? That's a fair summarization.
All right.
Okay. So if somebody comes before a judge and says, I have rehabilitated myself, the judge says, well, we're looking at the evidence here. You got 14 infractions. You haven't learned a skill, et cetera. You have not rehabilitated yourself. The judge denies it, right? That's the individual I'm talking about. Do you think in 2 years they can make a case for their release, that they've made that much of a change in 2 years? Or do you think it takes longer, given your experiences?
Well, I would think that it could take longer and it could happen within that time, but the bigger picture is how long has that person been incarcerated at that point so that you can get the whole picture. The 2-year situation that you're putting forth is not giving the whole picture of the individual who's been incarcerated. If you use me, for example, you would say, I've been in there for that 20 years and then I got denied and then went back up 2 years later, right? And your concern is that it would be traumatizing the victim. I believe that that is a possibility. We have to be realistic. I mean, every 2 years, it is a possibility, right? But I certainly don't believe that we can make law based on a possibility alone when there are so many great possibilities that would trump that.
Trump the trauma to the victim.
Trump the 2-year process. If you put into law that you would have to wait for 5 years, and the individual has a good record and has done everything that he can towards rehabilitation, right? Now, if you put in the law that he has to wait for a whole nother 5 versus a 2, I mean, that could trump the process of the whole bill being a second look, a second chance.
Okay. All right. Thank you. And again, congratulations on your success. I say it with great sincerity. And thank you, Mr. Chairman.
All right.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? If not, Mr. Salters, it's good to see you again. I just want to make sure that because you went back and forth with both Representative Fishbein and Representative Howard, so I just want to make sure that's clear what you're saying. So you are saying that with the 2-year process, you were ready the first time. You just were denied, and they're not the same thing. Not being ready and not being denied, and being denied are not the same thing. You can be ready and be denied, which is why you still advocate for the 2 years. Am I understanding you correctly?
You can be ready and still be denied.
Yeah.
Yes, you can be ready and still be denied. So to put that in law for a person who is ready and denied, that is the problem right there.
And you also have and please, if I'm putting words in your mouth, help me to take them back out. But you can have a person who has a claim of actual innocence, but has not prevailed on that yet. And this is a process because during the time they were in prison, they did all the things we would like them to see. And so that's a consideration for this as well, I think, is part of your testimony.
Well, if you have a person like who has a claim of actual innocence or wrongful conviction, I would say that this is another avenue that would work for a situation like that, as it has worked in my place. So, for example, the state's attorney's office did not oppose my sentence modification. And I think that is something that speaks for itself with regard to what we're talking about here today.
Thank you. We've seen that with other folks who've come before us and who have prevailed and gotten compensated by the state. So I appreciate your testimony. It's important to take into consideration just as much as all of the other factors. All right. One final pass. Comment or question from members of the committee? Comment or question? If not, thank you very much for joining us today.
All right. Thank you.
All right. Next, we will hear from John Doyle.
Good morning. Co-Chair Staffstrom and Winfield, ranking members Fishbein and Kissel, Vice Chairs Vizino, Flexer, and Gadkar Wilcox. Good morning to all of you. My name is John Doyle, or Jackdo, as a lot of people refer to me as. I'm the state's attorney for the Judicial District of New Haven. That is, I'm employed by the state of Connecticut in the Division of Criminal Justice as a prosecutor, where I've been employed for 27 years. As of now, I'm responsible for the state's attorney's office for the Judicial District of New Haven, where there are 28 prosecutors that work for myself in that district. I'm here in regards to two bills today. First, I want to just outside say I will stand on the submissions that the Division of Criminal Justice submitted in regards to Senate Bill 1327 and Senate Bill 1502. But I do have some comments and do some things I just want to add into our written testimony. The sentence mod procedure is currently in the state of Connecticut. I won't outline all the details, but in listening to the testimony that came up here this morning, I think you're aware that several years ago, the sentence mod procedure in the state of Connecticut changed drastically. Part of that was with our agency, the Division of Criminal Justice, the prosecutors and our agency agreed to some of that and recommended it. In addition, there were a lot of advocates and including people that pushed for the changing of the sentence modification bills. You may recall that prior to the change in the bill, for one to get a sentence mod, somebody had to make an application to the state attorney's office, and the prosecutor was essentially the gatekeeper before that went to a superior court judge. And there were times that we did agree to matters. Other times then this particular statute changed, and as you know, as it currently stands, is an individual, if they are serving a sentence of less than 7 years, they can apply for a sentence modification and have a hearing before a judge, whether or not the state objects to that. After 7 years sentence, they need the state's agreement before they can go to a hearing. And quite often, and just like my office does, we have committees that review those packages, determine which are matters that should go before a judge for hearing and which ones we oppose to. And also, as I'm sure you're aware from testimony been submitted here, individuals who go to trial and get convicted regardless of whatever sentence they're serving have the ability to apply for a sentence modification. But as was pointed out in the testimony this morning, there is an ability that if you go to a hearing, you were denied, it's a 5-year wait before you would have to go for another hearing again. And what I would like to point out to this committee, and just to remind this committee, is that obligations and abilities for individuals to apply for something post-conviction to extend, to review their sentence, have several factors under Connecticut statutes and several avenues as well. We have sentence review. We have sentence modification, the process we hear today. We have commutation. We have hearings under 54-125A. To remind this body, that's the codification of Public Act 1584 or 23-169, commonly referred to as the juvenile parole hearings. Lastly, what I would indicate on behalf of the Division of Criminal Justice, has been alluded to this morning, on the sentence mod statutes, I'm concerned about the effect upon victims, as are all prosecutors in Connecticut, to require them to come back every 2 years.
Thanks, Jack. I'm sure there'll be questions.
I'll be happy
for
to
you.
answer any
Yep.
questions. on
Representative
that.
Fishbein.
Chairman. Oh, thank you, Mr. Chairman. Thank you for coming. I always see you remote. But thank you for coming here today. You were talking about the shift 2 to 5, 5 to 2, and the effect upon victims. Did you want to expound upon that?
Yes, I will. So currently, right now, if somebody applies for a sentence modification, our office, including the Office of Victim Services, make the efforts to contact victims and let them know that this hearing is occurring. To change this from 5 years to a 2-year period would require us to redoc the case and to also, by the way, make it obligatory, as part of this bill has also indicated, which means that we're going to have to contact victims every 2 years and advise them that a hearing is going to be occurring where they can come and testify and address the court if they want, or submit written testimony. We've heard a little bit this morning, and I'm sure you'll hear more throughout the day about the effect that the trauma certain types of cases have upon victims, and that is a very big concern for our office. I won't belabor the fact, obviously, that there's a kind of a state budget crisis. There's not a lot of funding and allocations to a variety of different agencies, but putting that aside, because we will rise to the occasion in whatever situation we're placed in. But I'm just concerned about the effects that will have upon victims and will also have upon court staff. As was also alluded, I believe, in the letter submitted by the judicial branch, and also alluded to by the letter by the state victim advocate. Representative Fishbein, hypothetically, just a few years ago, I prosecuted a very serious matter, a trial, individual sentenced to 30 years in prison. It concerns me about the fact that I would have to set up a schedule where at least 15 times over the next 30 years, unless there's some relief or it's reduced, that I would have to call that same victim with the services of the victim advocate and tell them that a matter is again up for sentence modification hearing, in addition to all the other avenues that are under the statutes.
I appreciate that. You obviously have experience with pre-sentencing reports.
Yes.
And with regard to 1502, this new proceeding regarding domestic violence, do victimization of domestic violence sometimes appear in those PSR?
If it's applicable, it appears all the time. So as well as I would also indicate to you if a defendant has been a victim of domestic violence, sexual abuse, human trafficking, and all of those other items that were mentioned in that particular bill. I would indicate, it seems to me, and I don't know if this body is recommending it, there's kind of a little bit of a, I don't want to say a conflict, but there's kind of opposing forces in 1327 versus 1502. When you have a situation where it is presumed that a prosecutor, a judge, and a criminal defense attorney did not take those factors into account in sentencing. I hear the situation as being described here this morning, or perhaps somebody didn't mention it or it didn't come forward. I don't know what happens in the state of New York, but I did read, I think it was Ms. Scanlon's letter testified this morning. I would tell you it greatly concerned me if a criminal defense attorney did not bring it to my attention as a prosecutor or to a superior court judge's position, the fact that a defendant may have been a victim of some type of offense or some type of behavior. Because I do fully believe that those factors would be taken into account by a prosecutor, by a judge, when brought attention by a criminal defense attorney. I could give you examples of cases where that has taken effect.
Yeah, no, and that's why I appreciate you being here today, because that's what I've been saying, that it's already part of the system. So, I very much appreciate the exchange. Perhaps not directly related to this, but you did talk about the effect on the system by allowing this. I'm hearing a lot of problems with habeas petitions because other areas of our judicial branch are dealing with sentence review and things like that, that habeas petitions are not being able to be addressed on a timely basis. Do you have any information with regard to that?
I would indicate habeas area is the one area of law I've never really dealt with as a prosecutor, but I do know that some of them are affected by the filing of sentence modification applications. For example, as I'm sure you're aware, one of the big focus in a habeas corpus petition is to claim ineffective assistance of counsel of an underlying attorney that handled your matter. I do know that sometimes I get applications for sentence modification, and when I do my due diligence and research and look into it, I find out there's also a habeas pending with some of the same concerns. I don't know really how they play off of each other, but I do know that as the judicial branch outlined with their own numbers, the number of sentence modification applications has grown exponentially over the last few years.
And in your JD, about how soon are they turned around? On
I mean,
average?
when they arrive to us?
Yeah.
Usually somewhere between 90 days to 6 months. It depends on which form it comes in. There are ones that are going to get the automatic hearing. And then there are ones where my office has to review and screen and determine whether we would oppose or agree to a hearing or not. And we do so by committee when we can get that committee together.
Well, thank you. Thank you once again. Thank you for coming here today.
Yeah.
Thank you, Mr. Chairman.
Further questions or comments, Representative Howard?
Thank you. Good morning, Attorney Doyle. I think I just want to make sure I understood. I had this question. I think Rep. Fishbein asked it in a slightly different way, but these sentence mods, are they all held at the JD or some held at the GA?
Some could be held in the JD, in the GA as well. But I think I would generally say you're going to see more of them in the Part A's where the sentences and the potentials where the more serious matters are handled.
And so you're expressing concern, I think you said it this, your support staff, but also your own attorneys and probably the public defender's office too, right?
Yes.
As far as the demand?
Yeah, so there's two, there's two things I just want to, so the committee can understand this big picture. I have about, give or take 400 criminal matters pending in just the Part A New Haven. That's 400, give or take, defendants. On a process where this would go every 2 years is, let's just say hypothetically, I had 400 this year, 500 last year. I'd have to establish a schedule knowing that somewhere in the next couple of years, 1,000 cases, potentially I would have to have sentence modifications on. I have hundreds now, but if I got into the thousands, I think that would be insurmountable. And when we talk about concerns over victims, that is a member of sentence modifications that I would have to handle to the exclusion or limitations placed on the regular criminal cases, advocating for victims and advocating on behalf of public safety. That is a big concern for us.
Well, to that end, you and Rep. Fishbein just talked about the process by which people can say they had ineffective counsel. So if you overburden, say, the public defenders, forget your office for a minute. If you overburden the public defenders, doesn't that become sort of a snowball then?
I would say, yes, I would say it does too. I think also is to look at the fact that, there's a lot of, there appears to be a lot of attorneys that handle the sentence modification and post-conviction things, which also ties back into 1502, where I don't think that I need this committee, I would ask you to accept and understand that a lot of these factors are brought up by prosecutors and defense attorneys in the regular GA courts, in the regular Part A courts where we handle the criminal matters. So all these factors that are thinking to be addressed later on are addressed in those process. And like I indicated, an attorney that wouldn't bring those factors to a court or a judge's attention, I don't think that some attorneys recognize that does happen in regular criminal court.
Yeah, well, I noticed that the public defender's office actually supports the legislation. That's why I was just curious your opinion on that. The other thing is, you mentioned contacting victims, and you heard earlier, and I get it, that victims aren't monolithic. What's your experience with victims when you contact them or have the victim's advocate contact them? Is it, despair, frustration, or how does that work? Or are they just, innocuous to it, or what?
It is all of the above.
Okay.
I can personally tell you that I've had to call victims on serious matters of which somebody is serving a sentence modification, only have to say comments such as, again, I was just before the parole board last week. I was just there for a commutation a couple years ago. I was just there for, now I have, and then after a sentence mod, which may or may not be work out, and some of them, and a good number do, then get the call. Now I have to go back to the parole board for one of the juvenile parole hearings. It is, it's very frustrating on behalf of victims. I'm by no way saying that there isn't some cases where certain modifications aren't appropriate. And there are ones that I've agreed to, and there are ones that I've had to oppose as a prosecutor. But to continuously have to with all of these between sentence review, sentence mods, commutation, habeas corpus, and then motions to correct illegal sentences, which are also filed, I would indicate that it becomes very frustrating to victims and very frustrating to the process. The process that the state and everybody agreed that this legislature passed 2 years ago is one that I think that is working and can still be worked with. Although I can tell you personally, it is a great burden to my office. But I have this position, I'll accept that burden. But this would be too much of a strain upon the judicial branch, victims, prosecutors, criminal defense attorneys, public defenders, the whole, and victims especially.
And I just want to make sure I have this right. So you've listed other avenues to essentially have your sentence modified, and sentence review, commutation, sentence modification, habeas corpus, parole. Did I miss any?
Well, there's the juvenile parole matters, which is,
Okay.
the 1584 hearings, if you were under a certain age when your crime was committed.
Right. Yep.
And then there's obviously going to be discretionary parole at the end of a sentence.
Okay. Thank you. Thank you, sir. And thank you, Mr. Chair.
Senator Flexer.
Thank you, Mr. Chair. Good morning.
Good morning.
I have a number of different questions for you, but I'm going to start first with a question. I believe this is the first time that someone in your position with your jurisdiction in New Haven has been before this committee, since this committee has made some pretty sizable decisions about settlements that were under your jurisdiction in recent years or in the last several decades. And I wonder if you
Sure.
could just share with the committee, given that you're here right now, how we can have confidence that decisions like the erroneous and harmful ones that were made in the last several decades are not being made under your jurisdiction today.
So the first of all I would indicate is that the Division of Criminal Justice, okay, over the last several years, of which before I was even a state's attorney, has established a variety of policies, okay, that we have in effect that are applicable upon all prosecutors. We also take into account the directives that we get from courts or from the Supreme Court and the directives that we get from this body in addressing things that we've done wrong. We have committees where we take a look at, going back, we have a conviction integrity unit, we go back and look at prior convictions. And we also have the responsibility of a state's attorney, of which I am now one of them, that if we think that something was done wrong or improper in a case, to go back and make efforts to address and to fix that. But I would also point out to you, Representative Fletcher, that a lot of the ones that you're talking about, these matters, as you heard, they indicated they occurred decades ago. A good number of them occurred decades ago. I think I was in middle school when they happened. I had nothing to do with them as a prosecutor at home, but I can assure you that as a prosecutor in New Haven now, the prosecutors in New Haven, and I believe all around the state, ask with the utmost integrity to be able to present exculpatory evidence, to investigate whether there's exculpatory evidence, to comply with all of our policies and all directives, so that something improper doesn't happen again. I know it is a large amount of money. I know that this body had to address a few weeks ago, but I also believe it's a small amount of cases and reflective of the number of cases that have been prosecuted in New Haven or around the state.
But you would certainly agree it's been a huge impact on individual lives, despite your description just there that it's small.
Of course it is. Of course it is on those individuals. Yes, it is. I respect that and I understand that because I've had to make the difficult decision in several of those matters myself. And I know how hard that is.
Thank you. Moving to the legislation that's before us. Are you here today as it relates to Senate Bill 1502, speaking on behalf of the whole division?
I am speaking, I was asked to come here on behalf of the division. I can't speak for every single prosecuting division, but I have spoken to the majority of the other state's attorneys, because just I'm sure as your body does, when statutes come up and they get addressed, we look at them, we discuss them. I do believe that, and I want to clarify what my position is on that, because I didn't get into too much. I think in concept, the idea that those factors for victims of domestic abusers, victims of sexual assault, human trafficking, or domestic violence, that those factors should be considered in sentencing. But what I'm trying to point out to this body is I think that they do. Now, could there also be a situation where something wasn't known at the time or was not brought up? But I can assure you, if those factors are brought up, they would be addressed by prosecutors, by defense attorneys, and by judges. I'm a quick example that I can give you of how that would be addressed. Some almost 20 years ago now, I prosecuted a case of a man who, without getting into too much detail, it was a trial, attempted to kidnap several young boys for sexual purposes. I conducted a jury trial. Those young boys testified at that jury trial. They were young. They were between 10 and 12 years old at the time. Very difficult case for them and their families, and they did a great job in testifying at that trial. And that individual was subsequently convicted by a jury for several offenses involving them. 10 years later, he was 12 years old at the time. 10 years later, he's a 22-year-old individual who is on the docket in the Part A court in New Haven, charged with several robbery offenses. His public defender attorney, Chief Public Defender Merkin, promptly brought that to my attention to remind me that that was the individual that was a victim in my case from 10 years ago. And I can quite assure you that between myself and Attorney Merkin and Judge Clifford at the time, we did take all those factors into account. So there is a mechanism for that. It's not like we just, that is something that we don't take into account. The system is designed to do so.
Thank you. And I think that example you just gave is a compelling one, except that would require, for that to always be the case, that would require that you always happen to be within your jurisdiction. No. Right? That 12-year-old person who's then a 22-year-old who's committed offense in another part of the state wouldn't happen to have the people in place who have that memory, correct?
No, but what he, in this matter, he had his attorney available, and the attorney came to our office about this factor. She didn't come to me directly, and then we looked into it. I happened to have been the prosecutor who handled the underlying matter. And even if, even without directly coming to me, knowing that he was a victim in the matter, that's also something his attorney could look into and request reports and request matters to substantiate that as part of the plea bargaining process.
Right, but it was looked upon differently because not only was it the attorney sharing this information with you, but it triggered a memory that you personally had.
Oh, on this particular one, yes, that I had. But
So-
the information, the memory probably wouldn't have been triggered if the lawyer didn't. Well, put it this way, the memory was triggered because the lawyer brought it to my attention. But if the memory had been triggered without the lawyer bringing it to my attention, I would have taken that account as well.
Right. So oftentimes when victims come forward of domestic violence, of sexual assault, of stalking, they are dismissed. They are often met with people within our system that will make assumptions that they're lying, that they're not telling the truth, that they're attempting to deceive. And many people who work as victim advocates watch as victims are discouraged from bringing up the abuse that they've suffered, particularly if they're facing a criminal offense. And so how do you see the system now encouraging a victim to come forward when they've been already addressed at some level as not telling the truth or exaggerating the circumstances of an experience that they've had?
I apologize. I'm not exactly following. Are you indicating that so there's a criminal prosecution of one individual and the person that you're referencing is the victim in that matter and their inability to come forward and talk to the authorities about what happened? In another case or the case in which they're the victim?
It could be both. It could be a case where they're the victim, and it could also be a separate case where they are also being accused of a crime.
Okay, so in the case where they are the victim, I mean, there's a mechanism where the matter is now, if there's a case where there's criminal prosecution occurring, I'm going to assume at some level that between the police and if it's in court now, a prosecutor has made the decision that this is a prosecutable case and that we are going forward on it. The victim, as you may aware, may have strong views or positions one way or the other. But I would indicate if it's a situation that's now in court with the prosecutor, it's not something that we're going to dismiss and indicate or be disrespectful to that victim, because we've obviously commenced the prosecution where we do believe there's merit or credibility to what they've said. Now, in regards to a matter in which you're the criminal defendant and you have that background or you have that experience, I submit to you, yes, there's going to be sometimes where it might not be documented in either police reports or DCF reports or things like that. But I would also indicate that if that is brought up by a criminal defense attorney, that is something that's going to be taken into account by a prosecutor or judge. There may be factors that are always brought in. Not every single time are there factors that are brought up on court also in the record. There's a lot of pretrial negotiations that prosecutors and judges and criminal defense attorneys have beforehand, and a lot of factors come up. And then there is the pre-sentence investigation report, which we would hope that most defendants would submit to it, whether you're, no matter which side of the fence, where you can cooperate and provide information that could be a background for a court to take and determine in regards to sentencing. So there are mechanisms for that. I think what the state attorneys in general, and I'm speaking for myself, are concerned about in 1502, where we're carving out certain offenses and saying, or carving out, certain backgrounds of certain criminal defendants that must be brought up separately to a court under this particular statute. It's directing us to do something that we would normally do anyway. And so I don't know. And for practitioners of criminal law, that means prosecutors, defense lawyers, and judges, who I want to clarify actually do the regular GA work and Part A, pretrial and trial work, not the post-conviction work, they know that that's always brought up. They would always bring that type of behavior up if it was made available to them. I give it to you the situations where a victim or a defendant may not want to bring up certain backgrounds. I understand that. But if these factors are brought up to a prosecutor and a criminal defense attorney, they are going to take them into account.
I appreciate that. But do you acknowledge that there are times when a victim may be discouraged from bringing that information forward because of the perception that that they are not telling the truth, that they are just doing this to try to look more favorable because they're facing a criminal prosecution.
So are you talking about somebody who may be a victim of sexual?
No, I'm talking about someone who's being, and I don't mean to interrupt you. I'm just
Okay,
trying to
that's fine.
clarify. I appreciate the clarification. I am talking about someone who's being charged with a crime, who wants to come forward and say, this is the abuse that I've suffered. And there's a culture that says women lie, people exaggerate things. And that culture makes it so a person who's on the line for being prosecuted for a crime might not want to come forward and share the totality of their experience.
I would indicate that I can understand if somebody does not want to come forward and share the totality of their circumstance and be concerned about it. But I can tell you that this is one thing I could speak on behalf of all 215 prosecutors in the state of Connecticut, that we would seriously take that into consideration in how we handle things. If a criminal defendant brought that up through their defense attorneys, and not speaking for the Superior Court judges that you appoint, I'm sure they would also take that into account. So it is a little concerning that parties believe that we don't take that into account, because we do.
And I appreciate that you just made a statement on behalf of all you said it was 215
Give or take.
prosecutors in the state. So I have had the unique privilege of, or not unique, but the privilege and honor of serving in this legislature for quite some time and working on issues concerning domestic violence and sexual violence for more than a decade. And in my experience, many of your colleagues are excellent at their work and excellent at understanding the unique circumstances of these kinds of crimes, both for people who are just solely the victim, but also for people who find themselves facing a prosecution themselves. But I have to tell you, and again, you're just their spokesperson here today, so you're getting my full frustration. Time and time again, when pieces of legislation are put forward concerning these types of crimes, the Division of Criminal Justice refuses to come to the table before a public hearing like this, meet with advocates, meet with people who speak on behalf of victims of violence, to try to work on legislation. And instead, you submit testimony here today. And we could have been working on this together for the last several weeks and months. And so I'm just wondering, when is the division going to be more of a partner in trying to write these types of bills in the future? Or is this just always going to be the way the division operates on these issues?
I'm sure speaking, I can't explain that background of the history or as you've described. What I can indicate is that I have in the past have testified before this body on a variety of bills, both as a state's attorney, as a regular prosecutor, and at some point in time as a union official. I currently sit on the division's legislative board, so I can tell you is that we do, when bills are passed, we do review them and take positions on them. We determine if they're of great importance to us or if not, whether we're going to submit written testimony or not. So it's done as part of a practice. I think I can't speak entirely on behalf of the chief state's attorney and other state's attorneys, but I can tell you that this state's attorney has no problem sitting down with bodies and boards and things to address and to make recommendations on laws. For a time, there have been a variety of committees that I've been involved with, in addition to our legislative committee, for a long period of time. In a prior position, I assisted the Hate Crimes Advisory Council on some statutes and some guidelines. I've been involved with a lot of legislation involving firearms legislation, okay, and things such of that nature. So I'm sure that whatever, I apologize for whatever boards or committees that you feel that we haven't been a part of. I can't speak for all that, but I do know that we do want to be part of the process because, quite frankly, I would indicate I don't particularly like having to be in a position of being reactive to some of these bills. I'm very concerned about some of them, and I understand perhaps your frustration is that here I am as a prosecutor telling you some problems in this, some which you may agree with, some which you may not. But I understand you're hearing them for the first time.
I appreciate that. And just so you know, and I don't think it was directed to you individually, but to the division, outreach was made on this proposal starting last year.
Okay.
So if someone from the division could have come to the table and worked with us on this, I think that would have gone a long way and frankly, making a better product to what we're looking at here today.
I would agree. And I do agree. And the other, and I would, in respect, what I also just want to indicate is that I do see between these two bills, between 1327 and 1502, for me as a prosecutor, there's kind of a, in one level, we're trying to get kind of a difference in sentencing structure or concepts regarding people who might be victims, who are now charged with crimes, who've been victims in the past. But that's also going to have effect when we go over to the sentence mods for the other individuals who are requesting that kind of modification. And I think you see the connection there, which does concern me in my sole role as a prosecutor. And, whatever happens with this, Representative Flexler, if there's anything that I can do to assist on behalf of the division to be part of that conversation, I'd be happy to do so.
Thank you. And I don't say this to be aggressive, but it's Senator Flexer.
I apologize.
It's okay.
I'm sorry.
It's okay. Thank you. Thank you, Mr. Chair.
Senator Getcar Wilcox.
Hello there, Professor Doyle. Nice to see
Hello.
you in a
Nice to
different context.
Yes.
Usually we're on
Well-
campus together. I just wanted to follow up on a Senator Flexer's question actually on SB 1502. So, you said largely your objection is that this work is already being incorporated by prosecutors. And so my first question is, how do we know that there's some uniformity there, that everybody is acting in the same way? Are you following the same guidelines, for example, that are suggested in the legislation?
Well, Senator, what I would indicate is that it's not just prosecutors. In my observations, defense attorneys do this and judges do this too. There's a lot of variety of factors that go into plea negotiation, plea discussions. And I think everybody recognizes that every single case is unique, okay? Based upon somebody's background, the history, the relative strengths and weaknesses of the case, the cooperation or lack of cooperation of the victim, eyewitnesses, every case is unique. But when we get to the point of where there's a potential disposition in a case, all factors are kind of brought up to the table. All things, and a lot of, and we know as attorneys in general that there's a lot of negotiations that goes on behind the scenes in chambers with judges and prosecutors and defense lawyers, where all of these things are brought to the table if they're known about and if they're brought up, but they're not dismissed because a defendant may have been the victim of an assault or a horrible upbringing, or the victim of a sexual assault or a crime. Those are taken into account by prosecutors, and defense lawyers and judges. And I think
Let me
it's
just ask, when you say those are taken, how would we know that? Like, is there a protocol that we know that for sure everyone, is there some documentation that everyone in fact has taken that into account? How would we know that that's been taken into account and there's been some uniformity, let's just say across prosecutions? And in the event that it's already being done, what's wrong with legislation that provides that uniformity? Since you're saying it's already being done, what is the objection to creating a uniform standard now so that we know for sure those factors are being taken into account and not just left to the discretion of the 200 prosecutors, for example?
Well, I understand, for example, but I think one thing that we have to point out is that it's not just in the discretion. Prosecutors are the ones who make the determination of what's charged or what offense or whether to bring a case in the first place. But a Superior Court judge is the one that has the ultimate discretion he or she has in determining what sentence to fashion. So when these factors are brought to the table, there are aggravating factors that a prosecutor would bring up. There are mitigating factors that a defense attorney bring up. There are, let's just say, mitigating factors that a defense attorney may bring up to a prosecutor that might affect their position on the case or their charging decision. But at the end, also, there's a Superior Court judge there who's going to make the final decisions. Now, how do we confirm what's documented? Part of it's going to be what's documented in a pre-sentence investigation report that is ordered by the court. But at some point, we can't exactly control what's going to go in there. You would hope everything would be in there. You may have some concerns about what prosecutors do or how they document it. Sometimes I have concerns about what defense lawyers may do or document in that report. Sometimes we have cases, I'm sure this body's aware a pre-sentence investigation report is required in all felonies unless it's waived by one of the parties. Okay, quite often, sometimes defense lawyers might attempt to waive it and a prosecutor would want it because we want all those factors to be there for a court or a judge to determine. So, and then even if it is ordered, it's going to be up to the defendant whether he or she wants to cooperate with that PSI and put those factors in there. So I don't know how to say how this body could be aware of it because I think the pre-sentence investigation reports are going to be confidential. Could there be a process why the judicial branch or perhaps redacts them and so you can review in certain cases if they're there? But I think that by I guess I would answer your question is like, if you codify this same stuff, which I think is already there, how are you going to get those answers anyway if there's no way to calculate it now? Okay, I guess.
Well, but
where
I
would
guess
respond.
that's my question. But right now, when it's not codified, we have no way of even knowing that there's a directive, except that you're saying that 200 people do the exact same thing, but there's no way to know that. They haven't been instructed to do that necessarily, right? So what is the objection to then codifying it since you've testified that that's what you do already? At least we know now there's a directive that says that this shall be taken into account instead of left to the discretion of the 200, where as it is now, because unless there's a protocol in place that I don't know of, you're doing this based on the discretion of whoever decides to use these factors, whereas the legislation is proposing that there's a directive that it shall be taken into account. So it doesn't change all the discretionary factors. It puts a directive on top. So what is the objection to that? Just to create a more of a sense of uniformity.
Well, by the way, and that statute addresses two different levels. One is the initial sentencing and one is also the sentence mods. So if we could put the sentence mod issue off to a side for a moment, because my concerns about that. What you're doing on this proposed legislation is basically saying to, and it's not just prosecutors, it's saying to prosecutors, criminal defense attorneys, Superior Court judges, okay, and any of the other actors in the criminal justice system. It's highlighting three particular areas and then saying these three particular areas that you need to highlight on, even though you're already doing that, much to the separation of any other factors that you should consider. Deterrence, any other types of rehabilitation, acceptance of responsibility, effect on the victim, life-altering, all these things are taken into account by judges that weigh that.
It doesn't preclude you still taking those other things into account, right? It just directs that these things actually be taken into account. And there's a directive on it. It doesn't preclude any of these other things you mentioned.
I wouldn't say that it precludes them, no.
So what's the objection? Because I come back to my same question. What's the objection then?
Again, putting aside the sentence mods, we're directing that Superior Court judges looking, and the actors in the system look into factors that they already are looking into. That's my concern. Why do we highlight those three particular areas on behalf of certain defendants and not looking in other areas on behalf of certain defendants? We're just, I would just ask the question about why these factors need to be highlighted when they are taken into account, as by the example that I gave earlier this morning, or gave earlier.
Thank you, Jack.
Thank you. It's nice to see you.
Nice to see you.
Further questions or comments from the committee? Representative Quinn.
Thank you, Mr. Chair, and Attorney Doyle, good to see you. Does the division keep any statistics on what % of cases sentence modifications are sought in?
I do, we may, we have some very good research and data planning people. I do not have any particular knowledge. And your question is not how many are filed, but how many are granted?
No, how many are filed?
Yeah, I do believe in the, if I was reading it correctly this morning, and a letter submitted by the judicial branch's external division, they put some numbers in there. I will tell you that in the time that I been the state's attorney in New Haven since June of 22, they have substantially increased in number, more than 2.5 times.
Okay.
So part of our concern here is that, just to put in perspective, I've got 400 cases. If we resolve all of those right now, would say please, and let's just assume some of them involve prison sentences. That means double that number in addition to the regular docket. I'll have twice as many sentence mods 2 years from now.
Okay. I mean, clearly the thought in 1327 is that perhaps 5 years in between modification requests is too long. And I understand your concern that 2 years might be too short. Is there a happy medium? Is it 3 years? Is it 4 years? I mean, one way or the other, the burden is going to be the same. And it's just a question of how often that burden is going to be undertaken.
Well, one fact I'd like to just to point out, Representative, just to recall this right now, if the sentence is less than 7 years, you could apply for a sentence modification the day after you get sentenced. I just had one of those 2 weeks ago. But if you are sentenced to more than 7 years, okay, you get to, as a plea, you would need the state's permission, okay? as the gatekeeper on that. And I want this body to be aware. In New Haven, I have about 70 of those pending. Once or every 6 weeks, my staff gets together, 5 prosecutors, we review as the gatekeeper function. Some we agree, some we do not. And the ones where I would indicate we don't agree are usually when individuals don't have very much as far as rehabilitative efforts while in custody, or at the very, very beginning, or not even halfway through a large sentence. But there still is a process. So when we get to the 5-year part, just to recall, it's sentences that are greater than the 7 years, which requires permission, or jury trials. So if somebody goes to trial and gets convicted and say on whatever charges is given a 40-year sentence, then it's every 5 years if denied.
Okay.
In addition to all the other statutory methods as well.
Okay. I mean, I think in general, I agree with your concerns on 1327. I am struggling, though, on 1502 to see why this would be a tremendous burden. I mean, practicing in the area myself, I mean, obviously, if I think I've got any factors that are going to help my client, you're darn right, I'm going to be bringing them up to the state's attorney and or the judge in a supervised pretrial. But you know, I guess having it be a requirement, for lack of a better word, of prosecutors saying to a defense attorney or a pro se, if it happens to be that way, are there any factors we ought to be considering? I mean, I guess I don't see that as being as great of a burden. And I certainly understand that there are far more cases than you have people to adequately handle them.
And in regards to the staffing issues, I mean, you know, I know that's for another committee here, but the reality is we accept that. Okay, you know, we know that, and I can tell you I personally have some of the most hardworking prosecutors in the state. You know, I just think about the fact that yesterday afternoon, while the St. Patrick's Day parades go on in New Haven, 3 of us were in the office working on behalf of the people. But I would tell you in regards to 1502, I think the greater concern for us are those factors in regards to sentence modifications, as opposed to what Senator Gadker-Wilcox talked about doing it in the first part. I'm more concerned about the sentence modification part. And I know that we're very concerned about the part where it appears to say that if you have been a victim of these matters and you can establish it at sentencing, that there's a whole entirely different sentencing structure for individuals in that position. You folks appoint the Superior Court judges, and I think that's really difficult to say to them, you have discretion, but in certain situations, you're not going to have discretion. So you have discretion, but in certain situations, you have to go there. But that's for this body to determine.
Okay.
Thank you.
Thank you, and appreciate you being here and your insight on this.
Thanks.
Senator Chagall.
Thank you. And thank you, Attorney Doyle, for coming here and testifying. Just a couple of questions for you. And I know that you're in New Haven, which is pretty busy court. So if you can't speak to the whole state, then we could just maybe stay in the New Haven area. About how many cases would you say end in a plea deal instead of going all the way through trial? Is there a percentage?
A percentage wise, I would have to say over 90%. I think it is well known, at least in the 27 years that I've been in New Haven, for the most part, most of the cases that go to trial are murder or homicide offenses, and then some child sexual assault cases. Okay, you know, judges are also known. We're just known in general the fact that those are the cases that are most seriously most going to go to trial, because the pros and cons are both difficult for the defendant and for the victims and the people responsible. Occasionally, you know, there are some robberies or some shootings that go as well, but for the most part, it's those types of offenses that go to trial.
Got it. So approximately 90%. And out of that 90%, I would say a majority of those are going to be getting a lesser charge in order to take that plea deal. What would be the incentive for them to take a plea deal? Is it a lesser charge?
Yeah, for the most part, yeah, a lesser charge, or you could have multiple, you could have, let's say, an incident with multiple charges. You could also have multiple incidents or multiple files. And then somewhere along the way, a prosecutor and a criminal defense attorney, perhaps with a judge, will work out a situation of certain incidents or certain charges within certain files. I mean, the general concept of the idea is for all the parties involved, be it the state, the defendant, the victims, the witnesses, to try to come up with an agreement as opposed to going to a full trial and requiring the state to prove charges beyond a reasonable doubt.
Got it. And that would go to kind of the experience I had. Done criminal defense investigation work, done assigned counsel work, helped the special public defender's office. So I kind of seen it firsthand, and I see a lot of individuals take a plea deal for whatever reason, right? They don't want to run that risk of the full charge, which normally is obviously higher than the plea deal offer. So I think I'm just trying to understand in that 90%, they are getting a reduced charge essentially, or consolidating the charges. So their exposure to their full sentence is much less. That's why they would take the plea deal. Fair assessment?
As a general proposition, yes.
Okay. And when individuals are able to apply for a sentence modification, can they do it when they accept the plea deal?
Can they apply for a sentence modification when they accept a plea deal?
Yes.
If the currently is right now, if the sentence is less than 7 years, they can't apply for a sentence modification. As indicated earlier, for example, we have an individual who was just convicted after a jury trial in August, received a sentence of less than 7 years. He's already applied for a sentence mod. He's not even a year into the sentence.
Got it. And I did look at the letter from the judicial branch, and I saw those numbers when there was a change in the general statute around 2020, I believe. You see the large jump in numbers of individuals applying for a sentence modification. And as you said, from 2015, it was 216 individuals, and now in 2024, it's 733. So you could see that they drastically increased, and obviously there's hearings, and everybody has to prepare for that. So it is obviously a burden on your time, and you guys are extremely busy. So I understand that. And I think that was said when you guys were going back and forth with questions and answers. I guess the other question I'm trying to determine, seeing these large numbers, and if you could do it by the year, the month, out of the 733 in 2024, any idea the percentage of individuals that were approved for a modification for a reduced sentence?
I can't speak for the entire state. I can give you an estimate, or I would say more of a guesstimate just for the New Haven Judicial District,
Okay.
because just between staffing and things, I've handled the greater majority of the sentence modifications in the New Haven Judicial, at least in Part A. I would say it's probably a 60-40 split in favor of most being denied, but some being granted. But I also want to just preface that is that we're also talking about some cases where they've been granted would generally be somebody who's significantly through a significant sentence. But where they've been denied, where I've noticed if there's a pattern, and every case is unique and everything's different, is the situation where somebody hasn't served even halfway of their sentence that they was given by a Superior Court judge, and they're trying to modify that particular sentence.
Got it. So
That being said, different factors, victim input, criminal history, all those things are going to be taken into account.
Got it. So just for clarification, so the individuals who have not served at least 50% of the sentence that they were either accepted in a plea or were given when the case was fully adjudicated, if it was under 50%, majority of those were not being granted. But if it's over 50%, that number becomes greater in favor of the sentence reduction being granted. Is that a fair assessment?
Or modified to some extent. I would say as a general proposition, there's been, if you were to do some, and I could forward it to this committee, there's at least 7 or 8 appellate court decisions addressing sentence modifications since these statutes changed. And most of them were appeals by defendants who were denied a sentence modification by a judge and attempted to appeal that up to a Supreme Court, the appellate court. And what had happened in most of those decisions, and at least 5 of them out of New Haven, where the appellate court said, weighing those factors there, the court looked at the seriousness of the offense, the effect on the victims, deterrent effect, and determined that the rehabilitative aspects of what an individual had done thus far, those that did not outweigh the deterrent effect or the effect upon the victim. So there are And those, and I also noticed in those that there were usually situations where a defendant had not done at least, 50% of the sentence.
Excellent. Thank you for answering those questions. Just my last question is, when this legislation, Public Act 102 passed, we see it approximately double, in certain cases, certain years, triple the amount of applications. Would you be able, with your professional experience, to give us an estimation of how many more we would see when we're reducing the amount of time before applying for this modification?
I guess the best way is, I think, I don't have the exact number, but I do know that I have at least 450 Part A matters pending in the New Haven Judicial District. Okay, so those are, if we just assume for a moment that some of them involve a period of incarceration, and bear in mind, these are homicides, robberies, sex assaults, home invasions, some with people with no record, some people with significant histories. But if we assume that, say, 300 of those involved a period of incarceration at some point, then I'm going to have to take 2024 and then 2025 and then some point in 2027, add that number together and expect that I'm going to get that number of sentence modifications. And that's quite a bit. Now, I would also point out that at that point, I have to reach out and make contact under our Constitution with all the victims in those cases. And what I'm concerned of, just as similar as what I happened to be about 2 weeks ago, I'm in the middle of doing 3 online sentence modification hearings. And I have the family of a homicide victim happen to be at my door, just dropped in, no doubt about it, but wanted to speak with me. And I was stuck on those particular hearings, something I couldn't break away from. So I'm concerned, and I know I know the state's attorneys are concerned about being able to deal with the investigation and the prosecution of our regular cases that are in the trial courts, and then having to handle a sentence mod document that could be twice as large as our regular pending cases. It's also about I'm not going to sit and tell this board that there isn't, this committee, by the way, there aren't some cases that don't deserve sentence modifications. There aren't some cases that don't deserve a hearing. But I dread having to go tell the family of a serious crime, when I told them a couple weeks ago, when somebody pled guilty or disposed in his case, that there could be a sentence mod in 5 years, there could be a variety of other hearings, and now I have to call him back and tell them, by the way, he's in custody, this individual's sentenced now to 30 years. I'm going to have to call you every 2 years for the next year unless this sentence is reduced, or if something else happens. And that is a great concern, and that should be a concern for victim advocates and victim groups as well.
Sure. And that's definitely a concern. But even a greater concern is, and that's why I've done the public defender work and did the criminal defense work. There's nothing worse than being accused of something you didn't do. And I think it's an important process. But with the manpower, you're going to have cases where individuals are incarcerated waiting for their trial. And we're going to end up seeing possibly them staying incarcerated longer because there's only so much manpower. Are you going to have to just do 1 and 1, right? One pending case that it hasn't been adjudicated yet, and then do one of these? So I'm just wondering, what the effect it would be on individuals that are awaiting trial that are currently incarcerated. Again, there's only a certain amount of time in the day. And how would you be able to balance that?
I'll be honest with you, until you mentioned that wasn't even a concern that I thought of. Not that it's not important, but in weighing the pretrial regular cases that are pending, giving less attention to the victims in those matter. Obviously, of what should be an equal concern is the fact that somebody might have a case pending. There may be issues with that case. They could be falsely accused. It could be a wrongful arrest, or they could just be plain weaknesses with the case. Witnesses may not be credible. Evidence may not be credible. And what I can tell you, it is our duty under our own, not only statutory and constitutionally, our own policies to follow through those, but that would affect the added burden of this number of sentence mods this often would affect that as well. And but I would indicate, as I came in here looking at these 2 different statutes and proposals, by the way, and concerned about victims, I am very concerned about having to call some victims and say that now you're going to have to come in every 2 years. So,
Excellent. Thank you for taking the time to testify, and thank you for answering my questions. Thank you to the good chair.
Thank you, Attorney Doyle, for being here today. You've been there a long time, so I won't try to prolong this forever, although others will. I heard you say several times what the impact on the public defenders would be, but what you say seems to go against their own testimony. So why do you have a different opinion about the impact than they do as it relates to them? They even say in their testimony that they don't think there'll be a rush to the courthouse door. So I just for clarity, because it seems to be a problem in terms of what you testify to and what they suggest.
So I guess there's a couple things that I'll point out in that regard. In my experience, most of the sentence modifications that are applied for, okay, people are represented by attorneys that are not public defenders. They're not always working in the public defender's office. Two, I also noticed that there's a lot of attorneys that handle sentence mods and post-conviction things are not the same attorneys that are how do I say this, have a regular practice of coming into the regular GA or the trial courts and handling those matters. Okay? And then lastly, I didn't want to say this today, but now that you've asked the question, I will point out what two of the prosecutors that I'm responsible for in both New Haven and Meriden have pointed out to me. And I mean, I just want to clear, this is not the chief state's attorney or my agency speaking. This is an observation and me repeating to you, Senator, what prosecutors have said to me, which is in the New Haven GA, the question I get asked by young prosecutors is, why are there 10 of us in the New Haven GA, but 20 public defender attorneys across the hall? And I get the same questions that's asked by prosecutors in the Meriden State's Attorney's Office. Why are there twice as many public defender attorneys than there are RRs across the hall? Now, also indicate, I know you're aware there's a lot of statutory and responsibilities that we have that are outside of the courtroom and outside of the plea bargaining process, including reviewing matters and looking for inculpatory and exculpatory materials. But I just, it's a, part of it is a burden that's just going to be solely on us, but I also do think it increased their burden somewhat. I just can't explain how they allocate it.
I'm unclear as to what, I hope I'm not being obtuse, but I'm unclear as to what the answer to my question was. You talked about impacts that don't seem to be on the public defenders. In fact, you said that many of the attorneys who deal with this aren't public defenders, and yet you testified here in response to several legislators about the impact on the public defenders. And so then my question becomes, how are you testifying to that when they are testifying in opposition to what you said? Your response to, maybe you don't have an answer. I'm not looking for anything in particular. It just seems a little bit odd that your responses were what they were earlier.
I would then, Senator, I don't know what effect that it would have upon them. Personally, I don't know what effect it would have on their workload. Maybe it's workload that they can handle. All I would tell you is this, is that if you put this workload on prosecutors, we're going to step up to the plate and we're going to handle it and we're going to do it. But in the meantime, what I just wanted to point out is all the other things that we have to deal with on a regular basis. Well, my biggest concern, my most serious concern, is on the effect on victims and having to call those victims on a regular basis every 2 years. That's my concern.
And I understand that. And I take your representations for the prosecutors as what it is. Representative Fishbond for the second time.
Thank you, Mr. Chairman. Yeah, I mean, I understand because there's a finite amount of prosecutors as well as public defenders. And you got cases, I mean, it's not like the door ever shuts down, right? Every day weekday you wake up, you go to court and there's another pile of cases. And this process, by increasing it, diminishes the ability to deal with those newer cases. And I certainly appreciate that. I just wanted to get into the weeds a little bit on the language. I'm running into this term, reliable hearsay evidence, and that's, many times I see that on a probable cause standard, right? But here we're allowing a court, a reviewing court essentially, to rely upon reliable hearsay evidence, which I don't see defined. Is that a problem? Is that something that is workable within the system?
I had this conversation with several prosecutors in the meeting because I don't know what I don't know how you define reliable hearsay. I mean, for those of attorneys, we know what hearsay is: an out of court statement attempted to be made in a court hearing for the, in order to prove the truth of that matter that's asserted. So courts already do that at sentencing hearings. Okay, well, you know, if somebody comes in and is addressing the court, whether it's on behalf of the defendant or behalf of the victim, something in the defendant's background or something that happened with the victim, or if we're referring to documents or medical reports or letters that are written in. So there is some level of hearsay here, and the court would need to balance that. But if I read this correctly, this is an effort to try to explain that there may be a variety of things from the past that somebody might look to bring in on behalf of a defendant, and that the court can accept reliable hearsay. But I'm not exactly, and there's some examples there, I guess, of prior medical records, statements, affidavits. But I would indicate, I do think that's something that probably should be defined a little better,
Well,
because I'm not sure what it is.
looking at both sides of this, also, the reliable hearsay could be used to refute
True.
the claim as well,
Yes.
right? So, you know, those looking to push that language could be disappointed with the result. The way I read this procedure, and I think you recognize this, it takes away a judge's discretion. Is that correct?
I think it is, as a prosecutor and attorney, I'm a little concerned about the part where it says that hypothetically, if a court was to determine that that the defendant was a victim of human trafficking, domestic abuse, or sexual abuse, that there's now you go to a whole new sentencing structure, that quite definitely is taking away, in my view, the discretion of a Superior Court judge. Because you're already expecting a Superior Court judge to exercise their discretion where they can in imposing and taking factors into account in sentencing, you know, deterrence, rehabilitation, incapacitation, or just plain, punishment. But if we step back now and say, well, these particular factors here, if you're found to have one of these factors, that there's a whole other sentencing structure scheme for you, that's problematic for me, or that's concerning for me. Because then you'll have other situations, well, how come that wasn't taken into account for myself? Or how come, and I think that's the great concern that prosecutors would have.
In your experience, you've been a prosecutor how many years?
It'll be 27 years this July.
And from time to time, you run across victims of child abuse
Yes.
that also commit heinous crimes. Is that fair to say?
Victims of, I have prosecuted victims of crimes. I have prosecuted defendants who themselves have been victims of crimes at times. Yes.
Sure.
In the past.
Victims of child abuse.
Child abuse, sexual abuse, kidnapping, trafficking, yes.
And under this legislation, those victims would not be protected. It's only victims of domestic violence. You get two similarly situated individuals. You have the child abuse is not domestic violence, it's a neighbor.
Yes. Okay.
Abuses a child physically. They're a victim of they're not a victim of domestic violence. They're not a victim of sexual assault, but they're a victim of child abuse. And then they go to perpetrate a murder. They are not protected under this language. You would agree?
That would appear so. So I think what you're indicating is that if you're accused of a crime now, and in the past you've been a victim of sexual abuse, that could be taken into account differently than if you're the victim of just child abuse.
Yes.
Which could be one and the same, but could also be entirely separate.
But the system as it presently exists, both of those defendants, criminal defendants, that information could be taken into consideration by the prosecutor as well as the judge in the course of sentencing. If this legislation was to pass, though, the victim of domestic violence would be given a leg up as opposed to the victim of child abuse.
In the sentencing part of it, yes. And as far as our discretion, we would take all of that into account. But as you pointed out, and I think I tried to indicate earlier, in the sentencing, it would have a totally different thing, because you'd have this different structure, which is taking away the discretion of a Superior Court judge, which is why you put them there in the first place.
And the victim of child abuse that perpetrated the heinous crime would not be able to avail themselves of this different
Sentencing structure, yes.
this legislation we create.
Yes.
So thank you. Thank you, Mr. Chairman.
Thank you. Comment or question from other members of the committee? Comments or question? If not, Attorney Doyle, thank you for joining us today.
Thank you, Senator Winfield. Thank you all.
Olivia Rinkus. Olivia Rinkus. Devon Ward. Devon Ward. Saw you earlier. Okay, we'll come back later. Betsy Cespedes. Betsy Cespedes. See you on there. Okay. Jess, oh, hold on. I see Devon Ward. Devon Ward. Okay, we'll come back. Jess Zanino. Are people able to get on? Because I see some of these names here. Okay. Clude Young. Clude Young. Okay. Dalia Romano.
Hi, yes, can you hear me?
Yes, we do.
Okay, all right, hold on one second, I'm just getting this up here. All right, good afternoon, Senator Winfield, Representative Staffstrom, and other members of the Judiciary Committee, and thank you for the opportunity to testify. My name is Dalia Romano. I'm a staff attorney at the Connecticut Fair Housing Center. We are a civil rights organization dedicated to ensuring that Connecticut residents have access to the housing of their choice, free from discrimination. And I am testifying in opposition to HB 7140, an act concerning Fair Rent Commission proceedings. The center has been heavily involved in the revival of fair rent commissions in Connecticut. Beginning in 2022, we co-developed a model ordinance, Fair Rent Commission Toolkit, and along with Connecticut Legal Services, we've provided training and technical assistance to dozens of fair rent commissions. We have also, over the past 2 years, represented approximately 53 tenants in front of 11 different commissions across the state. So we've sort of seen how a lot of different commissions operate. HB 7140, in our opinion, would impose an unnecessary burden of formality on fair rent commissions by requiring them to conform their procedures with the Uniform Administrative Procedure Act, the UAPA, which is intended to set out the procedural requirements for state agency boards, which have access to full-time professional staff and run really like quasi-judicial hearings. It is not The UAPA is not typically applied to municipal boards such as fair rent commissions, or as in another kind of more analogous example, like a planning and zoning commission is not subject to the UAPA. Fair rent commissions are made up of volunteers. They're not meant to be experts or professionals. Instead, they represent their community and are tasked with applying a relatively straightforward fairness and unconscionability standard. Most commissions are assigned only one paid town staff person, and outside of larger cities, it's usually only a part of their job to be working with the commission. So they really just have very limited capacity. And fair rent commissions are really already required to maintain fair and orderly hearings and to maintain their records. In my experience, they do this fairly well, and it doesn't make sense to put this extra burden on them to meet the same rigid procedural standards as a professionalized state agency. HB 7140, I believe, would make it needlessly difficult and potentially costly for towns to run fair rent commissions and put an unnecessary burden on these volunteer commissioners and town staff who already have very limited capacity. So for those reasons, we ask that the commission reject HB 7140. Thank you for your time.
Thank you. Comment or question from members of the committee? Comment or question, Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon. I'm just trying to figure out, is there a particular portion of 7140 that you oppose, or is it the whole idea of what the bill proposes?
I would say the whole idea, because 7140 essentially references the UAPA and says that that will be applied to Fair Rent Commission hearings. And so that whole concept is something that I would oppose.
Well, the UAPA is the appeal process, so the purpose of the language before us is to create a record and to let the towns and the Fair Rent Commissions know what they are required to have so that the Superior Court, if there's an appeal, can review that record. So I'm trying to figure out, do you have an objection to there being an official transcript of the proceeding?
I don't have an objection to that. I believe most commissions are already doing that. And so
Sorry.
go ahead. Sorry.
Where is that in statute presently?
I don't believe it's in the statute, but commissions are required to keep, public records, and they also the case law that exists on Fair Rent Commission appeals makes it fairly clear that the Fair Rent Commission needs to have a record of why decisions were made, what factors were considered, and how the commission reached that. So whether they have a formal transcript or just a recording or other record of what happened during the hearing, I have never encountered a commission that has no record at all.
Okay, I'm just trying, have you been involved in any of these appeals?
I have not been involved directly in an appeal.
Okay, because I'm looking at the statute as it presently exists. And it's 7148E. And it merely says that any person aggrieved by any order of the commission may appeal to the Superior Court for the jurisdiction in which the town, city, or borough is located. Any such appeal should be considered a privileged matter with respect to the order of trial. So that's all that it says presently. And I'm just trying to, I think I did ask you, you said it's somewhere in the rules or something about transcripts, notices, the things that are addressed in the legislations before us. Do you know where that is?
So I'm sorry, I'm not entirely sure I understand your question, but the current Fair Rent Commission statute doesn't get at requirements for transcripts. I'm just saying, sort of anecdotally from my experience with Fair Rent Commissions, they all have some sort of procedure to keep a record of the proceedings. And I believe Daryl Fennel, who testified earlier, spoke to what happens in appeals typically is that the court will look to that record of what happened in the Fair Rent Commission proceeding.
I'm aware of the process. Mr. Fennel talked about the transcript costs, and I think those are addressed in here, but thank you, Mr. Chairman.
Thank you, Representative. Comment, question from members of the committee. Comment, question from members of the committee. Seeing none. Thank you very much for joining us today, Ms. Romano.
Thank you.
I think this is a great time to remind folks periodically throughout the hearing so that folks know you get 3 minutes to testify. The 3 minutes will be indicated by the sound of a bell, I believe we have today. Sometimes you have a different sound. By the sound of a bell at the 3 minutes, if you are not finished, please wrap up. I will, if you keep going, indicate to you that it would be really great for you to wrap up. Please don't make me have to do that. We are doing really good today. I would also say to folks that if you have submitted testimony, we are in possession of that and can read it. So if you want to testify to the most salient points that will help you with the 3 minutes, it goes faster than you believe it does. Okay. And also, if you are skipped, I make an attempt to give you a moment to get on, and then we will move on. But at the end of the hearing, we will give you an opportunity to come back unless there was some particularly interesting issue with technology or something like that. Okay, so Leadon. Lori Leadon.
Hi, I'm right here. I'm
Excuse
just.
me. Oh, sorry.
That's okay.
We are on Lori Leadon. I did call you several times. Since you're there, do not go away.
Okay.
After I'm talking to you, Ms. Cespedes. We
I
will
am
call
ready if you're ready for me.
one second. Everybody let me finish.
Okay.
We will hear from Lori Leadon, followed by Ms. Cespedes.
Okay, sir. Thank you.
Okay, so this is my testimony supporting SB 1502, an act concerning sentence reduction or relief for survivors of domestic violence, sexual trafficking, stalking, or human trafficking. And good afternoon, Co-Chair Senator Winfield, Co-Chair Senator Salters, etc. My name is Lori Leadon, and I'm writing to express my support for Senate Bill 1502, a crucial act that would allow survivors of domestic violence, stalking, sexual assault, and/or trafficking who were incarcerated an opportunity for sentence modification, parole, or commutation hearings. I am an ACLU Connecticut Smart Justice leader, and I believe, as a survivor of domestic violence, that fearfully enduring the abuse caused the destructive behavior of addiction that resulted in my incarceration. I did not have the tools to deal with the trauma I experienced, which included verbal, physical, and sexual assault that was compounded with the fear of retaliation not only on myself, but also on my loved ones. And it kept me repeating the cycle of addiction and my desire to stay numb from it. SB 1502 will make Connecticut law more aligned with lived experiences of survivors like me by recognizing there are several reasons why a person's experiences of survivorship may be minimized or obscured within the criminal justice system, including high rates of post-traumatic stress disorder, PTSD, among survivors may mean that it takes a survivor months or even decades to recover from the trauma of the abuse and to communicate their stories effectively. I can identify with these lingering emotions, and it takes years. It took me a decade to navigate through this fire of emotions and feelings and triggers of such intense and horrifying memories. Only through support, understanding, compassion, and love can one slowly recover. And we need our community for this. These traumatic experiences must be considered when sentencing and when considering commutations. Connecticut law must continue to stay relevant and keep up with the evolving data to understand the ramifications of domestic violence, stalking, sexual assault, and trafficking. I urge the committee, please, to vote favorably, please, on SB 1052 for these reasons. I appreciate your time and consideration for this vital legislation. Thank you for your time. Lori L. Leadon.
Thank you. Comment or question for members of the committee? Comment or question for members of the committee? There are none. I want to thank you for coming today and testifying before us and sharing a little bit of your own story. Okay,
Thank you for taking the time for me, sir.
thank you. Betsy Cespedes.
Hi. Can I go there quick?
All right, you may testify.
Oh, good afternoon, esteemed members of the Judiciary Committee and all attendees. My name is Betsy Cespedes, and I'm here today as a peer advocate for justice and restoration. I am also a professional in social work field where I have witnessed firsthand the devastating effects of inadequate support, childhood trauma, abuse, and the systematic failure that often lead young people down to the path of incarceration. This issue is deeply personal to me. My brother was incarcerated at the age of 18 and has endured countless injustices while serving his sentence. Legal malpractice, denial of fair hearings, and an overall system that has failed to acknowledge his humanity and potential for rehabilitation. Like many others, he has been denied opportunity for commutation, sentence modification, and even a fair juvenile parole hearing. SB 1327 represents a necessary step towards justice. It acknowledges that people can grow, change, and deserve a chance to prove themselves. It creates a pathway for sentence reduction, regardless of mandatory minimums, and ensures that individuals are not indefinitely trapped by the past mistakes. Who are we to judge and allow personal and societal biases to dictate someone's future? At the very least, we must provide an opportunity for rehabilitation and reintegration into society. The current system disproportionately impacts community of color, low-income individuals, and those who lack adequate support from an early age. If we truly believe in justice, then we must also believe in redemption. We should be investing in opportunities, for transformation, not turning a blind eye to injustice. At the very least, we owe our incarcerated community members, brothers and sisters, a fair chance to prove themselves, return home, and continue positively to society. Positively to society. I urge this committee to pass SB 1327 and to take steps towards a system that is fair, just, and recognizes humanity of those who are incarcerated. Our brothers and sisters behind bars deserve an opportunity to rebuild their lives. Thank you for your time and consideration. God bless.
Thank you, Ms. Cespedes.
You're
Comment or
welcome, sir.
question? Comment or question from members of the committee? Comment or question? Seeing none, thank you very much for joining us this afternoon, taking some of your time to provide us with your testimony. We appreciate it.
You're very welcome.
Ian Wright.
Yes, hello?
Yes, you may testify.
Okay, thank you. I'm testifying for the Connecticut second lip. Also for my namesake, my father's name is Nicholas Wright Sr. Many people, brothers and sisters, are incarcerated nowadays. I just think it's vital, that the judicial system, takes a second look, as said in the statute, right? To take a second look at it, because there are many able-bodied and minded individuals that are incarcerated right now that could be potentially generating revenue for our society, potentially being rehabilitated and have been potentially been rehabilitated, but because of certain laws and old ways of this judicial system, they're probably still sitting in jail and things of that sort. I just think it's very vital for this law to be passed, so we can just rehabilitate. If not to rehabilitate men and women, then what is the point of this judicial system at all? What is the point of this whole process? It's just very vital that we pass this law to potentially create generational wealth and to potentially build our society. My father was incarcerated since I was the age of 4 years old, and when you were a young man and when your father is incarcerated, it leads to emotional and psychological distress, and that's just that's scientifically based, excuse me. So and many variables to that which can lead to crime, a life of crime on your own. I just potentially averted that through my own knowledge and personal knowledge and things of that sort, but it can be easily transferred of your father or mother going to prison and then you yourself going to prison. It can easily be a cycle and things of that. So I just think it's very vital that we rehabilitate our men and women of this state and push them forward to become cornerstones and pieces of the society, like they should be. Rehabilitation is something that is very vital. Jail's purpose is to rehabilitate, not to hold individuals for their whole lives. And in closing, I just want to say I appreciate you all taking the time to listen, and God bless you.
Thank you. And our appreciation of you testifying is the same. Comment or question from members of the committee? Comment or question? If not, thank you very much for taking some of your afternoon to be here with us and provide us with your testimony.
Appreciate you as well, my brother. God bless.
Mary Concepcion Pacheco.
Hello, yes.
Yes, you may
Good
testify.
afternoon. Thank you so much. Good afternoon. My name is Mary Concepcion Pacheco. I am advocating on behalf of my partner who's incarcerated in Connecticut. I'm also an arts administrator working with incarcerated folks throughout the country under a nonprofit called Apogee Journal. We've recently launched a publication specifically and exclusively working with incarcerated artists and writers. So I am here to testify on behalf of SB 1327, speaking as someone who's worked for almost the past decade in arts administration, supporting folks who are currently incarcerated, as well as recently released, and have been witness to the entire process of reentry as well as supporting people who are currently trying to return to their communities and prove that they have been rehabilitated through the U.S. prison system. I believe that SB 1327 is a really, really pivotal and crucial bill, aiding in bringing, as the other folks that have testified in support of it have said, in making that ability for folks to really truly be able to demonstrate rehabilitation and, in their own words, be able to make a case for themselves and for their capacity and ability to change while incarcerated. I believe that changing the window from every 5 years, getting the opportunity to get a sentence modification to every 2 allows folks to, again, be able to articulate for themselves and within their own ability to like find their pathway towards justice and freedom, whatever their case may be, to be able to do that in a way that does not unjustly lengthen their time in prison. And I believe that this bill is really, really crucial at this point in time in Connecticut's history, where we've seen, due to the changes in 2021, what it actually means to really take a look at sentence modification, at commutation, and all of these different avenues for folks to be able to modify their sentences post-conviction, can really have an immense impact on folks returning to their communities, and essentially bringing a lot of themselves and the resources that they have gained, including like their own. As I said, I've worked in arts, and I believe that as someone who studied liberal arts and now works making space for other folks who have been like underserved in their arts education, I think it's an amazing place to have seen these things in action every day. And I think this bill would allow folks the opportunity to share some of that work and to really make the case for their freedom.
Great. Thank you very much. Are there questions or comments from members of the committee? Are there questions or comments from members of the committee? There are none. I want to thank you very much for taking the time to join us here today and provide us with your testimony. Rafi Podolsky. Make sure you turn the mic back on. Thanks for joining us again.
Mr. Chairman, members of the committee, thank you very much. My name is Rafael Podolsky. I'm a lawyer with Connecticut Legal Services. I'm here on behalf of all the legal aid programs in Connecticut. I'm here to speak against House Bill number 7140, which is a bill that deals with fair rent commissions. Let me try and be brief and also say something about in response to some of the questions that were asked earlier. The UAPA does not apply to municipal boards. And there's a reason for that, because municipal boards tend to be made up not of professionals, but of people who live in the community. Fair rent commissions are a good example of that, because there's an overlay with fair rent commissions. It's really a board of equity. And so the notion of the lay people being on the board is kind of baked into the fair rent commission concept. The bill itself, there are 3 reasons I feel strongly against it. One is that it's simply unnecessary. It addresses, there is no problem that it needs to fix. The second is that it's really confusing to lay commissioners. even looking at the bill and looking at some of the words in it, pleadings, motions, intermediate rulings, offers of proof, objections, exceptions, you don't see these in Fair Rent Commission hearings. It really doesn't have anything to do with that. And then what it really does is it signals to Fair Rent Commissions that we want you to be much more formal than you are. And that is going to have negative consequences, both for the litigants, landlords, and tenants, both for the commissioners. It's going to make it harder for towns to find people to be willing to be commissioners. Given that there's not a problem, there's no reason to do this. The questions were raised about, well, it was said, well, this is only about appeals. No, it's not. The bill is about contested cases using the UAPA rules. The contested cases include the conduct of the hearing itself. In regard to appeals from Fair Rent Commission decisions, they are governed by the practice book. The practice book has rules. There's certain documents you're going to have in order to take an appeal, and on either side, and the respondent has obligations under the practice book. That's taken care of. So the fact that the statute doesn't itemize it is beside the point. And as I said, this bill covers the conduct of the hearing itself as well as the appeal. There was a question raised as to how, as to the court on appeal. The court on appeal is the Superior Court. You'd have to take an additional appeal to go to the appellate court. About the burden of a trial de novo. These are administrative appeals. There's no trial de novo. The case law is very, very clear that the appellate court, the Superior Court on appeal, will approve a decision of the commission if it follows the law and there's substantial evidence in the record that supports the decision. It's not what the judge would have decided if he was a member of the commission. It's whether, was this the range under which a rational commission could have come to a conclusion. For all of those reasons, I would ask the committee to take no further action on the bill.
Thank you, Attorney Podolsky. Question, conversation, question, comment from members of the committee. Question, comment, Senator Gankar Wilcox.
Thank you. Thank you for being here, Attorney Podolsky. Just a quick question for you. You said there's no need for this because there are protections kind of baked into the process. Can you just say a little bit more about, what that process looked like and what sort of baked in there that's already provided?
Yeah,
those
I
big
mean, a
protections?
couple of us have actually taken on the role of doing training for commissions. As a result of the 2022 statute, a whole bunch of new commissions had to be created, and we've worked with a lot of them. Basically, what's going to happen in a Fair Rent Commission hearing is the tenant's going to be asked why they think there's a rent, why they think the rent is harsh and unconscionable. And they're going to be given an opportunity to answer that question. The landlord's going to be given an opportunity to say why they don't agree with that. People can call witnesses if they want. Typically, most of the time they don't. Tenants usually don't have an attorney. Landlords, maybe it's about 50-50 now on whether the landlords have an attorney. There are a lot of people there without attorneys. Commissioners will have the opportunity to ask questions. Basically, it's an information gathering. Then the commission will, at some point, you end the hearing, and the commission will have its own discussion and make its decision. Those discussions by the commission are open. People can stay and listen. That's the basic structure. Prior to getting to the hearing stage, typically there's a lot of conciliation efforts, and a lot of Fair Rent Commission complaints never get to the hearing stage because the parties work it out. It's one of the beauties about the commission is that it provides what amounts to third-party intervention, the same way, similar to the way you get mediation in the housing court.
And there's some record kept of that, for those who
Yeah,
have.
yeah. These are municipal agencies, so they're bound by the Freedom of Information Act to keep records. So that's why I say to some extent, this is redundant. But then the question is, well, if it's redundant, why don't we put it in? Well, you don't want to put it in because it's not needed, and the putting it in will itself create problems. But it's not. That's the sense of being a solution in search of a problem. It's really. There is no problem, to my knowledge, at least, there's no problem that needs to be fixed. And the commissions themselves are learning how to do this. As the new commissions sometimes stumble a bit, like in their first case. But as they get more cases, they work it out.
And just two things. So you said then that burden will fall on municipalities then to fill in the gaps if it becomes too formal and people aren't willing to volunteer.
I mean, it's been a problem in some of this, in even some of the medium-sized towns to make sure that, to find the people. You're not really volunteers. You have to be appointed. It's not like you can just say, I want to be on the commission. But these are unpaid residents of the municipality.
And as far as you know, there haven't been sort of longstanding complaints about the process, which would give rise to legislation that directs it.
Historically, there had been virtually no complaints. The burst of new commissions, with new commissions sort of working their way through, I think has generated some complaints which are being addressed. So the burst, that literally the 2022 statute doubled the number of commissions. And so there've been some bumps. I wouldn't say there are no bumps, but I think those bumps are being taken care of.
Thank you.
Thank you, Senator. Representative Godfrey.
Thank you, Mr. Chairman. I appreciate it. My first political appointment when I got out of the Navy back in 1973 was to Danbury's Fair Rent Commission. We had one even way back then. I just want to confirm Attorney Podolsky's comments. They were informal. Their commission included realtors who knew the market. They included bankers who knew the market. They included people like me who at that time, it was my first political activity, and it was very informal. What I found was that both the renter and the landlord would usually come in without an attorney. Sometimes they did, sometimes it was legal aid, to argue the particular case. And it was pretty informal. We didn't want to scare the renters. We didn't want to scare the landlords either. We didn't want them to necessarily spend a lot of money on attorney's fees when it was usually just a matter of working things out. And Attorney Podolsky is absolutely right. The working out was more common than actually getting to a final decision. It was usually bringing information attention to both the landlord and to the renter, what was going on. And frankly, it worked very, very well. So I have to agree with Mr. Podolsky very, very much that it's kind of an overreach. I understand that due to our General Assembly action extending the requirement for creating a requirement for fair rent commissions. Back in the day, it was a municipal option, changed things. And that you're absolutely right. There are municipalities who are now dealing with the processes and the creation and the adjudication that happens they have not had to deal with before. I would give them more time to work this out locally, but certainly this should be kept out of the hands of attorneys like myself and more in the hands of the members of the commission who are appointed usually by a mayor or first selectman and confirmed by the local legislative body. And it would just, I think, work better, work fairer, and get everything on the table and provide an opportunity to work out the details rather than go into a confrontational kind of case that winds up going to court. So I hardly endorse Mr. Podolsky's remarks. He's right. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comments or question from other members of the committee? If not, Attorney Podolsky, thank you again for joining us.
Thank you very much.
Are happy to have you here. All right. Wildelise Bermudez.
Good afternoon.
Good afternoon. You may testify.
Thank you. Honorable members of the Judiciary Committee, my name is Wildelise Bermudez. I'm the Executive Director of the City of New Haven Fair Rent Commission. And today I'm here to urge you to vote no to HB 7140, an act concerning Fair Rent Commission proceedings. This bill would require Fair Rent Commissions to follow the same procedural requirement as state agencies. My opposition to HB 7140 is grounded on the fact that Fair Rent Commissions are not state agencies. They are municipal bodies made up of residents. Of the current 52 municipalities who have registered Fair Rent Commissions in Connecticut today, only 2 exclusively have staff that is assigned exclusively to support the Fair Rent Commission. The majority of the Fair Rent Commissions throughout the state of Connecticut do not have full-time designated staff that are solely working on Fair Rent Commission cases. We at the City of New Haven are the exception. Since the passage of the state bill 3 years ago that allowed for the development of more Fair Rent Commissions, the majority of Fair Rent Commissions that exist today rely on volunteers from their municipalities who are appointed by their mayors and their city council or board of alders to serve as commissioners. These are lay people who serve. HB 7140 calls for the over-formalization of Fair Rent Commissions, which would hinder functionality and make recruitment difficult. Courts have recognized that Fair Rent Commissions are not held to the same standards as state agencies. Beyond that, municipal administrative agencies are not under the state agencies. If boards and commissions in Connecticut were to follow provisions of Chapter 54 of the Administrative Procedures Act, it would severely burden Fair Rent Commissions. Furthermore, there are no plans to provide funding to municipalities who have Fair Rent Commissions. Yet, this proposal is asking Fair Rent Commissions, who are mostly made up of volunteers, to do more, making the process impossibly burdensome and very costly to municipalities. The current system of doing things for Fair Rent Commissions works. There is due process involved. If parties wish to appeal a Fair Rent Commission ruling, they can. And generally speaking, appeals rarely occur. In conclusion, I urge the esteemed members of the Judiciary Committee not to support HB 7140. Thank you.
Thank you. Comment, question from members of the committee? Comment or question? If not, Ms. Bermudez, thank you for joining us here today.
Thank you very much.
All right, we have Cindy Prizio. Cindy, don't forget your mic. Your mic needs to be turned back on too.
Good afternoon. First, I want to acknowledge our chair, Senator Winfield, and Representative Staffstrom, ranking member, Senator Kissel, and Representative Fishbein, and all esteemed members of the Judiciary Committee. My name is Cindy Prizio. I represent One Standard of Justice as the chief cook and bottle wash. We are a nonprofit civil rights organization that work with families and their loved ones who were. I can push you close. Thanks, hon. Oh, okay. Wait, there. Stop the clock.
No, I'm just having to.
Who were, the organization represents families and their loved ones who were convicted rightfully and wrongfully or accused of a crime of a sexual nature. I'm here today in strong support of SB 1500, an act concerning verification of sexual offense registrants' addresses. We want to decriminalize the paperwork so that individuals on the registry must verify their residential address every 3 months by signing and returning a letter sent by the Department of Emergency Services and Public Protection. Current law in Connecticut dictates that if the letter is 1 day late, it is an automatic Class D felony. As a strict liability law, the homeless are automatically guilty. So this bill will give relief to a lot of people and keep non-criminal behavior certainly out of our courtrooms. And it is cost savings. And I want to demonstrate this by telling you a story. Somebody who became a friend of mine approximately 1 year ago, He's in his 60s, and Irvin Villa, a resident of West Haven, was arrested right after dinner with his wife, who only speaks Spanish, not understanding what was going on. He was handcuffed, taken out. He had the money. He bonded out. Irvin's a good man. He offended in 1986. He's been with the same employer since 1995. He's self-employed. He's lived in West Haven in one of two houses as a homeowner since 2009. And we checked with the Middletown, the registry, and we asked, in his 22 years of registration, how many times was this man late? Answer, once. During COVID, he may have been 1 day late. And that's what resulted in the conviction. So what happens is, if you were to visit Irvin Villa on the website, it would say he was compliant, because this happened 18 months earlier, right? And so what we find are people are getting arrested sometimes 4 or 5 years after their alleged time. So let me just cut to the chase and tell you, I went to court with Irvin Villa. We wrote an affidavit.
Cindy,
Please let me do the
Cindy,
punchline, Gary.
you of all people know how this works. So we're not going to do that, because then I have to do it for everybody. It's not about you. It's not. We've talked about this. So let's go to the comments and the questions, and maybe you'll be able to get out
Ask
what
me
you
so
want.
I can tell you the punchline.
Hold on, Cindy. We talk about this. All right. Comment, question for members of the committee. Comment, question for members of the committee. Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon, Cindy.
Hi, Craig.
In Irving's situation, how long had he not recorded his address? He was 1 day late, or I'm just trying to get the whole timeline there.
So what happens is,
No, what happened in his case?
no, in his case,
Yeah.
his wife sends the mail out registered, and 10 days is from the initial postmark, right? And so he may have been 1 or 2 days late. He didn't, and normally what would happen is you'd get a violation letter, but they never got one. And so he didn't even know he wasn't in compliance.
Okay, so just trying to figure out what triggered the letter. Was it because he moved, or because it's a periodic filing?
Because he didn't meet the 10-day period, the date.
Okay, I'm just trying to figure out.
So if it was, this was in July, I think, July 22nd, and it was due August 2nd. I mean, I think that maybe it showed up August 3rd or 4th.
So is that because he's required to periodically file this? Is that the reason?
Every 3 months.
Okay, let's just move forward from there. So in that situation, so he files, lets the government know where he is. 3 months pass, and then what is the window to send in that notice?
I think the way it works is that when you miss the 10 days, it automatically sends out the letter, the violation letter. From our own lived experience with my loved one, I can say that's how it works.
Okay, so I'm just trying, when does the 10-day period start to run? Is it 3 months?
It starts to run on the day you receive the letter. So there's been a very positive change in Middletown. The letter, the inside of the letter date now is identical to the postmark. That was very smart on their part, because it was very confusing before.
Okay, so I just wanted, yeah, sure.
Okay, so I'm only interrupting because I think part of what Representative Fishbone is getting at is getting lost. So I'm going to ask you to not be in your experience and to listen to the question he's asking, because I'm not sure you're always I'm not sure you're always responding to that. And I think it's important to the committee understanding. So the question about from where does the time run, right? And then you started talking about the envelope and the positive change. I don't think anybody even really follows you because they don't know this system. So let's stick to the point at which the time begins to run, because not everybody is up to speed on this subject like you are.
So let me just, I'm gonna bring it back to a scenario. So you last let the government know your address January 1st.
Yep.
Okay, 2025. April 1st comes, it's 3 months later, right? What were you required to do?
Usually within 3 to 5 days of your date, they send out a letter.
Okay, but
Sometimes it's after your date. I mean, it's erratic, quite frankly. And then you have 10 days from the postmark to return it.
okay, so they automatically send you a letter even if you did re-register?
Because you have to verify your address every 90 days.
Okay. So the process is that you fill out their form, you send it back to them. And then 90 days later, you get another form that you have to fill out and send back to them.
Mm-hmm.
And if perhaps that form gets lost in the mail, you don't have a form to send in to them.
Correct.
Okay. So let's just say that you don't do that. It gets lost in the mail. April 1 comes, I think you were saying they send you a reminder letter of some sort?
A violation letter will go out.
Okay. And in your experience, how long after that date does the violation letter go out?
Probably the 11th day.
Okay. So, and is that because it's a 10-day grace period like you were talking about before?
Well, I don't know if I'd call it a grace period, but you have 10 days. By the time you get it, with the current postal service, you may have 3 days left.
So what stops an individual who gets the letter they filled in January 1st from copying that letter? Is there some sort of, and using it for subsequent filings? Is there something that precludes that?
I'm sure that would be against statute. That the statute reads, they will mail you a letter every 90 days. You will sign it, verify your address, and return it.
So I guess the concern on the government side is if you're not living there, you're more than likely not going to get the mail, and therefore they don't know where you're living. But if they send it to you in the mail, then there's some sort of confirmation because you're sending it back to them. That seems like the logical circle here. Okay. Has the 90 days always been in place?
Yes. The statute's probably 25 years old.
I mean, and I'm just, it seems like something needs to be done here. And I don't necessarily want to negotiate in the room, but, I don't understand where 90 days comes from, just to be frank. I think 6 months is more like a thing, but, I don't know. I just want to ask you about specific language here. Well, I understand the context of your testimony. Reducing it to an infraction takes away the draconian.
Leaves intent, but takes away the automatic strict liability, which.
Well, but it's like you're going for the goalpost too, because not only adding the intent, but you're reducing it to an infraction, right? So, you could say if it's a minor thing, that's an infraction, but understood. All right. Thank you, Mr. Chairman. I got it.
Thank you, Representative. Senator Gaghan Wilcox.
Thank you so much, Mr. Chair. Actually, just following up, perhaps on Representative Fishbine's comments, I'm actually now thinking about that 90-day period as well. But we spoke before, Cindy, and my question, I was interested to understand why this is considered a strict liability crime. Because as far as I understand, I haven't been practicing law for many years, just teaching, but they're very limited. The other strict liability crimes are fairly limited in Connecticut, and they don't involve a circumstance where the sort of the circumstances are beyond your control, like whether or not a letter gets mailed is beyond the control, unlike selling a firearm, right, to someone who does or does not have a lawful right to own a firearm. That's a strict liability crime. So the other strict liability crimes seem to be on circumstances that are within the control of the person who's subjected to the strict liability. And so and I said this to you also, but I'm very curious to sort of understand the history of that, what you may not have that answer now, but I just wanted to put out there, why that was considered a strict liability crime. And whether that makes sense, considering you can't really control, none of us really, frankly, when the mail is there, and yet it triggers a strict liability felony offense. So I did have concerns about that, and I just wanted to raise that. We talked about it, so I don't know if you have answers now. I just wanted to note that again.
I've been thinking about like, why would this be strict liability? And from some of the earlier testimonies, possibly on 1327 and 1502, we have our own set of law books, quite frankly, and that's what we are fighting. We want to be treated like any other class of offense. And we're not, clearly. We're the other from the other. And we want proportionality in sentencing review. We don't want a premium punch. And that's when this happened. You have to remember the hysteria that, there was not enough protection for victims, or, we were in a different era. And so we've overcorrected. And I know that's what the academics and my world-renowned experts would say. And it's hard to get back to the center, quite frankly. And I think that law is draconian, and it's harming even our families if you have a loved one that's on the registry.
Thank you.
Thank you.
Thank you, Senator. Representative Howard, followed by Representative Dubitsky.
Hi, Cindy. How are you? So the law requires, and I'm looking at the final section here, 54-257, the 90 days. And my first question is, so this can be done by email, right?
You know that because it passed out of your committee, I think. That's the only change in that bill since its inception. But you have to understand the population. Some of them don't even have a flip phone, right? Some of them are totally prevented or denied access to the internet, and others are just plain scared. And so, for example, we have been educating people about emailing, and they're still doing it the old-fashioned way, or paying $15 for certified registered mail, and they're afraid. They are literally and I don't blame them. When my son was given a violation letter, I was here working in 2015, 2016, 2017, but you have such a visceral response to it. And so the emails, I worked with Middletown, and Sergeant Lindo has been fantastic. And she's set up an acknowledgement. So if we email, we now get a response saying back, or that's the way it should work, that says we've received your email, to try to allay some of the fear.
So what I'm driving at with this, because I read this carefully, and I think that we can, I'm with you that I don't like making people felons because they didn't keep up with some clerical things, right? I think we agree on that. We may disagree on some other things around the registry, but that part I think we agree on. And my concern, and there's no testimony here from, at least I don't see any, from the Chief State's Attorney's Office or DESP, but how do you establish if the person did something with intent, right? Because this goes to with intent. So if I'm on the registry and I know that the law requires that I answer an email every 90 days, and it's been 90 days and I haven't gotten anything or said anything back or called, how can we establish whether it was intentional or I don't know, negligent, accidental, whatever word you want to use? That's my sort of enforcement concern. How would you enforce that? How do you establish that? How do you envision that going?
Well, in Irvin's case, he lived in the same town and the same house since 2009. How other people are on probation and they get violated. I mean, how much surveillance does one person need? If somebody's been offense-free in our communities, I mean, quite frankly, I let me even throw that out. I feel that a late letter, we're not looking at other behavior. We're looking at a physical late letter being lost, stolen. How do I know it even left Middletown? We have no idea. There's not a camera attached to it. So from a late letter standpoint, no one should be violated. If somebody else is involved in something, we feel they will be detected.
But, okay, and I'm not even going to disagree with much of that. I guess my question is still this. If Irving, for example, lived in the same house all that time and the letter got mailed to him and he never sent anything back. Now, maybe it got lost in the mail. How do you establish whether it was intentional or not? How can you say, how can the state say, okay, he did this intentionally or not, especially if he's been living there all that time?
I think you have to look at it in a different way. Intent to me would not be that the letter went out a day late. It has nothing to do with the late letter. We've got to decriminalize that. But the intent would be, am I deceiving to act in another way? You know, I'm late with my letter because I'm off doing something else. But the vast majority of these people are living law-abiding lives. Irvin, 1986 was his conviction. You think a late letter should criminalize him and send him to prison? Or after a conviction 40 years old, put probation on him? That's what we do in this state. And then we put probation on top of probation if you're homeless.
So I get you're against a registry. I understand that, but that doesn't get to my question. So if I'm on the registry and I get a letter, a verification letter every 90 days from the state, and the letter comes in, I open the mailbox and I throw it in the garbage and I don't send anything in, right? That would be intentional. Can we agree on that?
That would be intentional, but I don't, I still don't think it's that. I think it's more nuanced than that. I don't know. I've been in this for 10 years. I know the people who've been arrested. I've gone to court with them. I've acted on their behalf. I don't know anyone who's taken a letter and thrown it out.
Okay, so I'm not going to ask it to you again, but I will say this to you because you're here every day. We talk often. I may be willing to support changes to this, and I mean that wholeheartedly. To your point, it was my committee that ran out the email change to assist people to avoid getting prosecuted. But I'm going to need an answer from somebody as to how the state of Connecticut is to determine whether or not it was intentional when we're talking about things in the mail. So I'm obviously not going to get it here, but I'm going to need that. So I'm just telling you that on the record.
We'll need to think about it and get back to you. And my legislative leader will be on with about 5 other people after me. I really wanted to tell you Irvin's story. And I asked and I told what we were all about, said, you want me to go soft on this guy? He goes, I'm prosecuting. And then we go back a month later and I go to we got lucky. We got a new prosecutor. And the prosecutor, I went up to him, I told him the same thing I said to the first one. And he said, I'm inclined not to prosecute. And these laws are too stringent, so good luck to you. And that meant a lot, but isn't that, why is it always up to the, anything we do, parole, commutations, it's up to the panel that's reviewing you. It's really, you get lucky or you don't get lucky and you try again.
Right. Thank you. Thank you, Mr. Chairman.
Thank you. Representative Dubitsky.
Thank you, Mr. Chairman, and thank you for coming in. You used the words strict liability. Now, I know in the civil context there's strict liability. There where they actually the statute actually uses that word or those words. Is that actually in the statute? It says strict liability.
Yes.
Okay, and strict liability typically means there's no defenses. So it doesn't matter if you have, if your conduct was entirely reasonable and innocent, you're guilty anyway. Is that what you understand is in this statute currently?
Hold on a second, because you aren't here to testify, at least at this moment. So hold on. You're being asked a question about your knowledge.
Okay.
If you do have knowledge, you speak to that. If you don't have knowledge, the simple answer is you don't have the knowledge.
I missed the question.
Hold on. And others who have the knowledge later can speak to that.
Yeah.
So you're not required to have a certain amount of knowledge. Some of us would like that, but you are not required to. The simple answer is I do not know.
I apologize. I was distracted and I didn't hear the question, but I'm thinking that my legislative leader would be a much better person to ask some of the technical policy questions.
Okay. Okay, fine. I'll wait. Hopefully I'll be able to talk to them about it then. Thank you. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Representative Fishbein.
Thank you, Mr. Chairman. Cindy, since you do know a lot about this, what's the requirement within that 90-day period if somebody moves? Is there presently a requirement to let the government know?
Yes. And when I got involved, it might be a little bit more liberal today, but black and white is you have 5 days and there's a process you do. And so that it creates another problem. And so when we say we want to decriminalize the paperwork, we're including the letter, the change of address, and the picture. The picture is taken every 5 years. So in a change of address, it goes in, but a lot of times it doesn't get recorded in a timely fashion. And even when it gets recorded, they're supposed to send another letter out. And I do feel there's clerical errors because a lot of the guys are getting arrested for, it's something else we have to fight, that the change of address is not being recorded in a timely way.
So if I move, I filed my notice with the government January 1. I move February 1. I call the government back and tell them I've moved and give them the new address so they can send me out a new form with that new address. Is that how that works?
Well, it used to be in writing. And so and it used to be that I literally went to Middletown with my statement saying I moved. The Middletown people in some ways have gotten very kind and more permissive, so that I don't know if they're taking that by the phone.
Okay, because I'm just trying to figure out if there's a process. So government doesn't know that you've moved, right? But we recognize that since one is required based upon your representations to let the government know about your new address within 5 days of moving, right? There's got to be some process to initiate that. So, okay, well, that's interesting. When the form comes, is the address already filled in?
Yes.
Okay. Now the homeless issue, presently, I looked at the language as it presently exists. It doesn't appear that a homeless individual is precluded from filing the document. I guess the issue is, how do they get the document?
Yes,
Right.
there's no physical address. So, again, things have changed over the years. So, with the rise in homelessness throughout the state, they've taken those Motel 8s and they've made them into, as an example, a room is per individual or family. And there are many, many facilities like that. You can't get mail there. And so, for example, I had a person who in a wheelchair, and they had this poor man with a case manager and a physical manager on the premises, but he was unable to get mail, and they had him listed as non-compliant. And I'm sorry, but I'm afraid for people on the registry. And he was off all over taking buses looking for a place to live that would accept him. And I didn't want him being shown as non-compliant. So that was something where we all got together and we worked it through. But these are only, and they allowed it, but these are the case manager was mailed the letter to her facility, totally different physical address, and then somebody drove it over to this gentleman. But I'm fearful, I only get a fraction of people that we help. This is happening across the street frequently, across the state frequently. So we don't want people accepting a felony when it's through no fault of their own. And shame on us if somebody in this room doesn't agree with that.
So the language that requires or permits this telephone submission says that not later than January 1, 2026, DESP shall establish. Have you had any discussions with DESP about their ability, whether or not that's doable or anything like that?
So here's what we do know. I don't think the phone calls would change. If you're homeless now, and you've been arrested or you're still under, maybe there's a warrant out for you, but you're still homeless. If you end up in court, the judge will tell you to call once a week, Middletown. And therefore, this person who is homeless thinks he's in compliance because he's calling the registry once a week, but he isn't. And that ends up with more people in prison or certainly in the courtroom.
Was anybody, because it seems a little, if a judge tells you to call every week and you call every week, you're telling me that somebody's gone to jail because they've called every week?
Yeah, because you don't have a physical address. And so right now, the homeless, the ones that are trying to stay in compliance, are calling once a week, but it doesn't protect them from an arrest. And then the other people, there's a lot of problems with the registry, right?
Okay,
With
so
letters not showing up, so I don't think the traffic will increase. We're asking for sort of the same level of service, only protection for the homeless.
Okay, and I'm just trying to look at what we're doing here today.
Yep.
So you're saying that DESP already has the ability to do this telephone submission, to take this in, right?
I call them on a regular basis, Rep.
Okay, my
Fishbein.
question was, the language says that they're going to start this January 1, 2026. My question was whether or not you've had any discussions with DESP with regard to their ability to do this. Based upon what you were telling me, I think maybe they already have the infrastructure to do this.
I don't see anything changing at all from what they're doing today. And I think that when David, the legislative leader, comes up, there's a few language tweaks we need to make. Like the original language of SB 1500 only protects the letter part of it, the receiving the letter.
Okay, well,
Our language will protect all three groups of people.
I'll have that discussion when David comes up.
Yep.
I'm just questioning if they already have the infrastructure in place, why we're waiting until 2026 to do this?
I think that just came out of LCO.
Okay.
I think we can.
And then can you just offline give me the name of this individual and or individuals that went to jail because they followed a judge's order and called every week?
He didn't go to jail. He was on probation for 3 years for a late letter. His house had burnt down. His family moved to Section 8. And of course, he can't live with his family. That would be breaking the rules, a person with a sexual conviction. And so what happened is he let the family live, and then he didn't have a physical address. He had a very good job, but he was homeless.
But a judge told him instead.
The judge said, keep calling. And then he got arrested for it, and he fought it. And so ultimately, they may have thrown that out. But he had been offense-free for 30 years, I think. And so he was part of that grandfathered group. And the probation was like, what are we going to do with you? What? Hi, how are you? What you up to? I mean, up until 2 years ago, my community was getting 3 years probation for that offense, for a violation of a late letter. This past year, the person I told you from Bridgeport was offered 45 days in prison or 3 years probation. He took the 3 years probation. Then he got violated or arrested again because he didn't have a physical address.
Understood. All right. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? Not. Thank you very much, Cindy, for joining us.
Thank you, Senator Winfield.
Okay, we have Nazgal Ganoush.
Hi, I'm here. Can you hear me?
Yes, we can.
Wonderful. Thank you. Good afternoon to the members and leaders of the committee. I'm Nazgal Ganoush, Director of Research at the Sentencing Project, a research and advocacy organization founded in 1986. I've been researching and writing about criminal legal issues for the past 15 years. It's my pleasure to offer my testimony in support of Senate Bill 1327, for which I've also submitted written testimony. This bill would expand the state sentence modification statute by addressing 2 excessive restrictions currently in place, requiring those who pled guilty and received a sentence exceeding 7 years to obtain prosecutorial approval for a sentence reduction, and excluding all mandatory minimum sentences from review. This bill would change that. Connecticut's existing sentencing law has helped to free individuals, including Gaylord Salters and Eddie DeLeon, who are exemplary models of the kind of justice that sentence modification laws are meant to produce. Both are testifying today. But as I have heard Mr. Salters and DeLeon note in the past, many other worthy candidates for resentencing remain left behind. One reason for that is the 2 restrictions in Connecticut's current law that I noted, requiring prosecutorial gatekeeping in many cases and excluding mandatory minimum sentences. Broad reforms to scale back extreme sentences have been successful from a public safety perspective. People given a second chance after serving lengthy sentences for the most serious crimes have extremely low recidivism rates. This fact indicates that they've been imprisoned for far too long. In fact, criminological research has also established that lengthy prison sentences fail in other ways to promote community safety, while contributing to racial disparities in incarceration. For example, long sentences have limited impact in deterring others from criminal activity. That's because many people do not expect to be apprehended, and in fact are not apprehended, or they're not familiar with the relevant legal penalties or have their judgment compromised by substance use or mental health problems. In fact, excessively long sentences are counterproductive for making our communities safer because they divert limited resources for more effective investments. Based on evidence like this, legal associations like the American Bar Association and the American Law Institute recommend expansive sentence modification laws. These organizations have also called for eliminating mandatory minimum sentences, as has the NAACP Legal Defense and Educational Fund. By allowing, under current law, that people from who have mandatory minimum sentences to be barred from resentencing opportunity and allowing prosecutors to gatekeep in many cases, the current law is prolonging an injustice without contributing to community safety. I encourage you to course correct and pass SB 1327.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you very much for joining us today. Next, we'll have Alexandra Bailey.
Good afternoon. Can you hear me okay? Hi, my name is Alexandra Bailey, and I am the chair of the board of the Foundation for Judicial Discretion, as well as the chair of the board for Drop LWOP New England. You heard previously this morning from my colleague, Dr. Bashani Ree. But I'm also here for two very specific reasons in support of Senate Bill 1502. The first is that I'm a survivor of domestic violence, as well as a survivor of childhood sexual assault. And I was the lead campaign strategist on the Survivor Justice Act that passed in Oklahoma, and am deeply familiar with incarcerated persons, specifically women, all across the country who have suffered and been criminalized, and in some cases sentenced to life without the possibility of parole for saving their own lives or their children's lives. In answer to a few of the questions that were asked before, there's a very specific reason that we chose the civil definition of domestic violence. And that is because one of the things that we know about domestic violence is that coercive control is a very serious part of it. And therefore, by using the civil definition, we were able to encapsulate that. So if somebody is trafficked, forced into crime, we need to have coercion as part of this statute. In research, we know that up to 75% of incarcerated women are survivors of domestic violence. Here in Connecticut, we know that 23.2% of women and 13.9% of men are going to experience domestic violence in their lifetime. I have been part of this law in a multitude of states, and it has been a nonpartisan issue. This bill has been endorsed by everybody from the Conservative Political Action Committee to the ACLU, various offices all across the country, because they see the rightness of this. And so I'll close my testimony by telling you who this law actually affects. I think of Lisa Moss, a woman who was sexually assaulted with a hot curling iron by her then husband. And it was also found that he was sexually assaulting their 5-year-old daughter. When we talk about things like reliable hearsay, it was her daughter, now a grown woman, after Lisa had served 34 years of incarceration on a life without the possibility of parole sentence, when she wasn't even there when her brother shot her then husband. 34 years, just think about that. She walked out of prison on this law, her daughter, now a grown woman, by her side, who testified in favor. This law is thoughtful and based on what we know about what works in the way that this law has been constituted and put into effect all across the country. And if you have any questions about that efficacy, I'm very happy to answer them. But I very much ask you to report favorably on Senate Bill 1502. Survivors need your help, and you have them here in Connecticut. We're not guessing.
Thank you, and thank you for sharing your story with us. Let me pick up on that last point a little bit. So, you've mentioned in other states you've worked on similar legislation, and it's passed with, you said, broad bipartisan support. What are, other than Oklahoma, what are some of the other states that have passed something similar to this?
So Illinois has a statute that is not as robust as what Oklahoma has. New York State has the legislation. It is currently pending in Massachusetts, Louisiana, and here. And I am involved with all of those bills.
Okay. And you were here earlier when the Division of Criminal Justice testified?
I most certainly was and have been arguing about this with prosecutors all across the country for quite some time.
Okay, so that was sort of gonna be my question, is whether you've seen sort of similar objections from prosecutors' offices in other states, or whether it's sort of unique here.
Not only have I heard those objections, here's what I regularly say. There is no prosecutorial office in the entirety of this country who gets it right 100% of the time. It's just not going to happen. So to say that in every single case, all 215 of those attorneys have always 100% got it right is false on its face. But based on what we know, having visited the incarcerated survivors, we know that people have fallen through the cracks. We're not guessing. So somewhere in the course of your history, and even if your attorneys are doing everything they can now, we have survivors who've been in for 30 plus years. What about them? And more than that, you're making massive assumptions about how domestic violence actually works. We have survivors who were being actively threatened while they were waiting for court hearings and withdrew their complaints, only to then find themselves in a situation that led them to prison. I have actually stood by survivors who were being, having their children forcibly threatened if they did anything about what was about to happen to them. I've been with survivors who said that their mother is going to get shot if you say anything or you bring anything up. And then they come back 15 years later because somebody sent them a message in prison that their perpetrator died of a heart attack. That's actually a true story that I've heard. And now they go, oh, thank God. I can't even begin to tell you how many women who've served 30 plus years who lived in a time where domestic violence wasn't even what we consider it to be today. I'm sitting there talking to them and I'm like, you understand that what you're describing is a very serious physical and sexual assault. As a matter of fact, in some of the research that we had in many of the states, Dr. McLeod of OU in Oklahoma actually realized that of the 65% of incarcerated women who are domestic violence survivors, the vast majority of them didn't even understand that they were domestic violence survivors because abuse had been so pervasive their entire life.
So let me just drill down a little bit kind of on this point about, I mean, I think the main objection sort of like you just alluded to is, well, we already do this. We don't need to tell us to do it in statute. So not sure I agree with that position. I think we do that all the time in this building where we codify things. But
I mean, what's
be
the
that as it-
worst
but-
that could happen? You
but-
save a survivor.
But let's go on. Let's go past that for just a second, because I think one of the points that's not been talked about enough here today, I think Ms. Scanlon raised it really early, is, you know, much to maybe my chagrin, and despite the work we've tried to do over the last 10 years, we still do have certain mandatory minimum sentences in Connecticut.
Most certainly.
I'd like to get rid of all of them, but for the time being, they still exist on the books. One of the, I think thoughts behind this bill is, look, I mean, while you still have mandatory minimums on the books, there are certain offenses for which people are convicted of that a judge has no discretion in sentencing.
Yes.
Right? They are forced to impose a mandatory minimum sentence because we as a legislature have written that into the statute and said you don't have discretion, and that this is a way to give judges discretion. And I guess I'm curious, sort of from your work, of kind of how that has played, or the interplay with mandatory minimums in other states, and how legislation there has worked on that regard.
To be abundantly clear, the Oklahoma Domestic Violence Survivor Justice Act was the first law in the state that allowed for resentencing of violent crimes, the very first. It is the only one on the books. So I can't really compare Connecticut to that necessarily. However, what we know about mandatory minimums is that they affect poor, gender, pretty much pick an ism, and mandatory minimums is going to act on them in a disparate sense. But in this particular instance, if you were ever going to depart from what the state has decided must be leveled against somebody who commits a particular type of offense, I think prosecutors resist this law because it takes you into the gray and out of the black and white. Not every scenario of first-degree homicide or where you would level life without parole is the same thing. It's just not. And I would just ask everyone in this room, if you were fighting for your life, if your child was fighting for their life, I mean, homicide is the #1 killer of pregnant women in this country. You save your own life, and this state is not going to deviate to put you in another category. It's whatever the legal arguments, I would argue that that is morally reprehensible. And I don't believe, based on what I know of this state legislature, that that is the path that you all would want to go. In Oklahoma, this bill passed unanimously -4 votes. Unanimously. Like I said, CPAC to the ACLU, there's no question about the moral relevancy of these bills and the fact that they do help survivors. All of the red herrings about people who are not survivors getting out is frankly ridiculous. Asking the state to go back and review an area where they, quite frankly, in my opinion, screwed up is not going to happen easily. I've been part of the filings for these women. In some cases, they're 400 pages long. Page after page, witness after witness of abuse that is unspeakable. And all we've had for them is a cage. Do not listen to the hype on this. I beg you. Give them a shot. And as somebody who was like 2 minutes away from being one of those women, just don't listen to the hype. And actually, if you want to hear the stories of the survivors, our coalition is sitting over there. We're happy to talk to you. Some of them are still so scared they don't even want to go on the record. But they need your help.
Thank you. Further questions or comments from the committee? Further questions or comments? If not, really appreciate you taking the time and being with us today.
Thank you so much.
Theodora Fraser McPherson. Theodora Fraser McPherson. No. About Aaron Williamson.
Good afternoon. My name is Erin Williamson, and I serve as the Chief Programs and Strategy Officer at Love 146. We're an anti-trafficking organization that provides services to children and youth across the state of Connecticut, and to date have served over 1,000 suspected and confirmed survivors of trafficking across the state. I'm here today to testify in support of SB 1502. I've submitted written testimony, so I'm not going to review that, but I do want to provide the perspective regarding trafficking survivors, and I appreciate the inclusion of trafficking survivors in this bill. The dynamic of human trafficking, by definition, involves coercion, force, fraud. It involves a victimization in which a trafficker is controlling and manipulating the movements of their victim. And as part of that, sometimes those traffickers require their victims to commit crimes. We do see that occur. We also see that to the same way that you've heard previously about domestic violence, there are times in which the only way for a victim to escape is to engage in self-defense that might also result in victimization and in criminal activity. In these cases, it is critical that we as a state recognize the intersection of victim offender intersectionality, right? As the person just before me noted, these are gray areas, right? These are cases in which a victim has come to the point of being so deeply offended against them that they feel like their only way out is to commit that crime, or they're compelled to do so, often at the times because they're being threatened. We appreciate that this legislator is looking to create a directive, because while we have wonderful prosecutors across the state and they're often allies in fighting human trafficking, we don't see uniformity in terms of the extent to which these crimes and victimizations are considered. We do see discrepancies across the state. And so we believe that a directive at this point is necessary to ensure that these forms of violence and victimizations are taken into consideration at time of sentencing. Thank you so much.
Thank you. Questions or comments from the committee? If not, thanks for being with us.
Thank you.
Bella Gilmore.
Hello. Good afternoon. My name is Isabella Gilmore, and I am a domestic violence advocate for the Susan B. Anthony Project, and it's an agency that provides domestic violence and sexual violence services to those in the Northwest Corner. We are also a member agency of the Connecticut Coalition Against Domestic Violence, and I'm here today to testify and urge you to support Senate Bill 1502. Last year, Susan B. Anthony Project serviced 1,809 clients. Nearly a fourth of those clients had been serviced with criminal legal advocacy. More often than not, victims of domestic violence become entangled in the criminal justice system. One common way of this is through dual arrest, and while this is being worked out to be reduced, another way is through the criminalization of behaviors based on self-defense or coercive control, leading many victims to be involved in the criminal justice system as defendants. As we know, around 70 crimes carry a mandatory minimum sentence, and many victims cannot afford adequate counsel or in complex cases, nor testify in defense of their own victimhood due to the trauma or ongoing experience of domestic violence amongst legal proceedings. One case in particular, seen by the Susan B. Anthony Project, had a victim who had been under the influence during this case, actively struggling with substance use disorder. She had been coerced to go to the abuser's home to collect personal items. The abuser had driven them to the family's home while under the influence themselves. Upon arriving, the client was manipulated and encouraged by the abuser to verbally and physically attack several members of the abuser's family and extended family. Following the incident, the victim and offender had been arrested, charged, and sentenced to incarceration. The client would have benefited from SB 1502 had it existed when they were going through the criminal justice system. This client had one previous charge of operating under the influence, however, had no previous charges for violent or threatening behavior, while the offender, on the other hand, had an extensive history of violent, threatening, and disorderly conduct, and also had been a known abuser in the community. And they had been sentenced to similar lengths of incarceration and are actually being released around the same time. While this bill may not have led to dismissal of her charges or, complete omission of her incarceration, it may have led to reduction of her charges, reduction of her sentencing, or even reevaluation of her eligibility for the Family Violence Education Program, an alternative to incarceration. So there is no justice for penalizing victims to the same degree as perpetrators, and I thank you for your time and consideration.
Thank you. Questions or comments from the committee? Seeing none, thanks for being with us.
Thank you.
Norman Huey. Norman Huey with us, okay. How about Anthony Brunetti? Anthony Brunetti, okay. How about Jennifer Jazinski? Jennifer Jazinski. Okay. Stephen Harding. Hey. Don't let anybody in here.
Thank you, Chairman Staffstrom, Chairman
Chairman Winfield, Ranking Member Senator Kissel, Ranking Member Representative Fishbein, and other distinguished members of the Judiciary Committee. I am proud to sit here today and thank you for raising Senate Bill 1504, which I do support, and I'm submitting testimony today here in support of. There's multiple aspects to this particular bill. One it does in terms of pursuits. It does modify that outside of what is the current practice. As of now, as all of you know, police can only pursue in instances in which there's crimes of violence, which generally is referred to as crimes of physical force. And as an example, that means that if an individual potentially commits arson, there's potential to believe that a police officer couldn't reasonably, within those guidelines, pursue that individual, which I think most logical people would look at and say is not logical policy. So with that said, we would change that to give these officers more discretion and allow them to pursue in instances where there's crimes of felonies in general. I think we're talking about apprehending criminals, addressing crime, apprehending individuals committing felonies. These are all things that will help address crime in our state, reduce crime, hopefully, in the state. And so therefore, I support that measure of Senate Bill 1504. Additionally, to that, this would allow, it would require judges to place GPS monitoring on individuals that are released on bail for bail over $500,000, over $500,000. As all of you know, that is generally significant crimes and individuals that are significant risks. And this is a public safety issue more than anything else. We believe that there have been some instances in which if there were GPS monitoring, some serious violent crimes could have been prevented. And there'd be better, more effective monitoring of individuals that are potentially violent criminals or out on very violent crimes. I understand judges do have discretion in this regard and could place the GPS monitoring despite this statute, but this would require it in these instances. And we believe it's such a significant issue for public safety that it should be a requirement. In addition to that, and the other last component of Senate Bill 1504 that I do support is adding these 17 additional crimes to what would be required for 85% served before the individual or defendant or the criminal in this particular case is eligible for parole. These 17 crimes are really related to selling narcotics. We have seen a significant rise, unfortunately, in fentanyl deaths, and it involves individuals that are selling this product, this narcotic. It is killing people in this state. It's killing many of our youth. And by adding these crimes, I think it will help address not only criminal apprehension, public safety, but also potentially address the substance abuse epidemic we have in our state.
Thank you, Senator. Questions from committee? Senator Kissel.
Thank you very much, Chairman Staffstrom. Senator Harding, it's great to have you before this committee. I think this is maybe one of the first times you've appeared before the committee since you became leader of the Senate Republican Caucus. And it's one of your old committees, and I know that you probably miss us here in 2C. Out of these three proposals, generally, are there any that you favor most of the three? And do you still feel that, or do you feel that public safety is still a critical issue for the state of Connecticut?
Thank you, Senator. And this is my first opportunity to testify in front of the committee. I've always been a member, as long as I've been in the legislature, of the Judiciary Committee. So I've never had an opportunity to testify. So it is a privilege today to see my old colleagues who I greatly have great respect for, including yourself, Senator Kissel, who does a great job as ranking on this committee. And I would say out of the three proposals, I think adding the additional crimes to the 85% eligibility for parole, particularly surrounding the sale and distribution of hallucinogenic narcotics, I think it's a huge aspect of potentially addressing the fentanyl crisis we have in this state. I think setting a deterrence for those that are selling fentanyl in our state and potentially putting a drug that can kill individuals in jail and setting a deterrence in which that person would have to serve 85% of their sentence before they become eligible for parole. would go a long way towards addressing that issue and sending a strong message that we believe that we are going to apprehend and put in jail individuals that are selling this terrible drug that are killing some youth here in the state of Connecticut. So I would say out of all the proposals, I think that's a huge aspect, probably the strongest aspect of what I support in this particular bill.
I appreciate that. And I hope President Trump's efforts in working sort of a carrot and stick approach with Canada and Mexico and China to that extent regarding the fentanyl crisis bears some positive results. It's my understanding that as many people die per year in Connecticut of fentanyl overdoses as at the height of the Vietnam War, Connecticut lost men and women in the line of service. So it's definitely a scourge, and maybe we just don't give it as much attention as it deserves. And I will also note that while you're doing a fabulous job as leader of our caucus, you are part of that glorious class that came in at the exact same time, you and Chairman Staffstrom. So you guys have that bond going forward. Thank you very much, Chairman Staffstrom.
Thank you, we do. Yes, our amazing class of two.
There is a picture somewhere of Representative Staffstrom and I on a dais together, arm in arm.
There is. We should reenact it.
You tried to
sometime
burn
very
it.
soon.
I still have it.
No, that's not true at all. Senator Harding, while I have you on that side of the table, which is a treat for me, let me ask a couple
Sure.
quick questions, just to drill down on a few of these. So on the pursuit issue, how would this work when a pursuit crosses a town line? So if you've got a police officer, because as I read this, the individual officer, as opposed to the department or as opposed to the supervising officer, whoever, really has pretty broad discretion to decide whether to pursue or not. Would you agree with that?
Under current law, or do you think?
Under your proposal here.
No, well, it would still have to be a felony. If it was a misdemeanor crime, they wouldn't be able to. I mean,
No, but I mean, any felony, I mean, that could be, that could be larceny, that could be, I mean, there's plenty of stuff that counts. That could be, as we've heard here today, that could be failing to submit your paperwork to register as a sex offender as a felony offense.
Right.
So under this proposal, right, just because one of the bills that was on here today. So if somebody has failed to register to submit their paperwork to change their address as a sex offender, right, that's a felony offense under current law in Connecticut. The police officer would have the discretion to engage in a pursuit after that person who didn't submit that form.
Right.
Okay. Now, what happens when that person leaves Brookfield to go into Danbury? Is it the Brookfield officer or the Danbury officer who's in charge of deciding whether to break off that pursuit?
So two things. One is this would change it to a felony, and which post then would create standards by which an officer would have to abide by to determine whether or not to pursue. So to your point, Representative Staffstrom, I mean, those parameters would still be in the hands of post to determine. So it's not just a blanket. If it's a felony, you would have to chase. It would still be an option for the officer, and the officer, within the confines of what post would enact, would have to make a determination of what factors would be involved and whether or not public safety and other factors that an officer determines and whether or not to pursue the individual. I mean, I think any logical person would say that if someone were to commit arson and drive away, and the fact that we have a law that says a cop can't pursue that individual, I think is illogical and I think detrimental to our public safety. I don't think anyone here would logically tell me otherwise, and we're looking to correct things like that by what we're offering here, and then allow post to create standards beyond that point to determine what is safe for the public and what the officers should be pursuing. In regards to whether or not, and I like you lose, Brookfield and Danbury, bringing it back to my home base. I don't think any of that would change here. The only thing we're really changing in the law is having a post enact the factors to determine whether or not to pursue, and then changing from a crime of violence to a felony crime. The other standards that are involved statutorily, regulatory, or through post in terms of when a Brookfield officer pursues and then when the Danbury officer comes in as well, I don't think would change under this statute. I think whatever is codified or regulated under current law would still remain.
All right, I guess I just worry. I mean, right now, as you said, the policy, the pursuit policy is dictated by post. It's not dictated by the legislature.
Right.
And what we've done is in statute, we don't currently define sort of what factors the officers to look at. That's for post to come up with. And this just seems like to me, we're sort of heavy-handing post here, where we would be putting into statute-specific criteria as opposed to letting post come up with those. But let me move to the GPS one just super quick.
Sure.
Do you have an estimate on the cost for that?
We don't have a fiscal note, obviously. OFA could generate that. I don't believe it would be significant, considering that the judge has the authority to do this currently, and I would argue in some circumstances already does. So I would also argue there's not a lot of bonds over $500,000 in the state of Connecticut. I mean, in order to have a $500,000 plus bond, and for that individual to be out, we're talking about a very minimal population, and I would argue in some cases for violent criminals, a potentially very dangerous group of defendants in that particular instance, and that's the reason why we have that proposal.
Okay. Yeah, no, I just was curious to see whether you'd looked at whether, we knew what it was or wasn't. I mean, as you know, I've often suggested there are far too many people who are being released on bond that probably are a threat to society or are a flight risk, but under our current construct, under the current framework of the Constitution, our bail system is just completely messed up. And so, I look forward to working with you and your caucus on addressing that as we move forward. Representative Howard?
Thank you, Mr. Chairman. Thank you, Senator. Just a follow-up to the chairman's question. So I have the pursuit policy from Post in front of me, and it says the officers involved in the pursuit and their supervisors shall continuously reassess and determine whether it should be terminated. It further says that communications will immediately notify the supervisor. And then it says the police officer serving as a primary unit and the supervisor shall continuously reevaluate. And the pursuit may be terminated by the primary unit or the supervisor at any time. So the language before us, I don't see where it seeks to change that. You would agree with me that there's no effort in the statute to change the supervisor's role and leave it in the sole discretion of the police officer, correct?
Correct. None of that is changing. The only thing that's changing is it would give the officer potentially more discretion to pursue an individual that's committed a felony. But the other standards by which the officer would have to consider, none of that would change.
And then also looking at the current policy from Post, it says that offenses that constitute infractions, property crimes to include stolen motor vehicles, nonviolent misdemeanors, nonviolent felonies shall not be justification to engage in a pursuit absent articulable exigent circumstances. So as was stated, it's left in the purview of Post, but it seems to me from my conversations with constituents and individuals that I talk to is there's a growing frustration in the state where people who steal cars know that they don't have to stop for the police and they can just take off. Would you agree that that's the genesis of this change?
I do believe that that's a concern, and I've heard from many constituents that, and this is not only my constituents, people throughout the state that have the same exact concern.
And
yes,
I'm sorry, sir, you served in this committee for a long time. You dealt a lot with law enforcement, police related things. I've said, and I'll say now, the decision to pursue a vehicle is different on different circumstances. So given the exact same set of circumstances, weather, crime, everything, pursuing a vehicle at 3 o'clock in the afternoon through a school zone and doing it at 3 o'clock in the morning when nobody else is on the road are fairly different circumstances. Agreed?
100%.
And do you think that the police officers in this state, with all the training that they go through, can make those appropriate decisions?
100%. And that's what's reflected in this particular proposal.
Because currently there's a straight up prohibition on it. So if there's a stolen car, nobody else on the road at 3 o'clock in the morning on a nice dry summer evening, and that person doesn't want to stop for the police, they're free to go. The police officers can't chase them. Is that right?
It should be, this proposal reflects putting more authority in the hands of the police officer for make that decision at that particular time.
And their supervisor.
Correct.
Thank you. Thank you, Mr. Chairman.
Senator Whitfield.
Good afternoon.
Good afternoon, Senator.
Good to see you.
Good to see
So
you as well.
I think you know that I was involved in creating the current statute. And the reason I got involved was most police departments had come up with a no chase policy, kind of similar to what we do now. But there were some outliers and there have been some issues. And so the police, this doesn't always happen given who I am, asked me to take a look at it. And it was not of my design. It was of their own design that we did it the way that we did it, right? So the conversation about discretion and in their professional opinion has always been interesting to me subsequent to the passing of the law, because it was in fact them that asked me to do what we did and to leave it in the hands of posts in the way that we did. And I remember at the time that we did this, that part of the concern was about doing chases on broad-based felonies because of the issue of danger that we had. And even if it's 2 o'clock in the morning, that danger still exists. As a matter of fact, many of the accidents that involved the public were not during the day. So given that, and that this was a concern brought to us by the police themselves, I have a little bit of a hard time with the proposal before us, because it seems to suggest that we should be giving them discretion in a way that they have asked us not to give to them. Do you have commentary on that?
I can't speak for the police. I'm not a police officer. I'm not brave enough to put on that uniform every day. And so it's hard for me to say what their testimony would be. But I mean, there is a police officer that sits on this committee, I think, that has a very different opinion from that. And so, and the police officers that I have spoken to believe that this would enhance their ability to protect their communities. And I think that we've also heard from the people in the public that believe that it's potentially a logical policy to prevent, not saying that a police officer can't in discretion, but we have laws the way that it's written that they can't pursue certain individuals, where otherwise I think logic would dictate they should be pursuing the individuals. And so I think that's the reason the proposal is here. And I would argue that many police officers that I have spoken to, I think, would like to see a little more discretion. I think, in crafting this policy, I know, Mr. Chair, how much work you put into it and trying to get it right. And it's almost impossible to get legislation absolutely perfect. It's almost never going to happen, right? We try one size fits all, almost never works. And I think over the years, that's the reason why we make corrections from time to time. And I think that this is a tweak. It's not an overhaul of the statute or the law. I think it's a minor change, but I think it's a minor change that can go a long way in giving just a little more discretion to help police officers protect our streets. And that's how I look at it.
And I appreciate that, but I would suggest that from my perspective, and I don't want to be the opposition on this, right? But from my perspective, it's more than a minor change, because when you open it up to all felonies, many, if not most of those, would not be even a part of the thought process currently. So I think that alone makes it a major change. But I respect the fact that you all are trying to improve upon what we've done, and maybe there's a way to get to agreement. I don't know if that's possible, but if there is, I'd be happy to engage in a conversation.
Always willing to engage with you, Mr. Chair.
Thank you.
Further questions or comments? Senator Shkreli.
Thank you. And thank you, Senator, for coming and testifying in front of your old committee.
How do you like it, Chick?
What's that?
How do you like it? It's not bad, right?
I like this. I like working with these guys. I'm gonna ask you some hard questions though to give you a hard time. But we do important work here, and as the good chair was stating, there was an issue with the pursuit policy, and taking into consideration the general public's safety and well-being when these pursuits are happening. When this first came out, I'm like, this is crazy. We really need to be able to pursue and chase. And I had a couple of great conversations with chiefs of police and officers, supervisors that said sometimes, it's not the best thing because, it could be in the middle of the night or it could be at 3 o'clock in the afternoon and, schools getting out, there's kids walking and there's the possibility of additional unintended consequences or more danger to the general public. So I was kind of back and forth. And as we've seen this law be in place and the lack of pursuits that are happening, we're seeing more individuals running from the police. Talking to some of my local police departments, not only are they running when, it's a stolen vehicle or somebody stole something from a hardware store and they take off and they're running, individuals are literally taking off as it's just a regular traffic stop. Some of the officers told me, or departments, that they have another call signal to keep track of it. So if somebody's in the commission of a crime and they run, that's one signal that they'll call so they can keep track of it. And there's another one just for a general traffic stop, and people just aren't stopping. And I think this is important that we look at this now and we try to find a happy medium, because the individuals that are continuously just running and evading these police officers kind of know there isn't a consequence. And I think that, as you stated, we don't get it right the first time all the time. We passed this, we saw what was going on, and now we see individuals just simply not stopping. We're almost emboldening them to do that. We talked to some of the chiefs of police when we were talking about the street takeovers and how they're just taking off constantly. So I do think that this is extremely important that we keep this conversation going and we make sure we give these resources to the officers and they can make the determination whether or not it's safe to do so. And again, it could be called off at any time, from my understanding. So if we realize, even if there's no one on the road, but the individuals that are running are just, maybe driving erratically or extremely dangerous, that they can say, okay, this isn't worth it for the safety of the officers, the individuals actually fleeing, or the general public that may be in the area. But I do think it's an important conversation to be had, because I am hearing from the rank and file that it's happening way too often. And individuals know that they're not going to be pursued. They just throw a different plate on a vehicle and there's going to be no way to hold them accountable. Other conversations were brought up that if the officers, maybe could figure out who they are and then go arrest them after the fact, whether they ID them through, camera footage, specifically with street takeovers, people are recording those. They go back and they would make it an increased penalty for someone who ran from the officer. Whether that's going to be the solution, or we look at this and let it be known that you might not be able to get away with running. I mean, if you're, you will be pursued, you will be caught, and there'll be consequences. And we've seen that when there are certain consequences or changes in legislation, there could be a very positive outcome for public safety. We passed a bill last year that talks about the increased bond amount, cash bond on certain violent gun crimes, and we've seen that murders went down. So when we apply common sense to the legislation that we have that's been here for years or even recently created, that with those tweaks, positive outcomes could happen. And with that comment, would you see that us, analyzing and possibly reforming some of our pursuit policies could have that effect?
Yes. Yeah, I think, you summarized it well. I think that there are these are, in my opinion, are common sense measures that can go a long way towards addressing crime and maybe creating some deterrences for individuals to either run or for just to commit the crime in general, which is always what we want. So yes, absolutely.
Absolutely. And then just one more on section 6, we talked about, the manufacturing and sale of certain drugs. And we've seen the overdoses are just happening at an alarming rate, and they're cut with fentanyl. And I just had 2 funerals within 3 weeks in my local town from bad drugs. And it's terrible that our families are, in our districts, are having to experience this terrible loss. And in my opinion, this could be a way to deter that. But one of the other areas, it talks about crimes against minors, so trafficking of minors, and it's not just the drugs. It's also, people that are victimizing children. And just in the last public hearing, we were talking about certain types of child pornography that are out there, that there may be a little bit of a loophole for individuals to not be held accountable if it's made with AI. And I just wanted to point out that in section 6, it also does that. And this is a way to help protect our children. I didn't know if you want to speak to that.
Yeah, no, Senator, I'm very happy you mentioned it, because it was an important component to this proposal that unfortunately I forgot to mention in the beginning of my testimony, because fentanyl is such a huge aspect of it. As you mentioned, Senator, in your district alone, you attended 2 funerals of individuals that unfortunately lost their lives to an overdose. it is crippling some of our communities. And I think this would go a long way towards really helping apprehend and deter the individuals that are selling this narcotic on the streets and unfortunately killing some of our youth. But you mentioned a really important point of the proposal as well, which is helping address human trafficking and sex crimes, particularly against minors. And you read some of the lists of these crimes that are included in this. It was actually astonishing to think that these crimes are not 85% bids to begin with. The fact that we're not making some of these individuals convicted of these terrible, heinous crimes, particularly against children, to serve at least 85% of their sentence before they're eligible for parole. I think it's a common sense measure to highlight these crimes as significant and particularly reprehensible crimes, which they are. And so I'm happy that you allowed me the opportunity to mention those because that is an important part of our proposal as well.
Absolutely. And thank you. Thank you to the good chair for allowing me the time.
Thank you. Further questions or comments? Further questions or comments? If not, Senator,
Thank you, Mr. Chair.
Representative Harding, Senator Harding, Steve, whatever it is, always, always,
Steve is fine.
always good seeing you, and appreciate being with us today. All right. Next up will be Scott Raymond.
Good evening. Thank you for your time. I'm here for a gentleman by the name of Sal, who lives in West Haven. I'm in support of Bill 1500, and I'm going to read his letter. One of my requirements for being on the registry is to verify my address 4 times a year via a form that is mailed from the registry in Middletown. I must submit this form once every 3 months. Once it is mailed from the SOR, I have 10 days from the date of the postmark to submit it to the SOR, or a second letter is mailed with a warrant for my arrest. I am diligent in making sure this form is submitted as soon as I receive it. I always send it 2 days priority mail with a signature. I keep copies of receipts and documents showing the forms processed through the mail system. During the pandemic in 2019, mail was not being delivered on time. I had a situation where the first form was never received. I contacted the SOR, explained to them my situation. They instructed me to wait for the second letter and send it in. The letter did eventually arrive and I submitted it. I contacted SOR and they told me I was all set and the form was received and verified. Forward to December 22nd, 2022, 3 years later, I had a knock at my door. It was the state police with a warrant, which was for the late form in 2019. I spent 5 hours in jail until my friend bailed me out. I think I had to go through 4 court appearances in order to have these issues resolved. The prosecutor told me she wanted to monitor me to make sure I submitted the next form. I had to take time off of work to attend court hearings that I should not have been subject to in the first place. This process is very frustrating, and I'm always on edge each time I mail the letter because I never know what to expect. In February 2025, I was waiting for the first form to arrive this year. It arrived on my address on 2-6. I mailed it 2-day priority mail, which they should have received by 2/10. Well, this form somehow got stuck in Springfield, Mass. Post Office waiting for delivery. It was delivered 11 days late on 2/19. In the interim, I contacted my PO and explained what was going on. I provided him with my receipts. I also contacted Cindy from OSJ, who submitted the receipts, and contacted SOR to explain my situation. I now find myself paranoid every time I submit the letter, as well as when I hear footsteps on my stairs. I think it's going to be another warrant for my arrest. The SOR address verification process needs to be revised and fixed so people are not being arrested from a broken process of submitting a letter through the post office or being blamed for the process taking too slow. On a personal front, I was a member of the community for decades. It just seems wrong that if you do something right 40 times in 3, 5, 10 years, something that happens to no fault of your own, you can become a felon again. It just seems wrong.
Thank you, sir. Questions or comments from the committee? Questions or comments? If not, thanks for sticking with us. Linda Mack. Linda Mack with us. Abraham Santiago.
Yes, thank you. Can you hear me?
Yep, go ahead, sir.
Thank you. Chairperson, esteemed members of the Judiciary Committee and fellow advocates. My name is Abraham Santiago. I'm a husband, father, clinical technician, and founding member of Second Chance Education Alliance and a smart justice leader with the ACLU of Connecticut. I'm here today because justice in Connecticut has never been blind, but it has been selective. It has been ruthless for some and merciful for others. For decades, it has sentenced Black and brown people to die in prison without ever considering how they grow and change. I'm supporting Senate Bill 1327, an act concerning the reduction of sentence by a sentencing court or a judge. In the 1980s and 90s, when heroin and crack were ravaging Black and brown communities, the state responded with brutal mandatory minimums, truth in sentencing, and extreme punishment. Young men and women, many still teenagers, were condemned under a system that viewed them as predators, not people. Connecticut took the federal dollars, embraced the war on drugs, and filled its prisons with Black and brown bodies, offering no second chances, no path to redemption. Then came the opiate crisis. The faces of addiction changed. The victims became white, suburban, and middle class. And suddenly the system that had only known punishment found its compassion. Now addiction was a public health crisis. Now we needed drug courts, treatment programs, second chance laws. Connecticut and America ran to the rescue, not with handcuffs, but with outstretched hands. Where was that compassion in the 90s? Where was that mercy when Black and brown communities were being torn apart? The same people who were given excessive sentences under those laws, now widely recognized as unjust, are still sitting in prison today. Many have served 20, 30, even 40 years. Many have transformed their lives, but Connecticut refuses to acknowledge it. The Board of Pardons and Paroles finally began to correct these injustices, but the backlash was immediate. Fear-based politics rooted in the same racist narratives that got us here threatened to undo progress before it had even begun. Let's be clear, expanding sentencing modification is not about mercy, it's about justice. It's time to correct these extreme sentences. This is a test of who we are. Do we believe people can change? Do we believe in a just injustice that applies to everyone, not just those who look, live, and vote like us? If Connecticut refuses to act, let history remember this moment. Let history remember who fought to right the wrongs and who chose to uphold injustice. It is time for Connecticut to show courage and give incarcerated people a second look. I urge your members of this committee to support SB 1327. Thank you so much.
Thank you, sir. Questions or comments from the committee? Seeing none, thanks for being with us. Martin Gollner? Or sorry, Maria Gollner.
Hi, good afternoon. Can you hear me?
Yes, ma'am.
Hi, thank you so much for having me here today. I am the Senior State Policy Director for FAM. We began 30 years ago as Families Against Mandatory Minimums. We now just go by the acronym FAM. I am a litigator. I have been a trial attorney in several states, the state system in New York, Pennsylvania, Florida, as well as the federal system. And so we are here today testifying in support of SB 1327. And I want to focus my testimony on a few things. We have submitted more detailed written testimony, but I just want to talk to you briefly about the mandatory minimum provisions here and why it is so important to include a second look for mandatory minimums. My organization not only generally opposes mandatory minimums, we have also supported legislatures across the United States in implementing various types of second look laws. So we're very happy that you're considering this. We ask you to pass it. In your state, there are many, many mandatory minimums. So we've been in touch with the Connecticut Sentencing Commission, as I'm sure that you have on many occasions. There are at least 13 mandatories for Class A felonies, 39 mandatories for Class B, C, and D felonies, 20 for weapon offenses, 11 for driving under the influence, and the list goes on and on for unclassified misdemeanors and other enhanced penalties. You have nearly 10,000 people incarcerated in your state prisons as of the end of 2023. And although I don't have exact numbers for you today, we know that a statistically significant percentage of these are incarcerated under mandatory minimum sentencing provisions. We know based on decades of evidence that mandatory minimums do not work. They do not deter crime. They do not make the public safer. What they do is hurt public safety by consuming massive sums of money that could otherwise be used to prevent crimes. I have heard various witnesses today for over the last few hours talk about the lack of resources in legal offices, for victim outreach, for all sorts of things that the state needs in order to provide its constitutional mandate and constitutional rights to people. At the same time, the state is spending over $100,000 to incarcerate one person for 1 year. The state median income based on a quick Google search is $46,000. So we're spending double the amount of your average person's income, yearly salary, to incarcerate one person for 1 year. The purpose of corrections is to rehabilitate. There is absolutely a place for incapacitation, for deterrence, for all of the things that the prosecutors and everyone here has mentioned today, but there is also a place for correction and rehabilitation. That, in fact, in our view, should be the number one.
Ma'am, your time, I tried to be nice. Your time has lapsed. I know folks online sometimes can't hear the bell. Are there?
I'm sorry. Thank you so much. I appreciate it.
No worries. Questions or comments from the committee? Questions or comments from the committee? If not, thanks for being with us. Barbara Farrell will be next.
Good afternoon. To the distinguished members of the Judiciary Committee, I'm submitting testimony on 3 bills, SB 1502, 1504, and SB 127. I wholeheartedly support SB 1502. It's a no-brainer. It's the only right thing to do. To not consider the contributing factors in sentencing someone is to diminish the harm that the survivor endured. On 1504, let's not forget, I do not support sections of the bill. Let's not forget the sole purpose of bail is to secure the likelihood that accused will return to court. It's not supposed to be a two-pronged process. Pay your bail, and in addition to that, have pay for monitoring. And then on SB 1327, I'm in huge support of this legislation. For me, it's undoing some of the most egregious injustices that have played out in our Connecticut courtrooms for decades, maybe centuries. And I will focus on New Haven District, and we already know the egregious things that happen in those courtrooms. Because there is no genuine independent oversight over what happens in the courtrooms in Connecticut, some prosecutors and judges have weaponized the justice system primarily against people of color and poor civilians. It's undeniable fact that racism is deeply rooted in the DNA of America. There would be no need for sentence modification if the sentences handed down by our government officials weren't so harsh and unfair in the first place. The primary opposition to this righting of the wrongs will come from those who have built this unjust system, promoting it for decades. They have been allowed to crush the lives of so many people with their plea bargain system. In New Haven, for example, over 90% of the cases end up in plea bargains, not because people are guilty of all that they have been charged, but they end up that way because marginalized people cannot trust the system to be fair and just, and so they succumb to bargains to avoid more harsh sentences. In New Haven, millions in lawsuits have been paid due to police and prosecutor misconduct, yet the state continues to keep these same people in positions of power, many times elevating them. Relying on those who created the injustice to weigh in on whether someone gets relief is ludicrous to me. Jails and prisons are full of people who actually needed mental health and addiction services. If we concentrate our efforts on decarcerate and mending this unjust, overly punitive, racist system operating under the color of law, we could save the state billions in lawsuits as well as human costs to countless people who simply needed a compassionate ear and a vision for restorative justice. Mr. Brando Chickett from the Second Look Sentence Project did a thorough job in leading the way on how do we undo this mess that we're in. So let's do the work. Let's do it in this session and not for 5 or 10 years from now.
Thank you, Barbara.
And can I take something from, I just wanted to simply say, can I take something from my friend?
Barbara,
I'd like
you know,
I'd like a question, in other
okay,
words.
all right, all right.
I was just trying to.
I'll see if there's any questions, but questions from the committee. Senator Winfield.
Be careful here. It's sometimes you open it up and you don't want to go but so far. How long is what you were going to say?
Pardon me?
How long is what you were going to say? What you were going to tell us?
Well, it really wasn't that much. I'm just waiting for a question so I can just elaborate quickly on what I went through this morning, just sitting here listening to the prosecutor give his representation. And it was hard, but I do want to appreciate Senator Flexer for asking the question.
We're gonna get there. I was checking.
Okay, no, I won't keep you long.
So, all right, I am interested, particularly given the longevity of your time doing this work. I think many members of the committee know, but I'm not sure everyone knows that you've been doing this for multiple decades, and you've been involved in much of the reform that we've done, and much of it originates right with you. So if you have a response that includes what was happening with you, I'm happy to hear it, as long as I admonish Cindy and others, right? As long as we stay within certain parameters, I'm happy to hear it. So go ahead.
I definitely will. Well, this morning it was very anxious. I was feeling a lot of anxiety listening to the presentation from the prosecutor. And again, I wanted to thank Senator Lex Flexer for asking that question that I almost wanted to scream when she asked it. And she asked the prosecutor, like, with so many cases coming out of New Haven in your district, how do we get to, how do any of us trust what's going on? And I just wanted to scream, because that's what I'm sitting here feeling like. There's so much going on in New Haven, and this is the person presenting that everything is going right when it's not. As a matter of fact, I didn't want to call him out, but this is a prosecutor who, when my kids were young, thank God they've aged out of crime. If he heard one of my kids were coming through the courts, he wanted that case personally. He took it personal. And so that's why it's hard to sit here and listen to him talk about all the great things that are going on. And then quickly, I just want to say the most recent thing, when they talk about that they take into consideration before sentencing someone. A loved one of mine was recently sentenced, and it was misdemeanors. There was one of them was protective order, violating protective order. The victim actually came in and gave a statement, said, I don't want that person going to jail because they really need help. They needed substance abuse treatment and mental health treatment. And in the meantime, from the year that person was arrested to the year later getting sentenced, that person has gone through addiction, went in on their own, got clean and sober, and has been clean and sober all this time, but yet none of that mattered when it was time to sentence them. And again, this was New Haven District.
And to me, those perspectives are important. I sit here and listen to, and I don't think there's intention behind it, but I listen to what at least in my experience, feels very oversimplified about how our system works. And I'm a legislator, right? So I'm not just someone who just popped up in the building, right? I've been here, I've been on this committee for a very long time, and the experiences that I have and share with others living in community with them are often not reflected in some of the stuff that's here. And so I think it's important, particularly for folks who have engaged with us over and over and over as yourself, to put those perspectives on the record as we think about what it is we're doing. Thank you, Mr. Chair.
Further questions or comments? Further questions or comments? If not, Barbara, always good to see you. Thanks for being with us today.
Thank you.
Next up would be AJ Jackson.
Hello, hi. Can you hear me?
We can hear you. We can't see you, but we can hear you.
No, I took my video off. Is that okay?
Sure.
Okay. So hi, my name's AJ Jackson. I have no background in law. I actually work in healthcare for the last 12 years, specifically critical care. I submitted my loved one's testimony, as you may see in front of you, as well as my own testimony. Today, we are here to express our support for the SB 1327, a bill that seeks to provide greater flexibility in sentencing modification. The key reasons we support the SB 1327 include 1, it recognizes rehabilitation and reintegration, 2, addresses mass incarceration, 3, judicial flexibility, which gives judges the ability to modify sentences when appropriate, 4, encourages positive behavior, and 5, eliminates procedural barriers, making this sentence modification process more accessible. Passing the SB 1327 would introduce a more just sentencing system and recognize individual rehabilitation efforts. It further seeks to create a more flexible and individual sentencing system that can adapt to specific circumstances of each case. My loved one, Darius Jackson, was arrested in 2010 when he was 18 years old and sentenced on May 5th, 2012 at the age of 20 years old. He pled guilty to first-degree manslaughter with a firearm and received 38 years, later commuted to 25 years for good behavior. He is now 33 years old and has worked tirelessly to make amends for the harm that he has caused and taken every step towards rehabilitation. He's been a model inmate, demonstrates discipline, respect, a commitment to rehabilitation. He's contributed positively, which has been witnessed. He has been an active participant in the American Vet Dog Prison Program, as well as other programs such as Voices, Culinary Arts, Reentry, Life Skills. He mentors and is a certified recovery coach. He also maintains a spotless record with no discipline infractions for the last 12 years. The SB 1327 would recognize his rehabilitation efforts, allowing him to move forward and continue his positive transformation while also granting him. Sorry. Can you guys still hear me?
Yeah.
Oh, sorry. Positive transformation while also granting him a second chance under its provision. Therefore, we humbly ask for your support to pass the SB 1327. We do not wish to take away from the victims or their families, but believe in justice that allows for growth, redemption, and the opportunity to contribute positively to society. Additionally, the bill does not erase accountability. For victims, SB 1327 acknowledges their pain while also fostering a justice system that prioritizes transformation. Ensuring accountability remains. The SB 1327 does not automatically release individuals. It simply provides an opportunity for a judge to review a sentence mod at 2 years for an individual that's shown genuine change. It's about ensuring that people who have changed have a path to move forward. If someone has taken the accountability, worked to improve themselves, and shown remorse, allowing them as
Ms. Jackson?
yeah,
I'm not sure you heard the bell, but the
I
bell.
can't hear the bell. Sorry.
It's okay. I'm just informing you. So I need you to
Okay.
wrap up another sentence or two. And
Okay,
let's-
I'll just finish my little part at the end. I just wrote, I speak not only as a partner for someone who's incarcerated, but as a friend of an individual who has actually lost his life and became a victim. So while I deeply understand the pain and impact of such a loss, I also strongly support or strongly believe in the power of a second chance. Thank you.
Thank you. Comment or question from members of the committee, Representative Fishbone?
Thank you, Mr. Chairman. Ms. Jackson,
Hi.
I can't see you. How you doing? I hope this
Good.
doesn't become a pattern on this committee, 'cause I like to see people, but you mentioned that, 1327 would address mass incarceration issues, and can you just explain to me the link up? How does this, given that we have a lot of sentence reduction programs already,
Mhm.
how is this bill specifically addressing that situation?
I feel that it would demonstrate it because people with those mandatory sentences would have ability to come up for um, the ability really to just come up for modification, and therefore we wouldn't be spending as much money as we are currently on keeping people incarcerated that can come out that are rehabilitated or have worked towards the rehabilitation. I don't know if that really answers your question, but I was going to put in there, I'm not sure how good I will be at answering questions.
Well, no, I appreciate your perspective. I'm just trying to take in
Mhm.
representation along with the bill. The
Mhm.
example that you gave us was somebody who was subjected to a mandatory minimum.
Mhm.
No, I'm asking. I mean, I think you said 35 years, the person.
He was sentenced to 38 years, but in his case, he actually had a commuted sentence to 25.
Yeah, that's my point. So
Mhm.
the original 38 was already modified down to 20.
That's correct.
So you would have, when was that commutation or that reduction? When did that happen?
Um, Approximately 5 years ago.
Okay. Um, so your support of this bill so that somebody like that individual would be able to ask to have the sentence reduced again?
I see what you're saying, and I don't think we're really looking for, I guess, special treatment, I guess is what I want to say. But I just, I suppose if he was to come up for a prison modification at this time, I'm pretty confident that he would essentially get it because of all the things that he has done towards his rehabilitation that he can show and prove, and his remorse and those type of things. So I don't want to say that we're looking for, I suppose, special treatment because that's not the case. But I do believe that he is beyond rehabilitated at this point.
Yeah, no,
Beyond.
and I see this happen with a lot of people. The thing that
Yeah.
I'm seeing though is, that individual
Mhm.
was already able to get a sentence reduction. There's
Mhm.
already procedures that are in place, you know, perhaps
Mhm.
he could ask for a pardon. Uh,
Mhm.
so I'm looking at 1327 and trying to apply that to that
Mhm.
situation as well as others. But thank you,
Mhm.
Chairman.
Thank
I
you,
suppose.
Representative.
Sorry. Thank you.
Hold on, just let me check to see if there are any other questions. Questions or comments from members of the committee? Questions or comments from members of the committee? There are none. Thank you very much for spending your afternoon with us and
Thank
providing
you.
testimony.
Thank
Terry
you so
Britt,
much.
welcome back.
Oh, I don't leave. I live here. Ah, good afternoon. Hello, Senator Winfield, Representative Stastrom, Ranking Member Senator Kissel, Representative Fishbein, and esteemed members of the Judiciary Committee. My name is Terry Ricks. I'm a 61-year resident of Hartford, Connecticut from the Beverly Square Housing Projects, a 7-year smart justice leader, a mentor and advocate for young people trying to set themselves on the right path. I am here today to testify in support of SB 1502, an act concerning sentencing reduction or relief for survivors of domestic violence, sexual assault, stalking, or human trafficking. I am A woman who has survived every type of sexual assault you can imagine, lifelong depression and PTSD from these incidents. I've had to fight literally for everything in my life, even to be here today to testify on this bill in front of you guys. SB 1502 will help the law align with the lived experience of survivors by recognizing that there are many reasons why a person's experience of survivorship may be minimized or obscured within the criminal justice system. Survivors may be threatened, well, survivors are threatened into fear and retaliation if they speak out about their abusers. Survivors may not understand, which I didn't, that their own experience was domestic violence because the violence was done by a brother, a sibling, a cousin, a father figure. And that also comes with threatening. I'll do something to your mother. So that comes with threatening. This means that there are higher rates of post-traumatic stress disorder among survivors like me. It may take years and years to understand and process and recover it, if ever, the abuse a person has suffered and be able to communicate their story effectively. It took me 34 years until I was able to even begin to tell what was happening to me at 5. I believe that SB 1502 is a crucial step towards allowing survivors of domestic violence who are incarcerated as a result of actions to their abuse an opportunity for sentence modification, parole, or commutation hearing. I urge you, I will ask you of you all to support SB 1502, and I appreciate the opportunity to give this testimony today. I am not that woman that's only 2 minutes away from being that woman. I am that woman. So when the lady spoke earlier, gave the face, she said she was 2 minutes away from being that woman. I am that woman sitting here before you today. Any questions?
Thank you. Comment, questions from members of the committee, comment, questions. Well, thank you for joining us
Always.
again. I always have a smile whenever I see you in the building.
Listen.
So thank you. Thank you for the work.
Because
you
it's
do.
never about me, it's about other people. It's about lives, saving lives. Never about me.
That is clear.
And
That
I
is clear.
appreciate all you always being here. Thank you.
Absolutely. Thank you.
All right.
Rossi Sosa. Rossi Sosa. Alexander Thomas. I saw him earlier. Alexander Thomas? No. Yep. Christopher Dukes. Welcome back.
First time in person. Very much. I'm going to sit this right here so it's not like hard, but I don't have time. If they have questions, I'll show.
All right, you may testify.
Thank you. Good afternoon. My name is Christopher. Good afternoon, esteemed, I want to say colleagues as well, work for representatives. Thank you for all the work that you do. My name is Christopher Dukes. I've been before this committee before, and I've been, I was hoping other folks will be here, but I did provide quite a lengthy written testimony, and I'm glad to be here. I am actually living proof of what Ms. Barbara Fair testified to, but actually a living rebuttal to what Attorney Doyle represented to you or misrepresented to you earlier. I represent a group that's called American Justice Project. It was founded while I myself was sustaining what we called a chokehold, a 15-point chokehold. The chokehold is listed here. These are 16 tactics that are used by prosecutors and police to coerce plea bargains. Sadly, I didn't sign up for this job like some other folks did, but I sustained 15 of those 16 elements. The only one that I was successful of not suffering was wrongful conviction, because I was fortunate enough to be a civil rights investigator who investigated his own case and got the case dismissed during pretrial after 566 days of malicious prosecution. So while awaiting justice, it can take 7 years to get justice in this state. That's a living reality, and that's wrong. When there's so many people who know about what's going on, I can tell you right now that we have clients that we are representing in Manchester, Bridgeport, Vernon, and there's one more. There's one more. There in 4 different GA systems where these individuals are facing wrongful conviction right now. They're being maliciously prosecuted in no crime cases. There's smoke, but no fire. Representative Howard, good to see you here as well also. So Senator Fluxer, as I wanted to get back to a statement that you had made earlier, a question you made. When it was said to you that this stuff happened decades ago, I am living proof it's happening right now, and it's still happening right now. Those of you who I've gotten to know over the years know that your dads as well too. My children are still suffering from the chokehold, 7 years removed from the situation that took place. I know I'm going to run out of time, but I just wanted to tell you that I came to the table with a solution. It does not cost the state to commit to ending the chokehold. I don't have 3 minutes. Well, I can't explain the entire thing to you, but we have made ourselves available to work with you, to be at the table when you're trying to write laws, to find out how can we avoid these tactics being used. The state Supreme Court ruled in my favor in June. This is a case that should have never gone to the state Supreme Court. Currently, right now, I'm on sabbatical since June because the president of the university, Zuma Toro, who wrongfully terminated me, chose to protect a rapist instead. So after I blew the whistle on April 20th of 2018, I was wrongfully terminated while the rapist was protected. I was put on unemployment while the rapist received tenure approval from Zuma Toro afterwards. I'll stop there for now. Thank you. I'll be respectful.
Thank you, Mr. Dukes. And I just will say to you that your signs are not on camera because we don't allow for that.
I know.
Okay. So
it was for
so
you.
When you point to the signs, I just want to let you know that folks are not seeing them. And I'm happy to see you here, and I've followed your case, as I think you know.
Yes, sir.
I'm glad that you have gotten towards the end of that. You made contact with me for several years about that. Glad that you've made progress. Representative Fishbein.
Thank you, Mr. Chairman. Chris, you and I met, what was it, about a year ago?
Yes, sir. Excuse me.
And I too followed your case, and I'm very happy to see the outcome. I also want to mention that somebody had shared with me a video that you had participated in an exchange with people about justice issues. And somebody during that video had made some accusations against me, and you stood up for me. And
Absolutely.
I very much appreciate you bringing that group and telling them the truth. I do share a lot of the issues that you bring to this committee and that you fight for, and certainly any information. I'm always interested. I've learned a lot sitting in this chair since I've been here about the system and the process, and I very much appreciate what you've done in this space. So I have no questions with regard to the legislation. I just wanted to note those things for the record. So thank you, Mr. Chairman.
Thank you, Representative Howard.
Hi, Chris. I just want to recognize you. Well, I appreciate talking to you and following your case and you sharing that information with me. And I had to step out just the very beginning of yours. You're testifying in favor of 1327. Is that my understanding?
I am in favor of 1327. I am vehemently opposed to 1504 for the reason that I did not get a chance to explain.
Well, can you explain it to me? Why are you against 1504?
I'm against 1504 solely for the reason that it does not provide protection for all victims of domestic violence. And what I mean by that is our state has a practice that if you are a person of perhaps my gender, perhaps my race.
Is that 1502 you mean? 1502 is the sentence reduction for survivors of domestic violence. Is that?
No, 1504.
Okay.
It talks about
the
protection of victims, correct, and prosecutions.
Yep. Go ahead. I'm sorry.
Well, I'm sorry. So yeah, it was 1504, and it's because again, there is no provision that I'm aware of that protects individuals who come forward and say, know what? I didn't do it. I'm actually the victim. So when you look like me, I'm a big guy, right? So people look at me, there's no way that guy's a victim of domestic violence. They don't take into account emotional abuse, but they also do not take into account when false accusations are made, what happens after that. And I'm living proof that it can take 7 years. So immediately I was falsely accused, wrongfully arrested, overcharged, excessive bail, fixed to a GPS monitor. I don't wish that upon anybody. Fed bologna sandwiches for days. I haven't had bologna in 7 years. Right. So, and I can smile by that just based on the Holy Spirit in itself. I've never come here to be an adversary. I've come here to tell people this is what's wrong. Let me be a part of fixing the solution, not just for me, as Terry has said also, but for others. Because what happened to me can happen to any of you. It's less likely because of your position. But here I am, a person with no criminal background, no nothing. I was on a $750,000 bond, and the state of Connecticut tried to get it raised to $1 million in a no crime case. My colleague here is holding up 2 separate DNA results that have. Right, you've seen me in front of the Capitol years ago, putting that up, telling folks, this is what our state is doing. It's what the state did. They refused to acknowledge me as a victim of domestic violence. They refused to acknowledge my children as victims of domestic violence. They solely sided with the mother, and it wasn't until the DNA results confirmed that she is the one who planted duct tape, and she was never kidnapped. She was never hurt in any way, and the law protected her instead of us. CCSU leveraged the big black boogeyman theory, even though I was their #1 guy. I was their #1 investigator. They leveraged that as a reason to get rid of me because I had already blown the whistle on these sexual misconduct cases. And as I said, right now, while I was out the entire time, I don't want to stick out somebody here, but they know that I've been in communications with Terrence Chang, and Terrence Chang has been co-signing this cover-up of this rapist who is still working at CCSU right now, because what they did was they covered up his case. Instead of it being HR and being public to everybody, a public employee raping a student, they put it as a student case, which circumvents the FOIA process. It circumvents the public retaliation or coming back out, the outcry or outrage that a person can get away with this. And they've been protecting this man for over a decade, but the current president and folks are doing it, which is why I'm not back at work right now. So for all the Connecticut taxpayers listening, I'm a senior level director who's sitting at home on sabbatical because the hostile environment, after being reinstated by the Supreme Court, still exists. The people are in power, are doing the prosecutors, the police, who have covered up this crime that happened against me and my children, are still, some of them retire now, but there's been no accountability. So I still like to come forward for the sake of transparency, but we need accountability. We need to make sure this doesn't happen to anyone else.
And I appreciate that. And I understand your story. And I think, I would imagine everybody in this committee is in agreement. We don't want to see innocent people be accused of crimes, arrested for crimes, certainly not convicted or incarcerated, right? But I guess my question to you is there's 2 questions based on that. One is as much as you were wrongfully accused, right?
Yes.
People do commit crimes in this state that need to be held accountable. We're in agreement about that.
Yes, we are.
And so is your frustration then that when somebody is wrongfully accused in a domestic violence situation, for example, and it's proven that it was a lie, that they are not prosecuted? Is that your frustration?
Oh, well, that's just part of it. That's a small part of it. Just being falsely accused is not the only element that happens. It's the financial abuse that comes with that.
Right.
I've been separated from my children, my daughter now, for over 2,500 days. Okay, so there's all this that happens. My children have been emotionally abused under the nose of DCF for the last 7 years, and they refuse to intervene. And that's why I provided you all my written testimony to show you the thread of communications that I have had. Because this woman was not prosecuted, it gave her a way just last year to wage a new round of false accusations that I had to hire an attorney for and address. And when DCF found out a second time that false accusations were made, all they did was reverse the charges, reverse the findings, and drop it, and they cover it. They protect it. They won't make a public record of it because they know the implications it has on everybody involved. So my ask to the community has been, please conduct an independent review of this matter. Don't just gloss over it for the sake of getting through the session and move forward, because this is alive and well. And again, an officer of court sat before you today and misled you into believing that these issues happened decades ago and they're not happening now. The reason why I referenced him is because when this information was provided to Richard Colangelo before he resigned, he assigned Doyle to review the prosecutor misconduct in this case. That is off the charts. And he took 3 years, not 3 months, not 30 days, to just absolve the prosecutor and hide it because he has authority to do so. If anyone looked back at this case and see what this prosecutor did after she got that evidence, amongst other evidence, that the person she had deemed a victim up front was actually the perpetrator of the crime, allowed her to get away with it.
I appreciate your stories and I appreciate your frustration, but I'm focused on this bill right now. And I'm not dismissing what happened to you. We've talked about it at length. I understand it, and I understand, I get it, and I appreciate it. What I'm driving at is, it seems to me that the catalyst for all of that for you was that you were wrongfully accused, and it was proven that the person who accused you was lying, and they were not held criminally responsible, and everything else happened because of that. Is that what you're saying?
Part of that, but what I'm saying with this bill, it does not protect individuals like me. How does it account for a person of domestic violence lying on someone, engaging a SWAT team to come to one's home where your children can possibly be killed? That puts us as a victim of domestic violence, and the state doesn't recognize that. That's the issue. If this bill was to include something that would cover victims of domestic violence like myself and my children, I would be for it.
Okay.
Right now, as it's written, I believe that's what I wrote myself. As written, it does not cover that.
All right.
It keeps that hole wide open.
I hear this a lot from people who have been wrongfully accused of sex assault. I hear some people have been wrongfully accused of domestic violence, and I think it's wrong. I totally agree with you. But can you appreciate that we as a state have to walk a bit of a fine line? Because if we go down the road of prosecuting people who make even false accusations, it makes it much more difficult for true victims. That it creates a barrier for them to come forward. Can you understand that?
I totally disagree with that. And
Okay.
here's why. In the 20 plus years it's working as a CCSU investigator, knowing that individuals did have that challenge, that's why you do more than just investigate. You get out and you let folks know that they can come to you. And then when they come to you, you treat them professionally, and that word will spread. People don't come in some cases because they know they're not going to be believed. Here I was, a man who was 46 years old at the time. I endured the abuse that I was having because no one's going to believe that a 6 foot, 350-pound man is being abused in any way, even though I worked in the system.
Sure.
So my issue is you can't cater to one set of victims and not be all inclusive holistically to seriously address domestic violence. People who look like me have to know that when they speak up, people are going to listen, just as well as if I was blonde, blue-eyed, and 5'2", and of Caucasian persuasion.
Right.
That I'm going to be listened to and taken just as serious. Right now, our people are not trained to do that, which is why when they had a Scooby-Doo moment, like, oh, wait a minute, he's really the victim? Absolutely. And they refused to accept that. And our Attorney General's office kept arguing the false narrative all the way along. That can't happen.
Got it.
We can't continue to promote people and elevate people when they are creating injustice.
All right. I think I understand your testimony on the bill then. Thank you. And thank you, Mr. Chairman.
Thank you, sir.
Thank you.
And if I may, one point, I'd like to say, I like the fact that both of you are from two different parties, opposing folks to the fact that two of you can recognize that we can have a bipartisan approach to end these problems that's going on, because both of you, Representative Fishbein and Senator Winfield, I believe are vehemently against innocent people being plucked out of their homes, plucked out of their children's lives, plucked out of all during the COVID, costing the state millions of dollars. As we just checked off, this Representative Howard, this accuser got paid $80,000 for making false statements.
Okay.
When I'm successful
Mr. Dukes.
in the whistleblower
Mr.
retaliation,
Dukes.
she tends to make hundreds of thousands more.
Mr. Dukes.
Thank you.
Gonna set same rules with you and everybody
I
else.
understand, sir.
Representative DiCaprio.
Thank you, Mr. Chair, and thank you, Mr. Duke, for sharing your perspective. Can you just, because I'm newer to the committee, maybe others know this, but what is a 16-point chokehold?
A 15-point chokehold is what I sustained. The chokehold, Paul Butler, professor at Howard, had written a book called Chokehold, Policing Black Men in America. That has been the research that American Justice Project has been applying throughout our state. Just last year, after testifying before this group, we had a young man facing a 15-point chokehold, meaning the number of elements of the chokehold that has been applied. It's not a physical chokehold, it's a metaphoric chokehold. This gentleman was facing 60 years in Milford for a crime that never took place. We saw body cam footage featured on Channel 61 News. We assessed all the body cam footage. We assessed all the records, and we were able to determine that these were all false accusations by the Shelton Police Department. And as a result of us producing our report to his defense attorney, she then in turn was able to meet with the prosecutor's office, show them this is a no crime case. You need to dismiss these charges. And they did dismiss those charges. Unfortunately, while he was wrongfully jailed, he made a phone call to his wife when he was in there. And so the prosecutor convicted him for making that phone call to his wife while he was wrongfully jailed to begin with. And unfortunately, he took a plea bargain on that. And total pretrial and disposition was 15 months in jail. But 15 months is a world of lot better than 60 years. I would recommend, sir, that if you please take a look at www.americanjusticeproject.org. His case is featured under our campaigns, and so is mine.
Okay, thank you very much for that. And I'm another one, we're not in favor of incarcerating people, innocent people. All right, thank you very much for your testimony. Thank you, Mr. Chair.
Thank you, Rep. DiCaprio. Representative Fishbone.
Thank you, Mr. Chairman. Mr. Dukes, I think you'd agree with me. It's unfortunate up here. A lot of people think that domestic violence is just perpetrated upon females. But as you let us know today, you've been a victim. I had a client years ago who it was over 6 feet, probably not 350, maybe 320, big guy. And he complained about domestic violence, and they didn't believe him because you're a big guy. Until the wife in the middle of the night took an iron, the cord. She whipped around the cord, hit him in the head with the iron while he was in bed. Then they believed him.
Yeah.
I had a case a few years ago where a case I'm on tomorrow, where a woman keeps on making complaints to DCF and to the police that my client is doing bad things to the child. And she's making it up. It's repeated, and the child keeps on getting taken out of his care. I filed motions with the family court. You should send this case to criminal court because she's lying on affidavits. The case is staying in family court. It's never getting to the criminal court. It's a very difficult process to work with. I see it. Thank you for coming here today and the exchange. So thank you, Mr. Chairman.
Thank you. Comment, question from other members of the committee. Comment, question from other members of the committee. There are none. Thank you for joining us again.
Thank you, sir.
Enjoy the rest of your afternoon. David Walsh.
Good afternoon. My name is David Walsh, and I'm Legislative Liaison for One Standard of Justice. And I'd like to thank very much the committee for hearing us today and working on these difficult issues with us. I prepared some testimony that I did submit as written, but I think it's probably best if I just respond to some of the questions and issues that kind of came up throughout the testimony to this point, and then I'd be happy to take any questions. The first I'd like to address, that I think is kind of central to a lot of the conversations here, is whether this issue of strict liability. Representative Fishmine correctly pointed out that strict liability is not written into the statute itself around address verifications. It is, however, shown in the notes for those statutes. Beneath the statutes, it clearly states that the statute imposes strict liability. And also in our conversations with attorneys who work with this law, indicated that it is indeed dealt with as strict liability in the courts. So I just wanted to have that clarified. Also, I know there were questions that came up about other statutes that are strict liability. Indeed, I did some searching. You could only really find two. They are both Class E felonies. This is the only Class D felony I could find that was a strict liability. And the other two offenses relate to sale of alcohol to minors and carrying a dangerous concealed weapon. And then I'd like to move on to talking about this idea of address changes and whether or not the phone calls are allowed for that. I will say that that address changes, there are no clear directions that are provided, which is one of the problems I think that exists broadly for the issue around address verifications. There could be better clarifications of the responsibilities of those who are on the registry and how best to respond. You do receive notice when you have to have a photo retaken. But in terms of moving, there's no site, for instance, I can go to and just simply change it. I would go in person. I would be very nervous to do anything other than actually go in and get paperwork on that issue. The other thing is the question came up about showing intent and how that could be handled. Recognizing, of course, that really almost all of our criminal justice statutes have to have intent shown. There's nothing, I don't think, extraordinary about having to do that with late letters. But I would say that in order to demonstrate some sort of culpability in that, there are a couple different options. I mean, you could look at one, a pattern of behavior. Has the individual had a pattern of absconding or, communicating incorrectly what facts for the registry? And the other is, do they actually live in the residence that is written on the letter? If they do not, that would be a clear indication that they are attempting to mislead the state and would be a show of intent. So I don't think that any concerns around showing intent are difficult to any extent, but I think we would be able to work with members of the committee here to come to something that's satisfactory for all parties, because I recognize these are complex issues. And I guess the other thing I'd want to do is touch on the two items that we were looking to maybe make as friendly amendments. One of them is to actually narrow the public call-in so that it was really only available to those who would be institutionalized or homeless. In other words, reducing that burden, which would reduce the cost to the state.
And then what was the other?
Oh, okay, thank you. The other one is just simply to broaden this idea of needing intent to cover the other issues of a photograph, updating address, et cetera, because they really are the same types of thing. It's all about updating information in the registry. Thank you.
Comment, question from members of the committee. Representative Fishbone.
Thank you, Mr. Chairman. Thank you, David, for your testimony. It appears to me that making the registration as easy as possible would alleviate all of these concerns. So I'm having a little bit of trouble, I guess restricting the telephone registration to only those that are homeless or institutionalized would prohibit one who just wants to use that function. Why that would be a benefit?
I guess the reason I would see that as a benefit is twofold. One, I think that since at desk there already are people taking calls, that it could then be done with existing staff and resources, and it's something that could be implemented quickly. It also would avoid having to put any type of fiscal note in. I mean, I firmly believe that doing this could save a significant amount of funds. We're talking about 200 convictions a year that are really mostly unnecessary, and court time and arrests and police time and everything else. So I think, if anything, there deserves to be a positive note on this. But still, I would be concerned about raising the specter of an expense that then would jeopardize the passage of the bill.
Understood. Sometimes, because the balance we have here, ultimately, I think the balance is the victim, right? I think the whole public policy basis to have the registration is to inform victims potentially that somebody or potential victims that somebody who has one of these crimes may be in the neighborhood or the actual victim in the crime. It really is not to my knowledge, unless please educate me, it doesn't benefit the convicted person.
That's correct. It's not there to help the convicted person. And I would also add that there's been a lot of work showing that it does nothing to improve public safety. It doesn't actually reduce recidivism or have any impact on those things. But I just wanted to clarify too, that there's really no benefit to anyone. I do recognize that it may give some comfort to a victim to be able to see where individuals who have offended might be located.
Sure, because certainly there's no restriction on where the victim resides, so, ultimately that's what so I'm looking at this whole thing and I'm saying, if we make it as easy as possible to register, then you're empowering the individual who's required to register. You don't get the excuse of, I didn't get it in the mail or anything like that. And then you can leave everything else in place. Right? And then the cost, it really doesn't matter ultimately at the end of the day. Am I looking at this wrong?
Well, I would say that I would be hesitant there just because, there are a lot of tasks that everyone has to do that are relatively simple, submitting their taxes, doing different things that, I wouldn't want to have them made Class D felonies. That would be seen as obscene in most cases. And making them, strict liability, just because they're easy doesn't exempt, I think, the consideration of whether or not the punishment actually fits what the issue is, or, alleviate the state from having to concern itself with the fact that people are they're not able to control the very things that they're being arrested for. So I know you say to make them easy, but the devil's in the details there, I guess. And I need to know, because you have a variety of, you have people in situations where they're in institutions, mental institutions, halfway houses. Some people who don't have access to technology, say computers, they aren't allowed to go to libraries. They may be forbidden from doing that if they're under supervision. So it's more complex than your general population in terms of making something easy.
Understood. But all of those things, I think everybody has access to a telephone. I think that's
pretty much, even homeless yes, and that's why we thought that the particularly for the homeless issue, phoning in made sense. Yes,
and perhaps in the situations, yeah, okay, so that would meet a need. But then even those individuals who don't have access to a telephone could report to their local police department. Their address, or I'm homeless or whatever. I mean, what would you think about something like that? That would only apply to those people that don't have access to a telephone.
Right. No, I hear you. I mean, I think all those things of easing the updating of information are great, and I think they would help actually with the accuracy of data in the registry too, and that's a plus. But again, I must say that the D felony and strict liability are unheard of in other instances in this state law. And it really just doesn't belong there. And I guess I don't understand why it would be thought acceptable to keep in place.
Well, from my perspective, if we're going to I understand the excuses now, right? I didn't get it in the mail, or get lost in the mail coming back or something like that. Those are, in my mind, legitimate excuses that should be used to mitigate the conviction of a crime, right?
Yes.
But if we empower the individual to, email, telephone, mail, and they still violate, then, I got an issue with that. Because at the other end, if we ultimately say that this is to protect victims, and I've given the individual every opportunity that we can think of here today to comply, I got a lot of problems at the back end. So that's the exchange, but I appreciate the exchange. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us.
Thank you.
Pamela Elliott. Pamela Elliott. Alex Tobis.
Good afternoon, senators and representatives. Thank you very much for this opportunity to testify in favor of Bill 1327 regarding sentence modifications. I also would like to voice my support for 1502 for the domestic violence and stalking and sexual assault victims getting sentence modifications, as well as the bill regarding the sex offender registry updating. I've seen people who committed crimes when they were 15 years old, gone 20 years, served their prison time, served their probation time. 25 years later, they have this failure to register thing, and it derails their ability to move forward in their life from something that happened 20, 30 years earlier. With regard to sentence modifications, a lot of talk about how there might be a rush to the courthouse door or might overburden the courts, but keep in mind, sentence modifications offer the opportunity for the court to potentially release someone or to reduce an excessive amount of incarceration. That saves money every time it happens. I've filed motions in all 13 of the Connecticut criminal courthouses to modify sentences. We've had hundreds of years taken off of people's sentences. Gaylord Salters is one of my clients, and he testified here today about the transformative impact of a sentence modification. And there are many people who are either facing a mandatory minimum or who plea bargain and therefore can't get access. One of my clients, Christopher Shepard, was convicted of murdering his grandfather. What wasn't really considered during his case was that his grandfather forced him to perform oral sex on him from the age of 8 years old, and that the fact that he was a victim of sexual assault from his stepfather as well was not considered in his case. Mr. Shepard served 30 years in New York prisons, got parole there, but now is just starting a 60-year sentence in Connecticut for that case and has a 25 years of mandatory incarceration ahead of him. He's not eligible for a sentence modification, unlike many of my clients who committed the same crime, simply because when he was 18 and he was convicted, he pled guilty. So he needs to get the permission of the state's attorney to go and get a court hearing. And even if he were to get a court hearing, the court couldn't go beneath the mandatory minimum, even though he's been continuously incarcerated for decades. And the victim in his case was someone who sexually assaulted him when he was a child. So we need either 1327 or 1502 would help Christopher Shepard. There are many other stories like this, people who their victimhood and their experiences just weren't considered, especially in cases of plea bargains where, as State's Attorney Doyle mentioned, those cases are negotiated in private in back rooms, in judges' chambers. Clients are not there. There's no court reporter. There's no transcript. So we don't really know always what's being considered in those cases. And oftentimes those deals are for 20, 30, 40, 50, 60 years of incarceration. So should judges have the ability to look at those cases? And if the judge decides that maybe this incarceration is excessive or this person wasn't considered as a victim at that time, 20 years ago when they're 18 years old, yeah, judge should have that discretion. We need 1327. Thank you.
Thank you. Comment or question from members of the committee, Representative Howard.
Thank you, Attorney Thomas. I love when you testify in this committee because of the work you do. It actually does fascinate me, and I'm serious about that. So I have a couple questions for you. So 1327, which is the sentence modification bill, I don't know if you have it in front of you, probably have it memorized.
I've memorized.
Yeah, all right. So
this is my bread and butter.
Yeah, so down in 3539, the new sub C, it says notwithstanding any mandatory minimum term of imprisonment, basically the judge can, overrule any man-mins. Now, you've probably heard me say before, I'm not a big fan of mandatory minimums, probably for different reasons than my colleagues, but I don't particularly care for them. However, mandatory minimum sentences are established by the legislature, the voice of the people in our legislative branch of government. We're agreeing about that.
Of course.
Right. And this language would allow one unelected member of the judiciary to unilaterally overrule the will of the people, wouldn't it?
Well, you would be making it the will of the people to give judges that discretion.
Okay.
So that sometimes we endow in judges or other officials discretion And that is our will. Our will is to use your wisdom, is to use your knowledge. And it would actually bring our Connecticut mandatory minimum regime in line with the federal, thanks to President Trump, which is not something you probably expect to hear me say. But thanks to President Trump, there was a passage of a law during his first term called the First Step Act. And that bill actually established in federal court that a U.S. federal judge can go beneath a mandatory minimum in cases of extraordinary and compelling circumstances. And that was the first time in federal law that that ever occurred. Around the same time that you all changed the sentence modification statutes at the state level, this, with the mandatory minimums, would bring Connecticut state law in line with federal law.
Yeah, well, frankly, in a pure state, I don't know why the legislature puts mandatory minimums anyway. It infringes on the judicial branch, in my opinion. But
Agreed.
anyway, I digress. The other thing is 1502. So my experience has been that oftentimes perpetrators of sexual violence are victims themselves. You agree with that?
Unfortunately, like I think it was the movie Mystic River, where the character said it's the gift that keeps on giving.
Yes. Well, that's one of the things that so I'm struggling with 1502 for a few reasons, because certainly, in my experience, as I'm sure you probably know, I've been down this road with a lot of people, and I can appreciate the intent here. But are we opening a door where individuals who are sexual predators themselves, because of their own victimhood, have their sentences significantly reduced? Is that in the best interest of public safety, despite the problem?
I think you have to look at it case by case. Obviously there's situations where people might use abuse as an excuse. And there's other situations where there was abuse and then there was harm following the abuse, and that wasn't ever taken into account. And any prosecutor who is presented with it is going to take it into account, but oftentimes it's not, for one reason or another. I mean, there's often a press of, when a case first comes and happens, there's a press to get the case done with and over with.
Sure.
And so that you have to make strategic decisions about what you can emphasize. And often if you bring up abuse, it can backfire for just the reasons you talk about. Are you not taking responsibility for your own actions because you're bringing up abuse from your past? Plenty of people get abused and don't commit any further crime. So it's not an excuse. It's not a get out of jail free card. That being said, people can rehabilitate. One of the ways that people rehabilitate is by coming to terms with abuse that they may not have come to terms with prior to. So while they're, oftentimes I've sent psychologists into prisons, but they've spoken to the psychologist, and because she's really good at her job, they disclose abuse that they had never disclosed to anyone before in their lives. And that doesn't mean that they should just get out because of that, but perhaps that should go in front of a judge to think about whether maybe some of the decisions that were made decades ago might be augmented. And another thing too is oftentimes sentence modifications change the reentry process. So a person might get a 30-year sentence flat, but a judge might say, okay, you're nearing the end of your 30-year sentence, but you have no probation at the end. So I'm going to modify it to 27, but I'm going to give you 3 years of probation now. And because we now know that you had this issue when you were a child, but you're addressing it, the probation officials can now address it while you're in the community, and you don't only have help while you're in prison and then no help when you're released back onto the street. So sentence modifications, I believe, save the state a lot of money. There was a talk about habeas cases. Great thing about a sentence modification is if you release someone on a sentence modification, the habeas becomes moot. So all of the work that all these other attorneys are doing, gathering expert witnesses, bringing up a trial, doing all this, you can have a 1-hour hearing in front of a judge and the habeas hearing is no longer needed.
Right. No, yes, I appreciate that. And I wasn't so much, I would hesitate to say that, I'm sure it happens that people use their own abuse as an excuse, but clearly that does in some cases cause.
Of course.
Right. And that's sort of my concern is that, regardless of why people commit crimes, especially crimes of a sexual nature, whether they do it for because they were abused or they do it because they're just evil people, there's still create a risk to society, right? I mean, if you're a sexual predator, unrehabilitated, you're a risk to society. You would agree with that.
Yes, yes.
So do you understand, and can you alleviate my concern that that particular avenue could be used under 1502 for a significant, like up to a 50% sentence reduction?
I believe that it is because there are so many checks and balances that are built into it. It's not as though if you meet the criteria of this statute, you will get the reduction. It's still going to be issued by a judge who, by the way, in all of my experiences with sentence modifications, they have always been utmost concerned about public safety over everything else. The state's attorney is going to be at that hearing expressing their views about the public safety. Victim's advocate is also going to be notified, is also going to be present. If anything, I think that what you do when you have these hearings is you actually put more attention on these offenders who are coming back into our communities than if we just said, we're done with you at sentencing, see you when you get back. We're now bringing to bear on these cases expert psychologists, risk assessment experts, the state's attorneys, the victims' advocates, the defense attorneys, the judges. And they're all looking closely at things in these cases that maybe weren't even looked at all before when the person was sentenced. And they're all thinking about what is the best way forward for public safety with this individual, whether that means leaving the sentence as it is, which is the majority of cases where you have these hearings, or modifying it to reduce it, or more likely reduce the incarceration aspect of it somewhat, maybe suspending some of the incarceration, adding in some period of parole or special parole or probation, supervision, maybe a little GPS monitoring, throw that in there. And so essentially, I think these, and also, by the way, you're encouraging everyone in there, in prison, to take their rehabilitation more seriously and to assist the staff because there's actually more rewards that would come from doing so. So I think that these laws are actually the best thing for public safety. They help public safety. They help the correctional staff maintain the order and control and rehabilitation of the facilities. They help probation and parole assist in the reintegration of offenders into the community. They help offenders rehabilitate themselves. And yes, they do provide victims with a lot of these notices, which can be very disturbing. But for those who are victims, Connecticut giving them these notices and keeping them informed puts us at the cutting edge. You know, there was a very big case in Maryland where a person was released and then it got reversed. The person had to go back to jail because they didn't send the notices. The notices are difficult, but when we're putting someone in jail and we're taking away their liberty, everybody's interest has to be represented. Yes, the victims as well as those who are incarcerated and society at large that pays for all of it.
Well, 1502, to your point about the judge's consideration, in 1502, it says that if the court finds by preponderance of the evidence that domestic violence, sex assault, stalking, or trafficking of persons is a contributing factor, the court shall depart from applicable sentences and make certain adjustments, and it's all outlined here. So if you're putting it, as I understand it, and correct me if I'm wrong, because you're the attorney and I'm not, and you work in this every day, we're putting it on the judge to say, once you find by a preponderance of the evidence, then you must modify the sentence as outlined here, right? That's what we're saying. So is that right? Am I?
Yeah, I think that is right, but there's a lot of discretion in that language, right? Because when you're talking about what is a contributing factor, the judge is left to decide whether it's a substantial factor or whether the substantial factor, the only contributing factor was the offender's own actions. And even if you find that a person was abused, you may still think, no, the only contributing factor in you deciding to do this was your own actions. I think that it flows somewhat naturally that once the judge makes that decision that this was a contributing factor, that finding has never been made before in the case, that they have to make an adjustment. I'm more familiar with 1327 than 1502, but I don't believe 1502 says they have to make a particular change, right? They still have discretion in how much change that they want to make based upon what they find.
Okay.
But I believe that to be the case. And, you know, I would be in favor of that discretion because yes, a judge is not elected. They're, you know, selected. They go through a process that you all are part of. But, you all do a very good job of picking people who do take into account the public safety and do care a lot and who listen to both sides. Everybody gets heard. So it's not a matter of none of these decisions are made willy-nilly. You know, they a lot of consideration is put into them before anybody gets released.
All right, thank you. I just, and I'll look it over again, and if you could too. I just, the way I understand it is, if a judge were to say, okay, the preponderance of the evidence that the individual committed this particular sexual offense solely because they were a victim of it, and they make that determination and say, but even still, they still pose a significant risk to society because they have not rehabilitated. The way I read the language, they're sort of forced to modify it as outlined there. But if you read it different, I'm happy to be corrected on that.
I believe that the language as it stands would give the judge is in the driver's seat. The judge will decide what the outcome is. What's being done by this language, and there's a little bit of overlap, like 1327 would help a lot of the people who 1502 is trying to help. 1502 is more limited to a particular group. 1502, in my view, does a really great, you know, I was more focused on 1327 because I have a lot of clients who wouldn't fall within 1502. But 1502 forces us as a justice system to really take seriously the concept of a trauma-informed sentencing, because I've been in many sentencings, unfortunately, where there are people involved who just say, well, if something bad happened to you, you should know not to do anything bad to someone else, which is kind of a logical point of view, right? I mean, there's a certain logic to that. And then it's true. But I also think that if you are more trained and aware of some of the research on PTSD and on the cognitive effects of trauma and abuse, that you might consider it to be more of a mitigating factor than you otherwise would. And I think that it's good sometimes to say, you know, let's break from the past a little bit and really start to dig into this trauma-informed way of looking at things. And that's why I think 1502 does. It still leaves it to the judge to decide ultimately, am I going to let this person out or not? I mean, and there's not going to be any appeal from what I read.
Okay, thank you. Thank you, Mr. Chairman.
Further questions or comments, Representative Fishbein?
Thank you, Mr. Chairman. Thank you, Alex, for coming here today. Very much appreciate the exchange you had with Representative Howard. And I understand, I want to stay focused on 1502 because I think we have our fundamental differences on 1327. But and I'm not holding you to this, but I just wanted to. It does, in my opinion, take away that discretion because the gatekeeper is, as Representative Howard read to you, once the court makes that finding, if you're looking it up, it's line 90 is where.
Thank you.
Yeah, no problem.
Okay.
Okay, it says a term of life imprisonment without the possibility of release shall be reduced to a term of 30 years imprisonment or less. So, and so on and so forth. So, my understanding is that the maximum penalty that we have in Connecticut, because we got rid of the death penalty, is life without the possibility of parole. So, you know, a Newtown situation, 26 people are dead. The max that person can get in Connecticut is this penalty. If this situation is to work as the proponents would have, a court finding that there have been domestic violence, which we've heard lots of stories about what was going on in that home, which some people could categorize as some forms of domestic violence. That term would be automatically, or the court doesn't have the discretion. They would have to reduce to 30 years. And just to go on from there, a term of 50 years of imprisonment or more, but not life imprisonment without the possibility of release, shall be reduced to a term of 25 years imprisonment. So it's a wholesale, you're cutting the term. There is no discretion. Court can't shave a couple years off. You're cutting the term in half. So with that information, do you think that that's good public policy?
Well, I think that what makes it good, I mean, I do. I'm not gonna lie, I love it. I think it's awesome. It's great. One of the best things I've ever read. But the reason why is because contributing factor is such a big deal. You have to understand, it's not just saying this person had abuse happen in their life. This person was stalked. This person was trafficked. This person was raped. You know, it's saying the fact that this person was raped was a contributing factor in the commission of the offense. To me, it would be inconsistent with any notion of justice if a judge were to find that. It's a high bar, okay? That's in essence like saying that that's like a contributing factor is the standard for causation under the Longshoreman Act. That's like the standard for like a workers' comp like injury. It's a pretty stringent standard. So it's like saying that at the moment of the crime, they were under an extreme emotional disturbance, which would preclude a finding of first-degree murder in a 25-year mandatory minimum. It would, and for the life without imprisonment crimes, which is a select group of people in Connecticut, for them to be convicted of that in the first place, they have to be convicted of first-degree murder with aggravating circumstances that are found beyond a reasonable doubt. If this were to be found, it's in Connecticut court, when you have a sentencing phase of like, we don't have cases anymore where you have a sentencing phase for these life crimes. Once you've convicted of the life crime, the life sentence is automatic. Now, in places that have the death penalty, if you're convicted of the life crime, there's a sentencing phase where there's the aggravating factors, and you have to prove at least a few of them. And there's the mitigating factors. And if you prove a mitigating factor, you can't get the death penalty. In some places, you can't get life. If you have one of these hearings and you prove that this crime was motivated in part, was not just motivated, but caused in part by these cause, because a contributing factor is like a causal link. If it was caused by this other abuse, to me, it would be wrong for a judge to find that to be the case and to not change the sentence significantly, because to get such a long sentence, it has to be aggravated without these mitigating factors. If a judge finds the mitigating factor, and this is a pretty significant mitigating factor. It's not just, I was drunk at the time and I didn't remember a thing of what I did that night. This is like not just that you were raped, but that you being raped was a contributing reason why you committed the offense. That's really significant. And I think that to give those, it's probably going to be a small group of people, that benefit would be a great thing, would be a very necessary thing.
So, Connecticut still does have capital crime. They're on the books.
Right, but only one sentence.
Yeah, they don't include an aggravating factor. For instance, I believe killing a police officer in cold blood. There's no aggravating factor, right?
That is the aggravating factor, that you killed a police officer.
Yes,
that's what's considered the aggravation. Yeah.
Well, but it's badge and uniform is really.
But that's an aggravated factor. It's just like if you assault a police officer, it's not just an assault, it's a whole different crime, right? It's an aggravating factor. Yeah.
Understood. I don't agree with you on the high bar, okay? Because it just says a contributing factor, right? So I would agree with you if it said a substantial contributing factor, right? Then that's right in line with what you were saying, right? but there could be various contributing factors, right? The person could have been under the influence of some, illegal substance and, there could be various, right? But this is in the singular, a contributing factor. So I would argue to you, it's a very low bar.
I'd probably argue that too. If I were representing my client, I would argue it's a low bar, Your Honor. It's just a contributing factor. But in a case like the way that this statute is written and given the reading the statute in context of what it's talking about, I don't think any judge is going to look at this law and think, oh, I should just start letting people out and changing these sentences. This is going to be a very serious hearing where, I mean, a lot of evidence is going to have to come out because you're going to have to prove it by a preponderance of the evidence. So it's not just a substantial evidence fact like standard. A judge is going to have to find it's more likely than not. I don't think that many people will win these hearings unless the state's attorney agrees before the hearing even starts that it should go through, which happens sometimes.
It does.
But interestingly enough, I don't think that there exists a mechanism for something like this, even in cases where a state's attorney agrees currently, for people, for example, with the life without imprisonment. Like, I don't think there's a way to get them resentenced under current law. A lot of time, if these hearings go and they're contested and the state's attorney saying you don't have enough evidence to prove it's a contributing factor, there's not a lot of precedent. This is a brand new thing. What does it mean for your prior trauma to be a contributing factor in a crime that you committed, that you were convicted of? I believe this is going to be a high bar. I predict that maybe no one would even get released in the first year. Maybe it'd take years.
So presently, well, first of all, there is no time limit, right? So somebody who was convicted 20 years ago and it's life without imprisonment. So we characterize that at 60 years, I believe, is, that person would be eligible, as well as the person who was convicted, last year. What is your thought process on making the standard clear and convincing?
I think that in practice, you're going to need clear and convincing evidence to convince a judge. I think that all of these standards have room for interpretation, and in practice, different people will apply them somewhat differently, but that the gravity of these cases, you're talking about very serious crimes and then very serious claims of crimes on the committer of the crimes. If you open up this window, this opportunity, it's going to be something that if lawyers feel very strongly that their clients fall under this, they will put the effort, the time, the work to be able to put together a presentation under the statute. It won't be easy because there's no guidebook. Oklahoma is the only state that has it. There's no instructions. Us lawyers, we're only going to try this if we really have solid stuff. And then if the state's attorney doesn't agree, it's going to be very hard to convince a judge to go back on what another judge did. Judges are also very respectful of what prior judges did. So if they don't want to go and say that a prior judge got it wrong. And we're not usually arguing that they did. We're usually arguing that there was something they didn't consider or didn't have at the time. This is not going to be easy at all. But for those for whom the effort is made and for whom it is their truth and it wasn't considered, these cases really, it really makes people believe in our justice system more when we can make some of these wrong cases right again.
I don't disagree,
Yeah.
but the question, you're saying it more than likely would require clear and convincing anyway. Is there any harm in just writing that as clear and convincing?
Well, you guys are on that side. I'm on this side for the words you use, but I believe already as it's written, you're creating a very high hurdle. I don't think really it will change it that much, to answer your question, really. Like, to be candid, I don't think it would change the tenor of these hearings much. if it's clear and convincing. But I also don't want to, I don't want you to, in the end, judges have to judge. They have to make a judgment. There's no like formula of this person's faking their abuse claim. This person really was in a in a state where they were not getting treatment and now they are, and they really get it now. Judges have to like look at the person. A lot of times they're basing their decision a lot on what the person's coming right in front of them and talking to them. So more important than whether you go with clear and convincing or preponderance or substantial or contributing is giving these victims this avenue where if lawyers feel strongly that this is one of those small group of people where if we bring up this abuse, people are going to say, you know what, maybe we need to look at this person a little bit in a different way than we looked at them before. Oftentimes with the support of victims. Oftentimes with the support of victims.
So, I appreciate that. And many times as lawyers, we get not personally invested, but
passionate.
We get passionate. Yeah. Right. And we understand that our client was wronged. Perhaps the system wronged them. Why would we permit as part of the evidence here an affidavit? Well, it isn't even an affidavit. It says a sworn statement from the lawyer.
I think you should permit anything essentially in it when it comes to people, questions of custody and questions of sentencing. The traditional common law rule is that the rules of evidence do not apply, and that a judge can consider essentially anything in sentencing as long as it's not false information, falsehoods, misinformation, provably, verifiably wrong things. The more information, the better for judges as they make their decisions in these sentencings. You don't want to hide anything from them or keep anything out because we trust them to separate the wheat from the chaff. I would want original lawyers to be involved, to know what was going on. Why didn't it come up before? It's probably not as important as the forensic, psychological, and medical testimony. That I think will probably be the most influential.
Yeah, I would tend to agree. But, you know, the lawyer who's invested in the case and passionate about their client saying, yeah, you know, 10 years ago, they told me about a domestic, and
it can provide context. So, I mean, like I said before, sometimes you don't want to come out and say that I was a victim of something in the past because, you know, you practice, you know, you go into a courthouse, sometimes there's the nice prosecutor and there's the mean prosecutor, you know, or there's the prosecutor who cuts a break and there's the one plays the bad cop, right? And the bad cop, you don't want to bring them the mitigating material because they're going to say, oh, so they don't accept responsibility. They're making excuses. They're not changing their life. The good prosecutor, maybe you go and you bring it to them, you show it to them. And this is not to impugn anybody because you need to have different types to do the job. And a lot of people take advantage in a system as well. But sometimes a judge is going to really want to know why this wasn't brought up in the first place from the original lawyer. And to have the lawyer say, I didn't bring it up because it wasn't going to work in that courthouse at that time. We had just had a big case in that courthouse that made everybody really upset. And if you brought up this kind of excuse, it would backlash. And we made a strategic decision. We're not going to bring that up. Or this person was sitting in jail and they weren't earning any earned time credit. And if they plead out and they get sentenced, it was a 1-year offer. They'll be out of jail and they'll be able to get back to their life again. But if we have to go and get a psychiatric evaluation showing that they were abused, that'll take 6 months and they won't earn any earned time credit. And even if they get a better offer, they'll have already served a year in jail. So it's not worth it to go into that. But, you know, and then they get a violation of probation. Now they're in jail for 10 years. But anyway, so like, we want to, it's good to know why it didn't come up. I mean, sometimes it's not going to help my client, frankly, that you know, it's going to be bad. It's, you know, the lawyer didn't believe it or, you know, or whatever, but it's context.
I would hope that the reviewing court would ask that question if it's relevant. So, but thank you for coming here today. Nice to see you.
Further questions or comments? If not, Alex, thanks for being with us.
Thank you.
All right, I think we're up to Randall Chinook.
Good afternoon, leadership and members of the Judiciary Committee. My name is Randall Chinook. I'm the founder of the Connecticut Second Look Sentencing Project. Founded the organization in 2023 to advocate for legislative changes in Connecticut that would accelerate decarceration. I'm going to deviate from what I was going to say today because everybody before me has made most of my points and more eloquently than I think I would have made them. So I'm instead going to respond to a couple of things that I heard in the room today in two areas. A lot of it derives from the change in application frequency from either 3 or 5 years to 2 years. So, and there's two components to that. One is the effect on victims, and one is the effect on the system that could cause. So, of course, we're all compassionate about victims, as we should be, and any change in law should consider any impact that there might be on victims. That being said, State's Attorney Doyle this morning said that if there were the possibility of applications every 2 years, victims would be required, a quote, to appear in court every time. He knows very well that's not correct. They have the choice to appear, to submit a statement, or do nothing. So I want that to be corrected. Further, regarding notification, I believe that it has been established or it's being discussed in the branch, not quite sure of the status, to notify victims, not necessarily when an application is submitted for sentence mod, but only when a hearing is scheduled. Let fewer than half of the applications receive a hearing. And so this would reduce notifications to victims by half right there. And I'm not sure where that stands, but it's something that could be advocated for with the branch. There's much further discussion about the impact on victims in the written testimony from the sentencing project. I'd like to point you to pages 7 to 8. They really discuss this eloquently. The other aspect is the impact on the system. And 5 years is 1,824 days. That's an awful lot of days to wake up in an 8x10 cell trying to maintain hope that you'll get another sentence modification hearing. 2 years is still 730 days of waiting. And just because some people aren't ready after 2 years doesn't mean that nobody should have that opportunity. Mr. Salters said it very eloquently this morning, you can be ready and still be denied. So I'll wrap it up to say that it is inhumane to focus more on theoretical impacts to the system than it is to the very real positive impact that 1327 can have on the incarcerated and their loved ones. Thank you.
Questions from the committee? Representative Howard.
Thank you, Mr. Chairman. Thank you, sir. I just, thank you for mentioning the victim part. I want to just drill down on that. So I appreciate what you said, that the victim is only notified when there's going to be a hearing, right? And that a majority of them don't go to hearing. But this language would change that, wouldn't it? Because under existing law, it says that during the period, upon agreement of the defendant and the state's attorney to seek review, but that's coming out. And now it says, at the time the defendant, or would say, at the time the defendant files an application with the court, the defendant shall provide the state with a copy and materials, and not later than 90 days after receipt, the sentencing court shall schedule a hearing. So that's a significant change, because your representation was, well, what I heard basically was, I wouldn't worry about the victims too much because most times they don't go to hearing, which is probably true currently, but this would change that. Everything would go to a hearing, wouldn't it?
I don't believe that that is the intent of that language. The intent of the 90-day notification was to ensure that the applicant is informed promptly. Notice is, I think notice to the state's attorney's office is unchanged.
So,
I'm sorry, go ahead.
So correct me then, because I'm in line 43.
I'm sorry, I don't have the numbered
Okay.
version here.
All right, I'm in what's going to be the new sub D, and I'll read it to you.
Okay.
It says, at the time the defendant files an application with the court, the defendant shall provide the state with a copy of the application and any materials and documentation filed with the court in support of such application. Then it says this, not later than 90 days after the receipt of the application, the sentencing court or a judge shall schedule a hearing on the application or may reject it only on technical grounds.
Mhm.
So you interpret that to mean that the court has 90 days to respond and not schedule a hearing?
Correct.
So the words, the court shall schedule a hearing, you don't interpret
Shall
as,
docket a hearing, yes, shall put it on the docket within 90 days. That's correct.
right, and that's not current language, that was proposed.
That's correct.
So would you agree with me then that even while today, most applications don't go to a hearing and the victim doesn't need to be notified, this would significantly change that?
That is not my interpretation of what this means.
Okay, thank you.
Further questions or comments from committee? Not. Thanks for being with us.
Thank you all.
Heriberto De Leon.
He's here.
Good afternoon, co-chairs, Senator Winfield, Representative Strafstrom, Representative Fishbein, Senator Kissel, and members of the Joint Committee on Judiciary. My name is Heriberto De Leon Jr. I reside in the town of Bloomfield, and I am here in support of SB 1327, and that concerning the reduction of a sentence by a sentencing court or judge. I am honored and humbled to be here today, standing before you to fulfill a long dream of participating in my civic duty as a resident of Connecticut. I am in support of SB 1327. Today I speak of lived experience. I was incarcerated for 32 years and 9 months. I have been home for approximately 11 months and 17 days. I'm a canvasser and organizer with the Full Citizens Coalition. I'm currently full-time at Capital Community College, striving to attain my associate degree in social work with the goal of getting my LCSW and double majoring in policy or justice reform. With that said, I am one of the lucky ones, as I stated in my opinion piece that was published in the Harvard Current, which I submitted as testimony today. All I ask is that this committee take in consideration that people serving long sentences are not the same people decades later. I am proof that, and I bear witness to many transformations in prison. I would not be the person I am today without the guidance and support of those prisoners who found their own transformations way before I was warehoused to a prison cell. Throughout my incarceration, I met amazing people who had defied the expectations of their criminal history. These individuals were committed and achieved deep transformation, yet they were repeatedly denied a chance to be evaluated at their present selves. The handful who were lucky like me are home today, and they have been a huge support and inspiration on who I want to be, and only reinforces my dream to be a full citizen. In saying that, I walked out of prison that day grateful for that second chance, but I also feel guilty about leaving those. I truly feel have made a transformation and deserve to be heard, and also want to participate in their civic duty in being a full citizen also, to mend the harm they cause in their communities. I believe this process can be achieved with this bill by reevaluating people as they are today and not in the time that they committed their crimes. Thank you.
Thank you, sir. Questions or comments from committee? Representative Howard.
Thank you. Just one quick comment, Mr. Chairman, for my colleagues. Eddie, welcome. It's really great to see you. I first met Eddie at one of my visits to the True Unit at Cheshire Correctional. In fact, actually, it was my very first visit. And you showed me around. You taught me what True was. You showed me what was going on down there. And I just want to say for the record and everybody listening, your story is a success story through and through. I was impressed with you that day. It means a lot to me to be sitting here with you and have you in this building. I don't know, if your success story is representative of the majority of people that go through there or not, but yours truly stands apart. And from meeting you and to hear today, I'm certainly proud of the journey that you've been on. And you didn't note it, but I will. Many of the people that you said you left there are people that you influence in a positive way. I don't know what that number is, but I'm sure it's quite high. I got that from my experience there with you. So I just wanted to say that. And for you and for my colleagues, that you definitely are a success story when it comes to our correction system in the state of Connecticut. Thank you, Mr. Chairman.
Further questions or comments? If not, thank you, sir, for your advocacy and for your work. Paul Atkin.
Hello, members of the committee. My name is Paul Atkin. I've been a resident of Norwalk, Connecticut for most of my life. I'm on the registry for an out-of-state conviction. I'm here in support of Senate Bill 1500. I'm a small business owner and a homeowner and a Norwalk, Connecticut property taxpayer. I've lived in the same house and have been registered with the state police there for over 17 years. As important as it is to pass this bill for homeless and institutional registrants and others, I have an issue that I'd like you to consider regarding this. Every 3 months, my anxiety level becomes almost unmanageable as I wait for my quarterly mail from DPS. I use the Postal Service Informed Delivery app and go to my mailbox as soon as I see the delivery is made. This allows me to quickly return the letter and verify my longstanding address, which covers the legal part of the process that I have complete control over. However, what happens if I never receive the letter? What if the Postal Service employee or a potential third party, if the Postal Service is privatized, has something against me or my class of person? Or if the letter falls off the sorting belt into a corner of the facility, or the postal truck has an accident, or thieves or vigilantes target my mailbox on the street, and thus I never received the original verification letter, I'll be charged with a felony and potentially in prison for a lack of response for something that I never received, which was totally out of my control. Speaking of strict liability, how can I be held responsible for a felony if the system to get me the notification is not foolproof? It's terrifying to know that every 3 months I'm at risk of being charged for a felony for the crime of not receiving my mail. I have 3 employees in Connecticut and many clients whose lives and businesses would also be disrupted if I were to experience this misfortune without my fault. In the 16 plus years I've been registering in Connecticut, that's 65 quarterly letters. I've had several experiences with lost return letters back to Middletown. One letter took 16 days to get from Norwalk to Middletown. Meanwhile, I was marked as non-compliant on the registry page. DPS told me to wait for a second violation letter to arrive. When I called on day 16, I was told my original return letter had finally arrived. They marked me as compliant because the postmark was in 10 days as required by the current law. But CSP stated that I was still at risk for arrest and prosecution by my local jurisdiction because even though the issue was resolved as far as the state was concerned, the local police still had the right to arrest me for the violation. Fortunately, nothing has come of that yet. Another negative experience noted in my written testimony, after another negative experience, I moved to a more costly and reliable option, FedEx. This worked smoothly for several years until my most recent verification this year, where my overnight envelope was misrouted by FedEx to a location in Western Massachusetts. After days of tracing, I saw the letter was finally delivered and signed within the time limit. But remember, the 10 days they give aren't 10 business days, so there's even a smaller delivery window if there are holidays or weekends. This bill, by increasing the deadline from 10 days to 20 days and reducing the penalty of conviction to an infraction in most instances and require that the state prove in criminal intent, basically eliminating strict liability. In other words, I have no control. How can I be held responsible for a felony if the system to get me notification is not foolproof? I hope that this will mitigate this loophole. I ask that you vote to pass Senate Bill 1500. Thank you for your time.
Thank you, sir. Questions from committee, Representative Fishman.
Thank you, Mr. Chairman. Thank you, sir, for coming here today.
Thank you, Representative.
I learned a lot about this process today. You know, I agree with you. You know, it's a fundamental portion of criminal jurisprudence that in order to be convicted, you must have found to have had the mens rea. That's the term, right? To have committed the crime.
Right.
I guess the situation here is that innocent individuals convicted of a different crime are potentially entrapped into becoming convicted felons. So I do agree. I would, this system, as I'm hearing about it, makes absolutely no sense to me. So, you know, I look forward to, we got a lot of bills this session.
Yes.
I think there's some things that we can do, as long as there's cooperation at all levels of government to try and make this easier and to prevent individuals from being wrongfully convicted because they didn't have the mens rea. So I very much appreciate you coming here today. So thank you.
Thank you. Yeah, if you can work on the front end, because I think we forget that. We're responsible, I'm responsible for a postal service activity, and things are not doing so great with them these days. So it's
Amen.
really,
Yeah.
so and I'm glad to speak with you, you know, one-on-one or anybody also at some point if you have time.
I think we got it.
All right.
Thank you.
Thanks.
Mr. Chairman.
Thanks.
Thank you very much.
Appreciate it.
All right, Kaylee Romanos? Romanos? Okay, Amber Lengus?
Hello there, can you hear me?
Yes, ma'am, go ahead.
Thank you very much. Good afternoon, Representative Staffstrom, ranking members, Kissel, Representative Fishbein, and the esteemed members of the Judiciary Committee. I really want to thank you for all your time and attention today. My name is Amber Valangas. I'm a resident of the 108th Congressional District and 30th Senate District in Connecticut. I'm a crime survivor, civil liberties activist, Marine Corps veteran, and a mother of 4 who currently serves as the executive director of Restorative Action Alliance. We are a regional organization that seeks to end cycles of sexual violence without the use of counterproductive state policies like registries that perpetuate harm and strip people of their civil liberties. We work with both survivors and those who have caused harm or been swept into the criminal legal system. We are looking to work towards hope and healing for everyone. I'm here today in support of SB 1500 and also SB 1502. And I just want to state in terms of SB 1502, Domestic Violence Survivors Justice Act, we fully support this bill because we understand the nuances of cycles of violence and how violence of any kind, domestic violence, sexual violence, is really individualized to each person. So this bill gives the opportunity for consideration on an individualized level, connecting factors to the commission of a crime and providing opportunity for those things to be considered. I want to move to SB 1500 because every 3 months in my home, a letter arrives in our mailbox. It's just a piece of paper, but it carries the weight of a felony charge for my loved one who is required to register if it's not returned within 10 days. My loved one is required to verify his address with the state, as you've heard again and again today. And if that letter isn't received in time, no matter the reason, he could be taken from our family after we've done a lot of work to rebuild after his return from incarceration. This makes little sense, considering he is also currently on probation and an officer comes to our home every other month to make sure that he still resides here. A few months ago, while my loved one was away for a few days legally taking care of his mother with all the proper permissions, I drove up our dirt road in rural Connecticut to get the mail with my 11-year-old son. Like any other day, he jumped out, grabbed the bundle of letters, and stuffed them into the seat pocket of the car. We drove home. In there were bills, junk mail, political flyers, some from folks who actually sit on this committee, and it was all mixed in. This verification letter was there. He was focused on his homework, his gym bag, whatever was on his mind that day. I was focused on getting through another long afternoon, what I needed to prepare for my work with the ACLU the next day, dinner plans, etc. The mail was forgotten. 2 days later, I found it while unloading groceries. My stomach dropped and my hands started shaking. That single piece of paper sitting there crumpled under a grocery bag was a time bomb. If I hadn't noticed it, if a
Ma'am, I
few
don't know
more
if you
days
can
had
hear it.
passed, my loved one could have been charged with a felony and taken from our lives again.
Amber.
After all of the years, all the work that we do, we have been in compliance and rebuilding our lives.
Thank you.
And this is not for harming it.
Thank you. That was the bell. That was the bell some time ago. So thank you very much. Questions or comments from the committee? Questions or comments? If not, thank you for taking the time to share that story with us. Manny Sandoval will be next. All right. James Jeter.
Good afternoon. Good afternoon to the co-chairs, Staffstrom, Winfield, and ranking members Fishbein and Kissel, vice chairs Fasino, Flexer, Gagger Wilcox, members of the Joint Committee on Judiciary. I'm here testifying today in support of SB 1327, SB 1502, and SB 1500. Before I start, I just want to say that due to several members of this committee, there have been huge strides in reform and rights protections over the course of a very short span. And I just want to acknowledge that while saying there's still so much more work to be done. I'm opening up with a quote, and this quote is important to me because of the work I do and the research we do and the impact that it's had in our communities. The quote is, "Let me define the liberal wing of the Democratic Party. The liberal wing of the Democratic Party is now for 60 new death penalties. This is what is in this bill. The liberal wing of the Democratic Party has 70 enhanced penalties. The liberal wing of the Democratic Party is for 100,000 cops. The liberal wing of the Democratic Party is for 125,000 new state prison cells." This is Joe Biden, August 24th, 1994. This was one of the most savage bipartisan piece of legislation to ever come across our nation, written by a Republican senator and endorsed by a Democratic Party. The weight of the 94 crime bill has yet to been weighed over the last 30 years. The impact and rollout of what this bill has done, it is the first piece of legislation since emancipation that is strictly built around Black pubescent bodies. It incriminates at the age of puberty the idea that the language of the super predator youth, which was debunked and which was co-opted politically, it was an academic theory that said that what communities needed were far more resources in these children's lives, that they needed men, that they needed, the government needed to fund churches, mosques, the Boys and Girls Clubs, the Ys, far more than they were to stay a pending generation. That never came. But when co-opted, that language became the fodder to incarcerate at an exacerbated pace and to over-sentence and to ignore all ages and all factors. The ignorance of factors is in this speech, in this floor speech. What it has done to our country and to our state, by the early 2000s, we were second or third in the nation in incarceration per capita. And we've made great strides, but we're still dealing with the ramifications from that era, and it has affected all areas of law. And the reason why I support these bills is because many of times, if you look at the culture of prosecution during those eras, a lot of those prosecutors are now judges. The same judges people are going before for modifications. I've worked on over 100. All right. Thank you.
Thank you. Questions from the committee? If not, thanks for taking the time to stick with us today. Appreciate it. Angelie Pathmanathan?
Hi, good afternoon. I'm online. Can you hear me?
Yep, go ahead, ma'am.
Thank you very much, Representative Staffstrom and the esteemed members of this committee for the opportunity to speak to you in support of SB 1502. My name is Angelie Pathmanathan, and I am the supervising attorney of the Criminal Justice Advocacy Clinic, the Jerome and Frank Legal Services Organization at Yale Law School. I'm testifying in support of this bill on behalf of the students of the clinic and based on my experience as an attorney in New York for many years and now in Connecticut. I do not speak for the university. Our clinic believes that SB 1502 is necessary to provide incarcerated survivors of domestic violence, sexual assault, stalking, and human trafficking the formal opportunity to seek trauma-informed sentencing relief in Connecticut. While many of us in this forum may understand the impact that surviving such abuse has on a person's actions and decision-making, that understanding is not universal. This bill, we believe, provides a mechanism to educate the public, legal advocates, sentencing and parole decision makers, and incarcerated individuals that someone's experience of domestic violence, sexual assault, stalking, and/or human trafficking should be considered a mitigating factor when a sentencing judge or the parole board decides what is the most just and proportionate sentence for the crime committed. We also understand that people do not necessarily know that their survivorship of abuse contributed to their criminal conduct at the moment of their crime, at the time of their arrest, or even during their prosecution. Oftentimes, individuals only come to understand that the trauma they experienced before their crime contributed to their decision-making and criminal activity long after they've been sentenced, once they've had the time and the space from their abuser to engage in therapeutic programming, counseling, deep reflection of how their abusive relationship shaped their choices and their options at the time of the crime and afterwards. For this reason, our clinic maintains that SB 1502 should offer people the opportunity to seek trauma-informed sentencing relief when they are ready and have the evidence to show that their experience of abuse, whether that be at the person's initial sentencing proceeding or at a resentencing hearing or parole or commutation application down the road, whether that experience contributed to their criminal offense. Finally, I just want to highlight that SB 1502 does not add any additional types of sentencing, parole, or commutation hearings in Connecticut's existing procedures, nor does it take away the sentencing judge's or the parole board's ultimate discretion to decide whether the person's evidence of survivorship warrants consideration and justifies a lower sentence, commutation, or release on parole. Instead, SB 1502 only seeks to, one, formalize the types of evidence a person needs to provide to those decision makers to prove that their experience of abuse contributed to their criminal conduct, and two, offer guideposts for the decision maker to determine whether sentencing relief is appropriate for the particular individual based on all the evidence presented at the respective hearing. For all these reasons, our clinic respectfully asks that the committee vote in favor of SB 1502 to provide necessary and overdue sentencing relief to incarcerated survivors in Connecticut. I welcome your questions.
Thank you. Questions or comments from the committee? Questions or comments? If not, thanks for being with us.
Thank you.
Marilyn Vashi?
Vache, yes, thank you.
Thank you. Go ahead, ma'am.
Thank you for giving us the time today. I'm testifying as a member of the Religious Society of Friends, which is who are known as Quakers. I'm guided, I and the others in my meeting in New London are guided by the belief that there is that of God in everyone. This belief has led Quakers throughout history to work for justice in many arenas, even unpopular ones. In this tradition, I and the others in New London Friends meeting are working to end injustices in the systems that, while intending to prevent sexual harm, are ineffective, unjust, and burdensome to administer. Connecticut SB 1500 offers a small but important step in this direction. So you've heard already from others about how this bill might modernize the process for people to keep up with the state requirements, to notify the state of their address changes and confirm their address every 3 months. You've learned that at the current time, they only have 10 days from the postmarked letter from DESPP to get the letter back, and that this would extend that to 20 days. And it would probably save the state a good deal of money because currently there's as many as 200 cases that go to the courtroom as well. You've heard that there is irregular, inconsistent enforcement, and that this impacts our homeless citizens disproportionately. I'm going to go off script to address a couple of questions that came up. In particular, the question of, well, maybe we should still keep it a felony because, if I understood this, because we're going to make, if the bill goes through, we can make it so much easier for people to register. Well, I want to add that I'm a retired psychiatrist, and I can tell you there are so many people who don't open their mail because of their mental illness. They are acutely depressed, they're acutely manic, they're psychotic, and this is a population that has high levels of mental illness. So I think in addition to all the other reasons for you to move this bill forward and support it in the legislature is the understanding that this is an extraordinary burden for many people. You heard from Amber, just an ordinary middle-class family, it can be quite a burden. And for people who are severely ill, all the worse for them. So seeing that current laws regarding sexual offenses don't further public safety, can cause harm to those who have already completed their sentences, and adds to taxpayer burden, I ask you to support SB 1500 as it moves through your committee and through the legislature. Thank you, and I'm happy to take questions.
Thank you, ma'am. Questions from the committee? Seeing none, appreciate you being with us.
Thank you.
Shannon Coulter.
Good afternoon, Representative Staffstrom and venerable members of the Judiciary Committee. My name is Shannon Coulter. I'm a policy graduate student at the University of Connecticut School of Social Work. Today, I'm here to testify in strong support of SB 1502, which would bring trauma-informed sentencing to survivors of gender-based violence in Connecticut. For the last 6 months, I've had the privilege of contributing to the work of the Connecticut Coalition Against Domestic Violence. During this time, I have researched how DVSJA laws like SB 1502 have been implemented in other states. In the course of this work, I've talked with both advocates and opponents of this law. I've talked to congresspeople and incarcerated people. I've talked with survivors and sentencers. What I've learned is that there are decision makers within the justice system who very much wanted to consider a defendant's experience of domestic violence when determining a sentence, and they were unable to do so due to mandatory minimum laws. So I support SB 1502 because it puts control where control belongs, in the hands of judges. I looked at all the data from New York, and in 6 years, across all 63 counties in New York, just 154 DVSJA motions total have been filed on behalf of incarcerated survivors there. So SB 1502 is not a get out of jail free card. It is not a second bite at the apple. SB 1502 is about two things. It's about making gender-based violence more consistently visible in the law, and it's about getting sentencing right. DVSJ cases are uniquely complex. They often defy neat categorizations of victim and offender. I suspect this complexity is why, in New York, DVSJ cases, 74% of prosecutors consented to the judge's sentence modification. I'll repeat that, 74% of prosecutors consented to judges' sentence modifications. We know this law works. It's already helping survivors in other states, and thanks to all the stakeholders who were so generous in sharing their knowledge with us, we have an opportunity to ensure that it works even better here in Connecticut. Thank you for considering this legislation. I welcome any questions.
Thank you. Questions from Committee Rep Fishman?
Thank you, Mr. Chairman. I think you've been here all day listening to all this about 1502. Something came to mind. What if a judge in sentencing originally took these factors into consideration? What's to protect the system from double dipping?
I think what we've heard from stakeholders within the criminal justice system is that they are often unable to take these factors into consideration.
No, there's nobody who's come before us who's actually been in a court. Mr. Taubes, I think, was the only person, and he recognized that sometimes these things are presented and they are considered. I think everyone else was outside of the area. I'm just looking at what's to prevent that from happening. I mean, there's a pre-sentencing report that's done that many times talks about the upbringing of the individual, let's just say that they were homeless for their upbringing, that that they had a very troubled youth and all of that stuff. And under our present statutes, judges are supposed to take those things into consideration with their discretion. victim of domestic violence is mentioned, you know, the person had to get a series of restraining orders, criminal protective orders, all of that stuff. And the judge in their sentencing considers that. Doesn't expressly says it on the record, but it's all part of that mosaic, right? How do we prevent through this language, because it doesn't appear that there's any bar, how do we prevent the double dipping?
I'm not sure what you mean by double dipping, but I will say that aside from the fact that the DVSJ would untie the hands of judges in the state of Connecticut, it also, it allow them to consider the full context of an offense, whereas they can't necessarily do that right now. I would say that the DVSJ's good policy in some of the same ways that the raise the age legislation for young offenders is good policy, in the same way that HB 6657, which acknowledges the way some trafficked individuals are coerced into crimes, is good policy. Similarly, Connecticut's employment, housing, and credit laws make special considerations for survivors of domestic violence, and I think it's time that the criminal law caught up.
I understand your position. So thank you, Mr. Chairman.
Thank you. Further questions or comments? Further questions or comments? If not, thanks for being with us.
Thank you.
Okay, next we'll hear from Donna Hirschko. Hope I got that right.
Good afternoon, everyone. My name is Donna Orsisko. I have the honor of reading you this testimony from an incarcerated individual. As an inmate in the state of Connecticut, I'm housed in a correctional facility operated by the Department of Corrections. If that mission is true to the name, that the goal of incarceration must be the correction of inmates, as it is in many European countries who focus on correction instead of purely punitive measures, and as a result have much lower rate of reactivism in conjunction with much shorter prison sentences, which eases the burden on their prison systems and saves the taxpayers money. Having been incarcerated for nearly 5 years now, I can attest firsthand that the state of Connecticut has a long way in regards to their system of corrections. Simply ignoring this problem with the hope it will go away or pushing it off for a later date will not help the situation and likely make it worse. Inmates should be given an idea to strive for their day-to-day struggles with incarceration so as to improve themselves instead of just waiting out their sentences. However, they can then get right back to their old ways once released. Potentially having a sentence modified below the statutory minimum based on ideal behavior and conduct progression like SB 1327 would do just that. Additionally, by restricting the ability for an inmate to reapply for a sentence modification for longer than 2 years only means inmates not successfully with their first appeal would no longer have something to strive for to improve their behavior and conduct. Finally, a plea agreement is essentially an admission of guilt on incarcerated, should not be penalized for admitting their guilt by having to get approval from a single, potentially biased state attorney with conflicting interest in order to apply a sentence modification. Improved conditions at correctional facilities for inmates, correction officers, and staff members are sure to follow with the passing of SB 1327 and others like it. The year is 2025, and the Connecticut system of correction needs to catch up to modern times, and that starts with the state legislature. As a closing note, I would like to say I used the words like inmate many times throughout this testimony, but it is essential we all remember this is not all we are. We are human, still worthy of regard, with friends and family that love us. Please give us and them your genuine consideration. Kindest regards, Peter Mafrandonia.
Thank you, Ms. Shishko. Comment, question from members of the committee. Comment, question from members of, and I hope I didn't butcher your name. There are no comments or questions. Thank you very much for joining us this afternoon.
Thank you.
Gus Marks Hamilton.
Good afternoon, Senator Winfield, Representative Staffstrom, Representative Fazino, and Representative Fishbein. My name is Gus Marks Hamilton, and I'm the campaign manager with the ACLU of Connecticut Smart Justice Campaign. I'm going to briefly try to sum up our testimony on 3 of the bills that you have already heard a great deal about today, Senate Bill 1502, Senate Bill 1327, and Senate Bill 1500. First, Senate Bill 1502 would allow survivors of domestic violence, stalking, sexual assault, and trafficking who were incarcerated as a result of their actions related to their abuse an opportunity for sentence modification, parole, or commutation hearing. It would also allow judicial discretion for future cases that would otherwise require a mandatory minimum sentence be applied. SB 1502 will help the law align with the lived experiences of survivors by recognizing that there are many reasons why a person's experiences of survivorship may be minimized or obscured within the criminal legal system. Senate Bill 1327 would also expand Connecticut's modification process by allowing people who are serving mandatory minimum sentences to petition for modification and remove the requirement that the state's attorneys consent to a modification hearing in certain plea deal cases. The majority of people serving life sentences in our state were young adults when they first became entangled in our criminal legal system. About 52% of those young adults were under the age of 25. 54% of the people serving life sentences here in Connecticut are Black, and people of color in general account for 71% of life without parole sentences in Connecticut. I think it's important to note that this bill does not automatically give anyone a sentence modification, but does allow people who are serving their sentences the opportunity to apply and demonstrate their growth and change. Finally, people should not be criminalized because of late or lost mail. House Bill 1500 would increase the number of days a person on the registry must verify their address by mail from 10 to 20 days and adds the ability to request a second letter if lost. The bill would also allow people to call the Department of Emergency Services and Public Protection to confirm their location rather than rely on mail. Finally, the bill would require intent for a felony charge, reducing the penalty for a late letter to an infraction if there is no intent to deceive the state. Because of these reasons, I urge everyone to support these 3 bills and appreciate the opportunity to give testimony today.
Thank you. Comment, question from members of the committee. Comment or question from members of the committee. Seeing none, thank you for joining us again. Anderson Curtis, welcome back.
Good evening, members of the Judiciary Committee, Chairman Winfield, Chairman Staffrom, Representative Fishbein, Representative Fazino. Did you guys set this up that we go back to back today? This is how we'll host.
Look at it.
Anyway, I'm here to testify in support of Senate Bill 1327. My name is Anderson Curtis. I'm the Senior Policy Organizer at the ACLU of Connecticut. You've heard many things talked about this bill today. I'm just going to hit on a few bullet points, and I have a couple things I'd like to say about it. The proposed bill amendment would revise the statute, remove the requirement for consent of the state's attorney for the sentence modification hearing when there was a plea deal. Allow courts to modify sentences below mandatory minimums. Require the docket of hearing or reject application on technical grounds within 90 days. To decide the case within 30 days of hearing, to provide a decision to the defendant within 45 days of the hearing, to the state the reasons for the decision. The application is rejected on technical grounds, such missing information or signature, provide an applicant with reasons for the rejection, allowing an amended application to be filed upon notice of rejection. If the application is denied in full, reducing the filing time from 5 to 2 years. The application is denied in part, reducing it from 3 to 2 years. 1,542 people become eligible for modification if this is passed. That is 23% of the population of Connecticut of incarcerated people as of 12/29/24. Now that's all the technical stuff, right? I'm here to talk about what does that look like? You know, how long is enough? You know, how long do people have to sit there? Like, I'm not taking anything away from the victims, Representative Howard. You know, I understand that they have that, right? I have victims in my own cases. My ex-wife was one, you know. By the grace of God, I was able to turn my life around and show her some things that I was not able to show them our children, but I did with my grandchildren. And when the pardon board contacted her, she said yes to the pardon. How long is enough? A few weeks ago, they were in here with the juvenile justice people, and I had a young man talking on a song. And he sentences some serious time as a young person. And I remember a line he said in the song that he was hoping for hope. You know? And so all I'm trying to say is that what does the scales of balance of justice really look like here today? Right? Sentencing these people to 40, 50 years, you know, what is that going to prove? And I'm not denying that the victim has input. Of course they have an input in this, right? But people can change, is my point. People can change, and they have an opportunity to come home one day and demonstrate that change. And hopefully this bill will open up the door for some people to do that. Thank you very much.
Thank you. Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon. Mr. Anderson or Mr. Curtis? It's Mr. Curtis.
Curtis is my last name. Anderson is my first name.
There you go.
It's one of those names you can flip around, you know?
I know, and I always get confused, right?
Yeah.
Have you ever been a victim of crime?
Myself?
Yeah.
Oh, yeah.
And the person who perpetrated that, was they arrested?
No, it was not reported. It was actually when I was incarcerated. And I was about 3 weeks from coming home, and somebody didn't want me to leave, and they punched me in my face. My whole face was swollen.
Yeah, sorry to hear that.
Yeah.
But you say you didn't report it.
Well, you know, I was trying to come home.
Yeah, no, I got it.
Yeah, yeah.
That's always used against you if you got into
You
a
never know.
fracas.
You never know what's going. You know what I mean? Like I had a date, and like I wasn't going to play with that. You know what I mean? But as far as
Outside, have you ever-
outside, you know, not necessarily a crime. Have I been a victim of the circumstances of my actions of crimes? Oh yeah. Have I paid the price of those consequences? Many times.
No, I understand. I just, we've heard a lot today from people that have been incarcerated, people that are standing up for people that have been incarcerated.
Right.
It's just, I've been a victim of crime.
Right.
And when the individual was arrested and the case went through court and they got the sentence that they got, in here, I had a sense of closure.
Okay. Okay.
And, because it was wrapped up. The justice system did its job. Whether or not I agreed with the sentence, totally different issue, right?
Okay.
But that's the process.
Right.
And I think the thing that's missing from part of what we're discussing here today is a lot of the stuff that we're talking about is reopening those things. I understand, because, I've had family members that have been incarcerated a very long time, and I got that.
Mm-hmm.
But, when you're shifting the sentence modification, you're going from 5 years to 2 years, when you're allowing for even more sentence modifications, the victims are concerned. I would be concerned if my case got reopened, and especially if it was a family member was murdered, right? And
right.
The murderer is put away for 50 years.
Yep.
And, as we heard earlier today, you have the commutation process, right? So
Right.
now the individual under a law can go through the commutation process, and as the victim family member, be part of that process. And I'd be disappointed, sentence gets reduced to 40 years. And then under another sentence modification process that we already presently have, it can get reduced again. And then that can happen under 1327 every 2 years. Wow. Do you understand how that could be harmful on the victim side?
I totally get that.
So what?
I
so
totally get that.
we just shifted this to the 5-year thing, like 2021, I think.
Okay.
So what is enough? Because it seems to be incremental here,
Right.
right?
Right.
Is one, I mean, and I'm not trying to be, you're up here a lot. We see each other
Daily, pretty much.
almost
Yeah.
daily,
Yeah.
right?
Right. Yeah.
So
Yeah.
you're like family.
Yeah.
'cause, you
I
know,
understand. Yeah.
what is the goal?
Well, from my stand, the goal is not to diminish the pain of the victim. The goal is not to push that to the side, right? The goal is to try to create a balance, right, where we all can live and have some opportunity for some people who have demonstrated some change, right? So now I'm talking about Mr. Salters talked earlier, a person who has demonstrated change, has done their due diligence to put the work in. Because it takes work to change. It doesn't happen overnight, right? I have an uncle who talks about, truth must be lived before it could be proclaimed. And I truly believe that. I'm not saying that everybody's going to be ready for a sentence modification. I'm not saying that everybody who submits one is going to be ready. But I'm saying there are some people who have worked their butts off to do that. And I also know that there's some people who may never get over being a victim of a crime. I could see that too, right? Because I came up here, I was just here talking about last week about the trauma of getting pulled over. I still deal with that trauma. I have trauma I deal with.
Would you be supportive of a system that allows fellow inmates? I'm just thinking outside the box.
Right.
Right?
Right.
To review applications for possible sentence modification, like it's sort of like a gatekeeper sort of situation. Because I agree, people improve. But
Right, right,
if somebody hasn't proven that they have changed, they're not going to be harmful, if their sentence is reduced.
And who would know better than the people who live with them every day?
Amen.
Right? Is that where you're going with that?
Well, that's part of it, because if you haven't proven it, 2 years is not a very long period of time, right? To get it. And I'm just trying to figure out a system where, as you talk about the balance,
Right.
right? And nobody's suggested that. But, we've got some great people on the True Unit, and there's other units in our prisons that, recognize the bad guys
Right.
and try and herald the good guys.
Right.
Right. And
Right.
it's those good guys that should
be
part of the process.
Right.
But I appreciate the exchange.
Yeah.
So thank you, Mr.
So
Chairman.
can I just say something about
Yeah.
So let's just throw the balance on that. Let's just call it the review board, for lack of a better word, right? I think it would have to be a balance of people, right? People like yourselves, lawmakers, some people who may have been victims, and some people who have seen people who are incarcerated go through their change process, right? So that all things coming into this conversation are in play when the decision is made, okay?
Doesn't that, well, finish, please.
I remember when we first started and we were going to do prosecutor accountability, one of the first people we met with was Representative Pettit of Cheshire. What is his input? How does he feel about it? The victim advocate office, right? Because we wanted their input into our bill, right? What is this going to look like when it's actually operationalized? So there's questions like what is fair, what is balance, who has the input. I'm not saying anybody's pain is greater than anybody else's, but there's a lot of pain out there right now. And what I'm trying to do is hopefully push this bill that there could be some hope to some people who are in some dark places. Because prison, 2 years, 2 days in prison is a long time. A lot can happen. Some people might not make it out, right? And so there's a consequence. There's living with your consequence. There's putting the change into effect in your life. I didn't begin to change in my own personal life. I only got tired. My parents walked up and down my back for years to get me to change. Long suffering, my mother and father, but they stayed on me because they wanted me to come back to what? The values that they raised me with. And they made sure of that. Now, I'm not saying everybody has that. I'm just talking about my case. You know what I mean? And even with all that, it takes time. You know, and so it takes time to even begin considering the change. It takes time to put that change into effect, and it also takes time for people to heal.
Yeah, no, amen to that. You know, part of the problem that I have with the process, these many resentencing avenues,
Yeah,
is it doesn't require, and I'm not suggesting this, but I'm just putting it into perspective,
yeah,
that the same judge who made the sentence does the resentencing. You know, that's a whole nother aspect. You know, because that's the person that was actually there who heard all that testimony, perhaps the reaction from the witnesses and the crowd, and is swept up in the actual adjudication of that case. You got somebody who's totally foreign
right,
to that,
right,
you know, that
Right.
doesn't have that
Right.
perspective. But anyway,
right.
I appreciate the exchange. Thank you, and nice to see you again.
Thank you. You're welcome.
Thank you, Representative Fishbone. Comment or question for members of the committee. Comment or question. I'll just say this. I think these conversations are very multi-layered. There's some folks who are victims and have no expectation to get anything out of our system. I've been a victim of crime more times than I have fingers, and I think maybe even toes combined. And where, at least for many of those, the situation I was in terms of where I lived and what the expectations in those spaces were, crime happens, you move on. That's just the expectation. Should not be the expectation, but it is, right? And so I think sometimes we talk about victims in a way that I don't think is inclusive of all victims, because some people are it's just expected that crime is a part of the experience of your life, and you move on. When I was a kid, I'd go outside. Sometimes the car would be going, oh, I guess we're not going to school today. And we keep rocking on, right? Like
Right,
little
right,
kids,
right.
because it was part of the
Right.
experience. I'd get up. Sometimes we didn't have a television in the house, and it's not like we could put that back in. As an adult, I've had the windows busted out of my car and some of the other things that I know you know
You
about.
know what happened to you?
Right.
Yeah, yeah.
Some really bad things.
Mm-hmm.
But I just say that to say that victims aren't one thing, just like the people who've committed crimes aren't one thing. And I don't think they all have the same expectations. And so we should just always carry that with us as we have these conversations. I just want to say one more thing since you're sitting there. We're talking about people's ability to change. And as I look at you and listen to the really good exchange between you and Representative Fishbone, I think about when I first met you. And your sense that you might not be ready for this whole process and all of that. And then I listen to how profound you are and how important you are to the conversations we have. And I think it's incumbent upon me to let you know just how much you impact me. So
Thank you.
thank you for being
Are you
with
talking
us.
about the fateful day in front of Walgreens when you had the double box of papers?
That was a little bit later, but yeah, that was still in the early stage.
Yeah.
So thank you very much for
No
joining
problem.
us and providing us with your testimony.
All right. Have a good evening, gentlemen.
too.
Thank you.
Brian Kierney. Brian, I see you're there.
Okay, can you hear me?
Yes.
All right. Sorry about that. Good afternoon, honorable members of the committee. Thank you for hearing me today. I am a retired police captain out of New Haven, Connecticut from 1987 to 2011. That's when I retired. I'm testifying in support of SB 1500. In reading the proposed bill, I find that it is not designated or designed to remove total responsibility from respondents, nor excuse real criminal noncompliance. I view it as a tool to fix the failings of the current system and human nature on both sides of the process that is designed to see compliance obtained. I'm not deluding myself to believe that every current non-compliant respondent has zero blame. What I am doing is speaking for those who are doing the right thing to the best of their ability and trying to comply and pay their debts to society. These people do exist. Let's face it, homeless people are hard to reach, if at all. I'm not trying to create and administer manufactured excuses to avoid responsibility. What I am trying to do is point out the legitimate reasons exist that may prevent strict compliance with the laws as it's currently written and through no fault of the respondent. Rehabilitation starts with the feasibility a feasible opportunity to get one's lives together, and spirit of the law should contain a gateway to freedom instead of an implementation of unnecessary penalties of incarceration and further destruction of one's progress and reputation. Capricious and arbitrary application of the law should not exist. A grace period of compliance would go a long way towards the objective goal, where the outcome should be about guilt or innocence rather than a determination due to technical difficulty beyond one's control. Although I have a brother in the registry, I still feel that this way regardless. I feel this way regardless of who is affected. I've always felt that this as much as a responsibility of law enforcement to find evidence that someone didn't commit a crime as much as it is to find probable cause that they did. Because why cause someone to endure necessary hardships, setbacks for situations that are out of their control? If a letter arrives late through no fault of the respondent, currently the respondent is subject to the potential penalties of a felony conviction. For some people who have committed a crime of serious nature, current law makes them a felon when the original criminal act wasn't even one. And even though when a legitimate affirmative defense exists without adequate defense, and in some matters, one size does not fit all, and the premise of due process appears to be at risk. In the case of my brother, his compliance letter was allegedly received 1 day after it was due. Current law makes the charge applicable if the alleged noncompliance exists for 5 days. By the records submitted, he wasn't even in violation of the law, but yet a felony warrant was put out against his arrest. Over time, several compliance letters were submitted and received subsequent to the one that they said was late. How do you still charge somebody for now being in compliance after several layers of letters? Several letters were submitted, and the one that was not submitted or allegedly not as submitted a year and a half ago is the one now standing for you when the person is, yes.
The bell has rung.
Okay, I'm sorry, I didn't hear it.
Yeah, I'm just making sure you know, and
Got you.
we understand your testimony, and thank you for it, by the way. Are there comments or questions for Mr. Kierney? Comments or questions for Mr. Kierney? There are not. I want to thank you for taking your time and sticking around with us till after 5 o'clock.
You're very welcome. Thank you for hearing me.
Absolutely. Patricia Gibbs. I see you there, so.
Can you hear me?
I can hear you, and now I can see you. All right, let's go.
Well, I must say good evening to all of you. This has been a very interesting day. I've learned a lot listening to everyone. Again, my name is Patricia Gibbs, and it is indeed my pleasure to support this bill. Being that I have children in Connecticut, grandchildren, great grandchildren, nieces, and nephews. One of my nephews is presently in prison, and he has been there for, I believe, 10 or 11 years. So, again, it's my pleasure to support Bill 1327. I strongly believe that, and I'm sure many of you agree, that life changes, people change. It seems that the focus today is to believe that the passing of this sentence modification bill will allow those that are serving or have served their sentences to this point in their life to be given a chance to prove to family and society that being released by the reduction of the sentence bill will be the best for them as well as for family. So I thank you for your time. And there's one thing I just want to share. Looking up on my wall, I see a plaque that says, "Life is fragile, handle with care." So God bless all of you and thank you for this time.
Thank you, Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon. Is it Mrs. Gibbs?
Mm-hmm.
Yeah. Hi. How are you? So you mentioned
I'm
that
great. How are you?
Can you hear me?
Yes, I hear you now.
Great. You mentioned that your nephew has served 10 or 11 years.
Mhm.
Has he tried to get one of these sentence modifications?
No, I don't believe that he has. I believe that he's just now doing, and he has submitted his testimony. You all may be receiving that or have it already, but no, he hasn't applied before.
Okay, is there some, because my understanding is that he would, based upon you were telling us about his period of incarceration, so on and so forth, that he would currently be eligible under the law, and I'm just trying to figure out.
Members of the committee, seeing none. Mrs. Gibbs, thank you very much for sticking around and
You're
providing
welcome.
us with your test.
You're welcome.
All
Have a
right.
great evening.
All
Thank
right.
you.
So I know we have Mr. Young left. Is there anybody in the room who signed up and did not testify? What is your name? Jennifer? Okay, Jennifer, you may come up and testify. Mr. Young, prepare yourself. Turn the micro. Yeah, there you go.
Good evening. Thank you all for staying. My name is Jennifer Jasensky. I live in Middletown. I am a survivor of a date rape, and I'm here to testify in support of SB 1500. My loved one is on the registry. Joe was released back into the community in 2006 with lifetime registration. He's been nothing but good to me and my family. He was released in 2006. 10 months later, he had a very severe stroke, leaving him with a limp, the inability to speak more than 5 or 6 words. He's gone through tons of therapy for that. Little ability to read, very little ability to write. I'm in fear all the time for him and his late letter, or I wasn't nervous and now I'm very nervous. I'm nervous every day because I don't pay attention all the time to when his registration letter is going to come. We don't live together. He lives with his sister. We kind of both help with his care. He doesn't have an official caregiver. He dresses himself, he showers himself, he goes out to eat, rides a bicycle, but can't drive and all the other items I mentioned. So for him to return that letter, he lives in a household where the mail doesn't come to him. It has to be brought to him. It's not his home, so he doesn't engage in getting the mail. If it's not brought to him, which has happened a couple of times because his sister was away and whoever was getting the mail didn't think to bring him the mail, he does sign the letter, gives it back to her, will give it to me. Sometimes we'll deliver it to the post office himself. I know speaking with Representative Howard out in the hallway, he said, well, then he should have an official caregiver. Maybe, but how now does that happen? How does the state be notified that this is his official caregiver? And it would be the responsibility of the caregiver. So if I become that caregiver, am I now liable to be incarcerated for his letter not being returned? Because now it falls to my responsibility if somebody has made his conservator. So I do worry about him. OSJ has worked with a senior who was confined to a nursing home. He was cuffed and dragged out of the nursing home, put in a cell for the night, went into seizure, was taken to the hospital where he remained until morning. The worst part of this is that they had the wrong person. So people in nursing homes and group homes, even just hospitalized, don't necessarily get their own mail. They're not in control of when the mail goes back out. SB 1500 would extend the days on that and take away the felony conviction.
Thank you. Comment, question from members of the committee. Comment, question from members of the committee. If seeing none, thank you for staying here and being skipped and then staying anyway to provide us with your testimony is very important to us. Thank you. Okay, so we're gonna hear from Mr. Young, but before that, what is your name? So I can. And you were towards the front. I got you, number 5. All right, Clude Young. I know you were
Can you
there.
hear me?
Yep, there you are. We hear you.
You can hear me. Good afternoon.
I can hear
Good,
you. Is it possible
okay.
to turn on your camera?
I've been trying and I don't think it's working right now.
All right.
I guess we're gonna have to go this way. Are you still able to hear me?
I'm still able to hear you. You may testify.
Okay, thank you very much. Good afternoon, Judiciary, Senator Winfield and Representative Sastrom, Ranking Member Fishbein and Kissel, as well as Senator Flexer and Senator Gatkar Wilcox. Some of you, this will be the first time hearing from me testifying. This is my 21st year testifying before Judiciary about these concerns that still have not been addressed. Some of them have been spoken to today. Some of them were rebutted by some of your other candidates and testimony folks, particularly with Attorney John Doyle's comments. Most of my issues are directed at the state's attorney's office, but it involves the OPM and post, as well as judicial review regarding corrupt personnel within those offices and those issues not being addressed. We do see that this is a recurring issue, that a lot of times that you've had to reaffirm these wrongful convictions and award people compensatory and punitive damages for wrongful convictions. And my concerns are that we're not addressing where the source and where all these issues are stemming from, because there's no transparency and no accountability. As one of your other candidates in testimony verified, some of the attorneys make it a personal issue when you catch them doing things inappropriately, and that would be considered retaliatory. And there is no protection in our system as of right now. I personally have been a victim, have been disregarded by the Connecticut State's Attorney's Victims Office, Office of Victims Advocates, when the person has acknowledged committing a crime. I've also been continued to be prosecuted after that and been told the person was trying to actually have me murdered and continued to be prosecuted. The entity of the Connecticut State's Attorneys as far back as Chris Morano, Kevin Kane, including Mr. Colangelo, and I've actually made contact with Mr. Griffith's office, and no one has called me back in 20 years to address these issues. Not a one. I welcome any questions, and if any of these concerns are disputable, please have the opportunity to reach out. I spoke to Representative Fishbein last testimony, and I gave him an incorrect CHRO number. The correct number is 072-0418. There's been a new suit filed against all these respective state agencies. And when these issues are brought to light, hopefully you folks will take these issues seriously and get accountability within in that office. I would highly suggest you going through the process of merging the CHRO into the Connecticut Judicial so that they have the civil oversight if anything is being done inappropriately. That would be my suggestions, but I welcome any and all questions.
Thank you, Mr. Young. Comment, question for members of the committee? Comment or question for members of the committee? There are none. I just want to thank you for joining us again, as I know you've been in front of us before. Next, we have Prince Davis. So you can come up, and I believe I see Jess Zanino as well. So Prince Davis first.
Good evening, Representative Fishbein, ranking member, and also Senator Winfield, Representatives Howard and Fazzino. My name is Prince Davis. I've been a resident of Connecticut for 46 years. I'm currently a lifetime registrant on the registry, and I'm writing support of Census Bill 1500. I live with my wife, whom I've known for 30 years and married to for 18 of those years. I've lived at my current address for 25 years, and that's in Congressional District 116. We are retired and are members of a church in Milford, Connecticut, where I've served as deacon for 11 years. I'm a father to an adult daughter and a grandfather to one child. I believe the law should change from the Class D felony carrying a 1 to 5 year incarceration penalty to an infraction. I understand the responsibility is the registrants to comply to the requirement, but they're not always at fault. I mean, for the loss of a letter that depends upon receipt of mail, they're not always at fault. On the morning of March 27, 2014 at 7:35 a.m., I was awakened by a series of very loud, heavy knocks on the front door of my house. Startled, I jumped out of the bed. Before I could answer the door was kicked in, and I was facing 4 U.S. Marshals in tactical gear with guns drawn, yelling threats, quote, "Get down on the floor or you will be tased," unquote. I was ordered to lay down on the floor. There I was lying on the floor of the hallway in my underwear. I was humiliated in a very threatening way. I was arrested on a warrant issued for failure to return an address verification letter, state statute 54 through 252, a Class D felony. And I was taken to lockup at the West Haven Police Department. After a while, I was transported to Milford Superior Court to go before a judge. I went through a long, stressful, and expensive legal process because of this technical issue that ended with the violation being wiped from my record after 1 year. Following that time in court, I began to return my verification letters via return receipt after that arrest to ensure that I kept a record and a tracking number. So, in short, I urge that you pass SB 1500. The law as it is now written only hurts families like mine and are trying to follow the law, that are trying at their best and to be good citizens.
Thank you.
Thank you.
And just a question, did you have any issues subsequent to that time in 2014?
No.
No. What? We're going to go with Representative Howard first.
Thank you, sir. Thank you for sticking around. And, you know, your story and what happened to you is exactly what I just said to one of my colleagues a bit earlier. I think we need to look at this statute and make some changes. I don't know that this is the answer, and I appreciate that you're in favor of the bill, but would it make a significant difference in your life if we took that 90 days and changed it to something else like 6 months or a year?
It would make a difference, yes. Particularly for me and for those who are going through the same process, yes, it would make a difference. But if I may say, my concern is the severity of the penalty, Class D felony, for something that it is ultimately my responsibility to make sure that within 10 days that letter comes. But sometimes I don't get the letter until 5 days after. And then to add in the weekends, add in the holidays. And this is funny. So one of the months I received my letters is October. And I have had particular instances of October. That's when it was. And in fact, I didn't have enough time to bell ring, but could I just share this? That, however, after all of the money, $400 over 8 years, in October of 2022, I was issued a notice of violation for failure to return the verification letter for a letter that was confirmed as being delivered. I mean, I did the tracking on my return receipt, and it showed that the letter was delivered on time. But yet, they sent a verification letter in which I promptly returned. So there was, of course, a weekend that came. I received the letter after they sent the letter out on the 11th. I received it on the 15th, which ended up being on the Saturday. So therefore, I couldn't return it until Monday, the 17th. and which I promptly put it in. I mailed it on the 18th. They showed that they received a letter on the 22nd. So that was out of mine. I did and kept my part of the bargain, but still I was sent a verification letter, which I promptly returned. And that letter got there surprisingly in 2 days. So I don't know what to say, but if you guys please will consider this.
Thank you, Ms. Davis. So that was, and the other question I have for you, you can respond by email, right?
I can now, but I started this journey in 2002.
Understood. Do you use the email option now?
I have not used it because I wasn't aware of it until I started talking with, thank God for Standard of Justice, one
Okay.
Standard of Justice. So they informed me of that, but I'm still leery of it, I guess I can try that, but none of that had anything to do with.
Understood. And I'm not suggesting that it's your fault or anything like that.
No.
I'm trying to get an understanding of how we can best facilitate this process to achieve the intent of the legislation when it was initially passed without creating these, pitfalls where folks like you fall into them unintentionally, but in a framework that works. So my final question to you, because you said to my first question, one of your concerns is that it's a felony. Would you think it'd be reasonable to, if we were to change the felony to a misdemeanor for a first offense, and then people who are habitually doing it would be a felony? Would you think that's reasonable or no?
I would think, why not infraction? And then never return it back to felony, because what he's doing, it's kind of like a great friend of mine, great orator, Deion Sanders said, you're killing a gnat with a sledgehammer.
Well, it could be, but so would you agree with me then, if we change it to always an infraction, you could basically pay your way off the registry, right? Because let's just assume we kept the current law and it's every 90 days, and let's just assume I'm on the registry and I get it and I throw it away and it's $100 fine. I pay my $100. 3 months later, I get it, I throw it away, I get a fine, I pay my $100. Couldn't somebody with means then pay their way off the registry, but somebody who doesn't have means has to stay on it?
That sounds good, what you're saying, but the idea of it is that you're still holding them responsible, but they're still responsible. You're not taking responsibility of them not returning the letter when they're supposed to. But again, I don't personally, I would speak for me, I would not intentionally get a letter and throw it away.
Understood, but I guess, but we have to make public policy for 3.5 million people, right? Not just for you. Not that there's 3.5 million people on the registry, but that's many people live in the state, right? So what I'm driving at is, we hear a lot in testimony here, and there's bills in other committees relevant to, social inequities and financial inequities where people who have money can, quote unquote, get away with crime because they have the money. I hear that in this committee all the time.
Yeah, we know.
Right? So under your suggestion that it just stays an infraction, you don't think that could create an inequity where somebody with money can just keep paying their infraction and then never have to register?
Not to the degree of putting someone in jail. Now, they don't have a chance. They have to do time where they made gains, but then being reincarcerated, they lose all the gains that they have. So it's a small fraction, but again, it's not taking away responsibility. And I get what you're saying, that, yeah, it would be a disadvantage to someone who just doesn't have the means to pay. Absolutely, I see what you're saying.
So given that, would you support something that's a stepped approach? So infraction for a first offense, misdemeanor second offense, something like that?
I would have to think about that.
Okay. All right. Thank you, Mr. Chairman.
Thank you, Representative. Representative Fishbine.
Thank you, Mr. Chairman. Thank you, sir. You've been here a while, so I appreciate your listening to you. And Neon Dion has some of the best ties. I love his ties. When you said about not trusting the system, I can appreciate when Representative Howard asked you about doing the email thing, right? you're clicking the button, you're like, oh, they're really gonna get it, you know, is the same thing gonna happen to me? I don't know if you know, but lawyers have to every quarter file with the grievance committee any advertisements that we do. And I go through the same sort of situation. When I click that button, are they really getting it? I mean, so I can totally understand that. During when you were telling us your story, you said that, so first of all, did you get convicted of the failure to report?
No,
Okay. But you said something about that it got erased in a year. So am I to understand that maybe they entered a nollie and that was hanging over
that's
your
what
head?
it was. Yes.
Yeah, okay. So at the end of 13 months, it got dismissed by operation of law.
Yes.
So good thing. You know, but still you had to go to court and deal with all that stuff and
Yes. And the other thing is I'm thankful that I had the resources to retain a lawyer who worked through the process. And
yeah, no,
otherwise that would have been 1 to 5 years. And to mind you about my background, I do have 2 strikes, and I believe that Connecticut does carry some form of a strikes 3-year outlaw. So
not really.
no, not really, but it's only in, okay.
Yeah.
All right, I'll take it from the
It's
legislature.
very difficult to get convicted of anything in Connecticut, but I appreciate that. Thank you for coming here today, and thank you, Mr. Chairman.
And thank you guys for giving me this time.
Thank you, Representative. Any other questions or comments from members of the committee? Other questions or comments? If not, thank you, Mr. Davis, for joining us today. Thank you for waiting all this time.
Yep.
Have a great afternoon.
Thank
All
you
right.
as well.
Jess Zanino.
Hey, good evening, everyone. Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and members of the Judiciary Committee. My name is Jess Zanino. I'm a Policy Counsel of the American Civil Liberties Union of Connecticut. I'm testifying in support of Senate Bill 1502, an act concerning sentence reduction or relief for survivors of domestic violence, sexual assault, stalking, or human trafficking. The ACLU of Connecticut is an organization dedicated to ending mass incarceration, eliminating racial disparities in the criminal legal system, and reducing harms to justice-impacted people. We strongly believe that the criminal legal system must account for a person's lived experience with domestic violence. People who are incarcerated are much more likely than the general population to also be survivors of domestic violence, and many survivors become involved in the criminal legal system for actions directly related to their victimization. Survivors are also often more criminalized for fighting back and protecting themselves from domestic violence. At the same time, there are over 70 crimes in Connecticut that carry mandatory minimum sentences, many of which apply without regard to the circumstances surrounding the crime. As a result, the process overlooks or sometimes ignores entirely how traumatic experiences like domestic violence, sexual assault, stalking, or human trafficking can influence offenses. All too often, people who are incarcerated are left out of legislation aimed at helping survivors of sexual and gender-based violence. Senate Bill 1502 is so important because it is intended to provide sentencing relief to survivors of domestic violence, stalking, sexual assault, and human trafficking who are also incarcerated. The bill would allow people who are incarcerated because of actions that were related to their abuse, the ability to seek trauma-informed sentencing relief by way of sentencing modification, parole, or commutations hearings. Judges and the Board of Pardons and Paroles would be given discretion to divert mandatory minimums during sentencing or resentencing when a person can show that their experience contributes to the offense. Other states have already successfully implemented DVSJA legislation, like New York, Illinois, and Oklahoma. And there's also similar efforts across the country, including in Massachusetts, Georgia, Louisiana, Oregon, and Minnesota. Senate Bill 1502 was a long-needed bill that would finally provide survivors with a trauma-informed approach to explain how the abuse that they survived contributed to their incarceration and with opportunity for potential relief. As such, the ACLU of Connecticut supports Senate Bill 1502 and urges this committee to do the same.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you for joining us again.
Thanks. Happy St. Patrick's Day.
All right. I believe I'm at the end of my list, but let me just ask, is there anyone who is signed up who has not had the opportunity to testify? Is there anyone who is signed up who has not had the opportunity to testify? Seeing none, we will come back and have another wonderful day of testimony on Wednesday. We like it here. All right, everyone, have a good afternoon.